What's good, chat? What's good, chat? We night. Who's in the chat? Let's get to it. Oh, those are blueprints. What the Dutch Muslims.
in a way, I think it is generational too. Like men our age, they want to be providers. They want their wives to stay at home. Now, when I talk to my 20-year-old daughter about her dating life, the guy that she dates or that she's talked to in the past, they want a woman that's going to bring 50% to the table. They want to give them. Because things are so expensive now, they want to make them with a woman. And I think it's just a little bit of a generation thing. I would say, like, tend to the kids, make sure he is taken care of 100% in the bedroom and outside the bedroom. Right, absolutely. Same kind of tradition. They want to trust. Right? Someone needs to be a leader, and someone needs to be the submissive one, right? Well, someone who is going to care for the leader in the household, whereby she is going to do things that he's not able to do, have the time because he has a career, he's at work, so tend to him, like, do his laundry, make sure he has breakfast, lunch, and dinner made. One thing I know people kind of mistake like submission to be like be her have, but I would have to disagree with that. I would say submission means somebody who is going to take the back seat or someone who's going to sit in the passenger seat and let the man take the driver's seat and make the decisions in the household and make sure the budget is intact and you guys are living within your means. Correct. I don't think that means that you have to be perfect. You still have a voice as a submissive partner. It doesn't mean that you're going to be the weak one and accept all those wrong demands. I mean, you can agree with them. You can still compromise or still work comfort. So you're telling me that being a submissive have a relationship is somebody that is just going to outlive 100% of the time? Family meetings that take a child a 30-minute away, a 30-minute away from home school, right? And then the mom needs to be the one to travel to do all that. But what if there's a school that's like 5 minutes away that's just good? Isn't there more to I would say as long as it's wrong. Yeah. Really. And that's why you have to be very careful on who you choose as a partner, right? I think we're it's like your husband should also submit to you. And I'm not saying that it's not I don't think either we traditional non-Christian or what's a traditional Christian and right? Wives submit to your husband, guys. The church has submitted to God and husbands submit to your wives as Christ. Yes. Just the church submits to Christ. Thank you, Christ, but you're just taking the husband should serve for me. You're just saying dimensions and matter. That's why there are instances where it is getting certain like if you don't want to see it on the movie, but it is like by man being like I'm willing to put my attempt to the side until you stand like I'm willing to and
What's good, chat? What's good, chat? We up. He ain't giving up? Oh, he disrespectful. I think that's where our boss was stopping at yesterday. We going to fucking watching. I don't know what time trial starts today. Oh, Warzone. That podcast going.
judge me.
Did you hear that?
I know it was somebody else. Oh shit. I don't know if I'm hungry or if I'm just my stomach just hurt.
Search results become more tailored, and job need will become more personalized. How? Well, what I say you start to think about job markets. If your preferences or qualifications align with the job, if they don't, you'll say straight to it. And if information is missing, you'll say question mark. The same thing with beginning and think in a private minimum base pay preference too. So, for you,
I'm really scared to be here alone. I'll bring this big shit out. This big shit is kicking. Marches is so annoying on YouTube. I'm also. Oh, 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 I'm being shot. If it pulls, I'll get those for fun. See through their eyes, intently. The person that fired first shot. There's something in there. I could tell. There's something in there. There's nothing that points to the very top to get focused. Just like all right.
Hope I don't find
Did you hear that? Did you hear that?
shot and left a knife spanner, bro. Shut up, Rico. Nah, we already got that, bro. We look a little pixelated. Oh shit. Where the fuck did he go? Running and gunning. Who's not even trying to start this over now? It's the bathroom fast chat. I hope nothing magic. Yes, it is. Yes, it is. Spinning through that block before, come on.
A game of hide and seek.
I'm going to chop you. See me, you hesitate with that gun. I know you ain't going. Music stops over look. That's loud. They might hit the wall up, bro. I was smacking the wall with the bullets, you hear me? Is there anything up here for me? Oh, look, there's a little chest. It's a little chest there. A little crate, eh? Alright, what y'all saying now, man? I think we got all them black. Should I let him live? Can't let you live, blood. I'm sorry. I keep hitting G instead of F, man. Look at this nigga standing on top of a block, bro. Baloncesto, Maracana. How did this dude come back? Oh, I forgot they come back. Alright, where we going on? Respectively. Respectfully. Right to the next spot back. I'm just making my way downtown, walking by. My bad, he ain't like my song. People have been destroyed by the Warzone by now. What are you looking at? Are you serious? Right back inside that fence? That's bollocks, bro. Bollocks, bro.
Did you hear that?
I didn't go on the building last time, did I? On top of this area, generated and jump one there into the roof. definitely not what I need to do. Helicopter records only 500 kilograms were salvaged and Frank still slacking on his parents will raise him well. Randy mentioned now I thought they were stated out by a woman who could fly. She was like a superhero who knocked it out to the sky. Quite the funny Rebecca. Everybody knows what music was originated. Weapons. We'll be running. We'll go to this telephone and then go back to Greenwood. Okay. And after that, we're making our way to yeah. Yeah, we're trying to get to all these reds. We're trying to get all of them. We trying to do all that. I got a trial that we can watch right now, to be honest. It's been on for a minute. Oh, that shit don't start too. Let's start something else then. Because to be honest, I like small court. And give y'all some court.
With him, correct?
Correct.
All right. And
Just so we can
it
get to
wasn't
our
any of
usual.
these
You know
men
how that go.
here, correct? Or if you recall. Do you recall who it was or no?
I don't recall.
All right. If you saw those security guards again, would you recognize them?
I won't recall.
Probably not. Okay. You remember seeing a bald-headed man up there? Do you remember that?
I don't recall.
May I approach on?
He ain't gonna recall nothing. I'm gonna let y'all know that right now. Little nigga straight in the trenches.
You know what? Yeah. Just put it up there so you can see what we're talking about. Thank you. I guess we're going to put it up on the screen too.
Which one?
Right, this one.
16.
Yes. You see that up there? The bald man?
Yes,
You don't see him today, correct?
correct.
All right. You weren't there at any point where there was other security guards involved, correct?
Correct.
At the end of it, you said we thugging, right? When you recorded the video?
Correct.
We over here at Northland, we thugging,
Correct.
right? What do you mean by that?
I'm just hanging.
What does that mean, sir?
Hanging.
Yeah. What does that mean?
It means we just around, messing around. You know?
And so that's the type of thing that goes on in Northland Mall, right?
Right.
People hang out, they might mess around, right?
Yeah,
And-
yes or no, please?
Yes.
And security might get involved with that, correct?
Yes.
This wasn't the first time you've seen security having to detain somebody, right?
Yeah.
At Northland.
Yes.
Here? All right. Thank you. Nothing else. Morning,
I
Mr.
don't want to
Nelson.
see no more Judge Lanville work.
Mr. Nelson, what time did you arrive at Northland that day?
Had to be about like, I'll say around the noon sometime.
Was
four,
this-
four, something like that, 4 or 5, sometime.
Okay, that's a big
Yeah,
difference.
a little bit, like in the evening, like.
Okay, first you said noon.
Yeah, around the evening. It's gotta be like even around like 4 or 5, something up in there.
Okay, and I know it was a long time ago. You don't
Yeah, it's a
remember.
while back.
You don't remember exactly when you arrived there, correct? Was it the middle of the week or was it the weekend?
I remember I had just
Oh, yeah, we gonna go
left
right
class,
there.
so it had to be around like 4 or 5.
Oh,
Okay,
yeah.
we moved on though. Is it in the middle of the week, weekend?
I'm not sure.
And how would you describe mall traffic? Were there a lot of people there, or was
No.
it pretty sparse?
No, it was pretty like,
It was pretty what?
it was pretty mid. It wasn't a lot of people.
Okay, and so when you come across this situation, were there, other than the security guards, were there a lot of people looking at this event, if you know,
No.
surrounding the event?
No.
And you started recording and you made some comments, correct?
Correct.
So you had access to your phone, right?
Correct.
And this situation didn't heighten your alertness enough for you to call 911 or the police. Would you agree with that?
No.
Did you call anybody?
No.
You basically just did a video and you moved on, correct?
Correct.
So, you said you heard the individual say something? Did you hear
said, "I
anybody
can't
say?
breathe." He said, "I can't breathe."
Did you hear the people with the blue uniforms say anything?
No.
You didn't hear them say, "Stop moving, stop resisting."
I don't remember.
You didn't hear the guy in the store
Just heard
yelling.
them screaming. They was just holding him down, and that's when we walked on.
You didn't hear did you see the owner of the store, if you know who the owner is?
I don't recall.
Okay, so you said you made this observation for several minutes and you moved on, correct?
Correct.
And you didn't alert anybody else in the mall about this situation, any storekeeper,
No.
any of one of your friends, if you saw them,
No.
any other security agent or officer?
No, sir.
And once again, you weren't alarmed enough that you thought this situation was going to escalate into something far worse than
Correct.
what you saw, right?
Correct.
So as you went around the mall, you said you came back and everything had pretty much ended at that time and point, correct?
Correct.
So what you saw was 3 security officers on another individual, right?
See, I need
When
to
got back,
address
it was
that.
3. It was 2 and I
It was
left.
3. And what kind of clothing did the individual who was being subdued have on, if you know?
I don't recall.
The 3 individuals, you said it was 3 or 4, I'm sorry.
3.
Now, when I started,
Did you ever see any of
they
those
just let me
individuals
use the
strike
shit.
that person?
No.
Okay,
Did
it's not
you
like
ever
this.
see those individuals kick that person?
No.
And when you came back, you said the person that you saw on the ground was gone, correct?
Yeah, he deceased.
But you didn't know that at that point, did
I didn't know.
you? You were contacted by someone who told you that?
Correct.
Who contacted you?
One of his family members.
And was that the day of, week later, year later?
It was about a week later.
And with that information, did you take your video to the police, Southfield Police Department,
No.
Oakland County Prosecutor?
No.
No.
Now, while you're making your commentating the event, you said this is some bullshit, right?
Correct.
Why did you say that?
Because he said he couldn't breathe. You know what I'm saying?
And once again, after you heard that, you walked away, correct?
Correct.
Didn't call anybody?
No.
Okay. Thank you, sir. Nothing further.
Good morning, Mr. Nelson. How many videos did you make?
One.
Just one video? The first time or the second time you were there?
Both times I was there. Both times I was there.
So you recorded 2 videos.
No, one video.
Okay, how do you record one video if you were there 2 times?
No, I recorded one video and we came back around.
Oh, so it was just continuous.
Right.
Okay, all right. Now, earlier you said you watched for 3 minutes, 3 or 4 minutes. Okay, was that the first time or the second time? Or the second time you got it?
Right.
The first time?
Right.
Okay, how long did you watch the second time?
For about like 3 to 4 minutes.
Okay, so about 8 minutes in all. The video that we just saw, that was when you came back or when you first got there?
That's when I came back.
Okay, but the first time, there were 2 officers there.
Right.
But in this video, it showed 3 officers. So,
Right.
all right. In this video, it did not show any knees to the back. So when you're saying, you said that someone had a knee to the back, was that the first time that you got there
Correct.
with the 2 officers?
Correct.
What was happening at that time? Was there a struggle at that time or a fight?
Correct.
There was a fight?
Correct.
Okay, so the 2 officers were fighting the individual that was there.
They was trying to detain him, to have him on the ground, and he was, I can't breathe. I can't breathe.
And what was he doing with his body?
Just laying on the ground on his stomach.
He was not struggling or fighting back?
He was struggling to breathe.
Struggling to breathe.
Right.
When you came back, you had stated a term. Did you mean to say that he was passed out at that time, or what were you
The
saying?
first time he wasn't passed out. When
Okay.
we came back, he was passed out. And the first time he said he couldn't breathe. We walked off, came back. He was gone.
Okay. Why do you believe that he was passed out at that time?
Because they was calling the EMS and he wasn't moving
How was he positioned?
on his stomach, but the
37
security still had him
side.
detained on the ground.
Did you see if there were handcuffs?
Yeah, he had on handcuffs.
He had on handcuffs. How long were you
Yeah.
there when the handcuffs went on?
No, we came back around, he had the cuffs on him on the ground, and they was calling it, he wasn't breathing. And that's when they called the EMS up there. EMS came there.
Okay. All right. No further questions.
Very brief redirect, Your Honor. Mr. Nelson, how many times did you hear the man say he could not breathe, if you recall?
At least 2 times.
And when you walked off the first time, did you expect that incident to end in a death?
No.
Nothing further.
May I, Your Honor? Thank you. Sir, you said initially you went there was 2 security guards,
Right.
right? And you said you started to record.
I'm going to object. This exceeds the scope of redirect.
I can go into the scope of things that were raised by the other counsel, not just the prosecutor.
Redirect. You are limited to the scope of redirect.
Process based upon the redirect now.
All right. Did you record the entire time that you were there?
Correct.
Right. So the video that we just played, it was only about 30 seconds.
Your Honor,
Are you saying there's more to it?
That's the
I'm
video I
going
had.
to object, Your Honor. This is exceeding the scope of redirect.
What was established was he said he recorded the entire time and then when he came back around.
I didn't
Yes.
ask that on redirect.
Did not ask that.
It was asked by another attorney though, and so it impacts my client, Judge. Just because it wasn't asked by the prosecutor.
But that was a direct cross. That was cross-examination. It wasn't recross, so no,
All right.
you have to.
Understood, Your Honor.
He was trying to fight his case. They said no.
Yeah, redirect.
Take nothing else.
Mm.
Thank you. Mr. Nelson?
I have a question, Judge.
Oh, well, based upon a redirect?
Yes, sir.
Okay.
I think so. So the exhibit that we saw is the entire videotaping that you did of this incident, correct?
Exactly. It's
Yeah.
one video.
I haven't finished my question. When I asked you when you got back to the scene, you said they were gone, and now you're saying that they were there.
Your Honor,
Which one is it?
I have to object. This exceeds the scope of redirect.
It does. I'm sorry. It does exceed the scope of redirect.
Okay. Nothing further, thank you.
Okay, Madam Prosecutor asked you if he said he could not breathe. Did you, in the recording that was there, did you hear it, "I can't breathe" in that recording that was presented?
I didn't hear it on that. When I came back, when I first came in, we came in the mall. He was like, "Help!" And we like, he stole something or something, so we laughed about it. And then we walked around. We came back. He was like, "Can't breathe," and he passed out. He was gone.
But in the video that was just shown, you did not, because we know that you had voice on the recording because you stated what you stated earlier, but we did not hear "I can't breathe" in the video that you just watched, correct?
Correct.
Okay, thank you.
We've been on here for almost 2 hours already.
Judge, may we ask that the witness not be excused because we may want to recall him as our own witness, then, since we have questions that possibly exceeded redirect.
That's fine.
All right,
Have a
thank
seat
you.
outside, Mr. Nelson, please. Call your next witness.
Your Honor, people call Hoy Monk.
Yeah.
Sir, will you please come forward? Watch your step, please, sir.
Please turn toward me and raise your right hand. Do you solemnly swear or affirm, under the penalty of perjury, that the testimony you're about to give before this court is the whole truth and nothing but the truth?
Yes.
You may be seated, sir.
Thank you.
And I'm going to ask that you keep your voice up because we are recording.
Gotcha.
Thank you. You may proceed.
Good morning.
Happy Tuesday.
Happy Tuesday. If you could please state and spell your name for the record.
Hoy Monk II, H-O-Y, first name, last name Monk, M-O-N-K.
I'm going to ask you to close
Wait,
that
Monk?
because I might show you some exhibits and I don't
Okay.
want to trip. So,
Gotcha.
thank you. All right. Mr. Monk, are you employed?
Yes.
And what is your occupation?
I am a youth and young adult pastor.
And Mr. Monk, I'm going to direct your attention to January 28, 2014. Do you recall that date?
Yes.
And Mr. Monk, were you employed on that date?
Yes.
And where were you working at that time?
Foot Locker Incorporated,
Okay. And what was your position at Foot Locker?
stock manager.
And where were you working at Foot Locker?
In the mall, Northland Mall.
Okay. In Northland Mall, is that in the city of Southfield?
Yes.
Oakland County?
Yes.
State of Michigan?
Yes.
And on January 28, 2014, do you remember the hours you were working?
I believe it was 10 to 5.
Now, Mr. Monk, on that date, did something happen at Northland Mall that brings you to testify here this morning?
Yes.
And where were you exactly in the mall when it happened?
I was sitting on a bench outside of Macy's.
Okay. And Mr. Monk, are you familiar with the store called LA Diamonds?
Yes.
And is that store also in the Northland Mall?
Yes.
And where is that store's location in relationship to where you were sitting?
About 15 to 20 feet away.
And Mr. Monk, when you were sitting on this bench outside of Macy's, was there someone sitting with you?
Yes.
And who was sitting with you?
My wife.
And Mr. Monk, when you were sitting on that bench, what is the first thing that you saw?
I heard a commotion.
You heard a commotion?
Correct.
And can you describe for the jury what you heard?
I heard a commotion going on to my right, which is where LA Diamonds was at, between an individual, and 2 security guards.
And when you hear this commotion, do you look in that direction?
Yes.
And you just said that you saw a person and 2 security guards?
Yes.
Let's start with this person. Do you remember what he looks like?
He was an African American male.
Okay. And did you know this person?
No.
Had you seen him before in the mall?
No.
Okay. And you said you saw 2 security guards?
Yes.
Okay. And how long had you worked at Northland Mall?
2003.
So from 2003 to 2014?
Yeah. Well, I closed the mall. When it closed, that was my last day there.
Okay. Okay. And so had you seen these 2 security guards that you saw interacting with that male on January 28th before?
Yes.
Did you did you talk to them, or you would just see them in passing?
I've had conversations before.
And the 2 security guards, do you see any one of those in the courtroom this morning?
Yes, there's one.
Okay. And if you could just point to him and just describe something that he's wearing.
Gentleman with the glasses sitting on the far right.
Your Honor, let the record reflect that the witness has identified defendant John Sieberlin. Now, when you see these, the defendant, now let me back up. This other security guard, do you remember what he looked like?
Yes.
Okay, and what did he look like?
He was a Caucasian male. He had a bald head.
Now, when you see the security guard with the bald head and the defendant interacting with this black male, what do you see next?
Could you repeat the question?
Okay. What happens next?
I see them asking the individual to leave the mall.
And the black male, was he doing anything? Did you see him doing anything?
It looks like he was pacing back and forth.
Did he have anything, he was pacing, notice anything about his hands?
If I remember correctly, his hands were in his pocket.
And do you recall which security guard asked this male to leave the mall?
Caucasian male with the bald head.
Okay. And so then what happens next?
They asked him to leave multiple times. He does not leave.
Okay. What's the next thing that happens?
The same officer or security guard who approaches with the bald head, the Caucasian male, he pulls out his pepper spray.
And what does he do with the pepper spray?
He instructs the individual not to approach him.
And has the male approached the security guard with the mace?
To my I don't really recall that, to be honest.
Okay. Do you recall how far apart in feet the security guard with the mace was from the male?
I would say about 5 feet.
Okay. And what is defendant Sieberling doing?
Sieberling
The other security guy with the glasses. What is he doing?
Oh, gotcha. He is assisting. He's standing a little bit further in the distance.
Okay. What happens next?
The individual takes a step towards the officer. He pepper sprays him. Well, security guard, excuse me.
Now, when the individual takes a step toward the security guard with the mace, does he make any physical contact?
No.
Okay. Does he make any physical contact with the security guard with the glasses?
No.
Okay. What happens after the pepper spray?
Both security guards attempt to grab the individual.
Okay. And are they successful in grabbing him?
Yes.
Okay. And if you can remember, do you know where they grabbed the individual? What part of his body?
Around the top of his back.
And is it both the defendant, or the security guard with the glasses, and the bald-headed security guard?
Yes, if I remember correctly.
Okay. And so they grab the male, you said, around the top of his back?
Yes.
And what happens next?
That's when the individual is trying to get them off of him.
Now, as the individual is trying to get the security guards off of him, does he throw any punches?
No.
Do you see any weapons?
No.
Do you see him kick the 2 security guards?
I do not.
Okay. So at this point, he's just trying to get away?
Objection leading.
Okay. Let me rephrase. What happens after that?
After that, They try to, he's overpowering them. They're trying to grab him, but he's getting them off of him.
Now, when you use the word overpowering, can you tell the jury what do you mean by that?
Overpowering them means that the two security guards are not successfully able to control the individual when I say overpowering.
Okay. Is he pulling away? Mackenzie, the individual, is he pulling away from the two security guards?
I can't recall that.
So, baby girl.
Okay. All right. So, what happens after the two, so at this point, the two security guards, they grab him?
Yes.
And what happens next? What do you see next?
It's like wrestling going on.
Do they eventually end up on the ground?
Yes.
Okay. And what happens when the two security guards and the individual end up on the ground?
When they end up on the ground, that's where they're still wrestling. There's still a tussle going on, and then a third security guard comes up to assist the other two security guards.
Okay. And the third security guard, do you see that individual in the courtroom today?
I don't remember the order that they arrived.
Okay. But my question is, do you see the third security guard? Do you see the other person that showed up to assist that day?
Yes.
Okay. And if you can identify him for the jury, who else you saw?
The security guards 3 through 5.
Just who else did you see next?
That's why I don't remember who I saw exactly, who was the order of it. I know the first two, I just don't know 3, 4, and 5.
Okay, all right. I don't need sequentially, but let me just back up. So they're on the ground, and you say another security guard shows up.
Yes.
Okay, all right. And do you remember what that security guard looked like?
I know what he looks like. I just don't know which order.
Okay,
like
I don't need you to know the order. I just need
Okay.
to describe me what he looked like.
They trying to get them security guards up out of there.
Okay.
No.
All right. That's all. I just want you to testify to what you remember.
Yep.
Okay. So you said eventually another security guard shows up.
Yes.
Okay. And what happens after this third security guard shows up?
He assists the other two security guards in grabbing at the individual.
Okay. And grab, when you say grab, describe for the jury, what do you mean by that?
They're grabbing at him.
Okay.
And at the same time, he's twisting and turning.
All right. And this individual, is he kicking as he twisting and turning?
No.
Is he punching as he twisting and turning?
No.
At any time, did you see this individual with any weapons?
No.
Okay. And you say that he's twisting and turning. If you can remember, because you said now there's 3 security guards, where they are positioned on his body.
They are positioned in his upper torso and his upper back. So as he's twisting, they're still on top, like at the top, this area. So if he twists over on his back, then this area.
So let me just clarify. So at this point, there's 3 security guards, right?
Yes.
Okay, are all 3 security guards on his back and his torso, or just one?
If I remember correctly, there was 2.
Yes.
That's the question. When you say on his back, what do you mean? I mean, were they just using their hands on his back, or were they physically, their body was on his back?
Got you. I would say more hands on his back.
Okay.
And you said there were 2 security guards that were using their hands on his back?
Yes.
Do you remember what those 2 security guards looked like?
No.
Do any more security guards show up?
Yes.
Okay. And do you see any of, outside of the 1 security guard you've already identified, do you see any of those individuals that were there on January 20th, 2014 in the courtroom today?
Yes.
Okay. And can you point to which individuals that you recall seeing on January 28th?
Gentleman far left and gentleman in the center, sitting right over there.
Okay, the gentleman far left, can you describe something that he's wearing?
He has glasses on, African American male.
You're going to let the record reflect that the witness has
that man,
identified
African American.
Mr. Aaron Murray.
Record was so Rico.
And who else did you see?
Gentleman, Caucasian male, sitting in the center with the blue shirt on.
Okay, you're going to let the record reflect that the witness has identified Gavin King.
Right, so I'm telling everybody. But he a civilian.
So at this point in time, Mr. Monk, how many security guards are holding Mr. Cochran down, or the individual down?
There's 5.
Okay. And are they on top of him?
Yes.
Okay. And how are they on top of him?
One of the individuals that I remember I don't see in the courtroom, he was around Mr. Cochran's this area. Mr. Cochran's face down. His arm is like wrapped under this area right here. And then the gentleman sitting far right with the glasses, Caucasian male, he was on the back of Mr. Cochran's legs, holding around his ankle area.
The individual that you identified with the glasses, did you see where he was on, and I'm using the name Mackenzie Cochran, at some point in time, did you learn that the individual on the ground, that his name was Mackenzie Cochran?
Yes.
Okay, all right, just so we can clarify for the record. The individual you identified with the glasses and the sweater, did you see where he was positioned on Mackenzie?
You said with the sweater?
Yes, with the glasses and the sweater.
Can't remember.
Okay, that's fine. And the individual in the middle with the red hair, did you see where he was on Mr. Cochran?
What the fuck is going on in my audio?
But these two, they were on top of him.
Yes.
Okay.
Judge, that's mischaracterizing his testimony.
No, I believe he testified that they were on top.
No, he said he couldn't remember where they were.
No, he didn't say he couldn't remember exactly where they were in terms of position on his body, but he did testify that they were on top of him.
She's leading him and she's mischaracterizing.
Excuse me.
Sorry.
I believe he said he couldn't remember where those two defendants were located. Is that correct, sir?
Correct. Not positionally wise, but all 5 were on top of Mr. Cochran.
Okay, once again, when you say on top, were their bodies on top of him or their hands?
Yes. There was one who had his arm wrapped around this area. There was one who was sitting on the back of his legs holding his ankle area. Then there were the other 3 with hands on the top of this area back in the middle area.
Okay, their hands
Hands.
right here.
Yep.
Okay. But nobody's full body was on top of these two.
The only one who would have had, the only 2 I would say, is the one sitting on the back of his legs and then holding his bottom of his legs, and then the other one had his body weight on top of him, the one who had him wrapped around. Yep.
And are any of these defendants the one that, if you remember, that had was doing the, holding the hand wraparound?
Don't see that individual in the courtroom.
Okay. You have to see.
While Mackenzie is on the ground, is he saying anything?
Yes.
Okay. And what is he saying?
I can't breathe.
And is how many times do you hear him say that?
About 3 times.
Okay. And as he's saying it 3 times, do any of the security guards, do they get off of him?
No.
Do any of the security guards, do they respond to Mackenzie's statement that he cannot breathe?
Yes.
Okay. Do you remember which one?
The same one who had his arms around.
Can you tell the jury, if you remember, how long the security guards had their hands on Mackenzie Cochran as he was down on the ground?
I would say about 5 to 7 minutes.
And so as the security guards have Mackenzie down on the ground, what do you see next?
The one security guard who I keep describing with his arm around, he is asking Mr. Cochran to stop resisting.
And let me back up. Is Mackenzie, is he face up or is he face down?
He's face down.
Okay. Is he moving his legs or moving his arms, Mackenzie?
Yes.
Is he throwing any punches with his arms?
No.
Okay. What do you see happen next?
I see the same security guard who was saying stop resisting. He has one of Mr. Cochran's arms behind his back.
At any point, are the security guards attempting to handcuff Mackenzie?
Yes.
Okay. And when they handcuff him, are they handcuffing him in front of his body or in back of his body?
In back of his body.
Okay. Besides you and your wife, was there anyone else, or any other family members that were there that day watching this happen?
Yes, my mom.
Okay. And did your mom, did she also work in the mall?
Yes.
Okay. And besides you and your wife and your mother, were there other people that were starting to stop and watch to see what was going on?
Yes.
Okay. Did anybody express any type of concern or anything like that?
Yes.
Okay.
Hearsay.
I did not ask what they said.
She asked, what did they express?
I didn't say it.
Thank you.
Did you see anyone try to intervene?
Yes.
Okay. All right. Now, are the security guards, are they able to get Mackenzie handcuffed?
Yes, eventually.
Okay. And what happens after Mackenzie is handcuffed?
They start getting up off of him one by one.
And does he get up off the floor?
No.
Okay. Is he still handcuffed on the floor?
Yes.
Okay. And how is he laying on the floor?
Yes.
And
face
how
down.
is he? Go ahead. I'm
face
sorry.
down.
All right. I talked over you. Okay. As he's laying on the floor, could you tell whether or not his eyes were open or closed?
Could not tell.
Okay. Was he moving?
No.
Talking?
No.
Okay. After the security guards stand up, what do you see happen next?
One of the security guards goes, and I only know this because I heard them conversating. One of them goes to get Southfield police who had went through the wrong door.
Okay. And where's Mackenzie Cochran at this time?
At this time, they have arrested Mackenzie Cochran against a pillar of L.A. Diamond.
They being home?
The security guards.
Okay. And when Mackenzie is arrested against the pillar, is he still handcuffed?
Yes.
Okay. Is Mackenzie, is his eyes open or closed against that pillar?
Now I can see his face and his eyes are closed.
Okay. Is he moving?
No.
All right. Did you see any of the security guards try to administer any type of aid or assistance?
I saw one of the security guards attempt to give Mr. Cochran some water in a styrofoam cup.
Okay. And what happens when you see that?
They put the cup to his mouth, but the water just dribbles back down.
Outside of the water, did you see any security guards perform CPR?
Not to my recollection.
Okay. At some point, did Southfield Police Department, did they come to that location?
Yes.
Okay. Did they, the Southfield Police Department, did they interact with Mackenzie?
I do not believe so.
Okay. After Southfield Police Department, did EMS arrive?
Yes.
Okay. And were you still sitting on the bench with your wife and your mother when EMS got there?
Yes.
Okay. And what do you see EMS doing?
I see them try to administer CPR.
Okay. And does Mackenzie become responsive?
No.
Okay. What happens next?
After they try to administer CPR, they quickly try to they get Mr. Cochran on the gurney.
Now, at any time, from the very beginning as to when this first started until the time when Mackenzie is on the gurney, did you see Mackenzie with any weapons?
No.
Okay. Now, Mr. Monk, before your testimony here this morning, did you watch 3 videos of this incident?
Yes.
Okay. And did you see yourself in some of those videos?
Yes.
And if you remember, what were you wearing on January 28, 2014?
I believe I had red pants on and a darker color shirt.
And the first video, and I'm going to refer to as People's Proposed Exhibit number 1, that being the Northland video, did you see yourself in that video?
Yes.
And was that video a fair and accurate recording of what you saw happen on January 28, 2014?
Yes.
And I'm also going to show you some photographs, if I may approach. Can I? Yeah, may I approach the witness? And this is people's proposed exhibits. This will be 2 through 13. I'm going to hand these to you, Mr. Monk, and if you could just look through them. And for the record, what have I given you?
Still shots from the camera footage.
And do those still shots, do those correspond to the camera footage of the Northland video, the first video?
Yes, based on the quality.
Your Honor, at this time, I will move to admit this will be First People's Proposed Exhibit number 1, that being the Northland video, as well as People's Proposed Exhibits number 2 through 13, that being the stills that correspond with the Northland video.
Sir, we don't object that he's not the keeper of records for these videos.
Well, Your Honor, I do believe that under 901B1, proper foundation is laid by the testimony of a witness with firsthand knowledge. Mr. Monk has testified that he was at the Northland Mall on January 28th. He saw what happened. He testified that he has watched the video prior to his testimony. He testified that he identified himself in the video, and the video he saw was accurate. I do not believe that for foundation and authenticity, as well as identification, that there's no requirement that the actual video taker be present. And so with that, Your Honor, I would move for admission under MRE 901B1.
Judge, what 901B1 says is testimony of witness with knowledge, testimony that an item is what it is claimed to be. He has nothing to do with Northland Security to say where that video came from. All he knows is he was shown this video by a prosecutor. Where it came from, he doesn't know. So they haven't laid the foundation that he knows where that recording came from, where these still shots came from.
Your Honor, that's not what his 901 says, Your Honor. What it says is that it has to be an accurate recording or an accurate replication that it is what the item purports it to be. He's indicated that he has looked at it. He indicated that it is accurate as to what it purports to be, accurate as to what he saw, Your Honor, and that is the foundation requirement under 901B1. Thank you. Your Honor, permission to publish. This will be People's Exhibit number 1.
Yes, ma'am.
And before we get started, for the record, Mr. Monk, where is this?
Where is this?
Yes.
This is
Northland Mall?
Yeah, this is Northland Mall.
Okay. And we have a pointer for you somewhere, right here. Okay. Well, Ms. Logan's gonna, do you see yourself in this video?
Yes.
Okay. I know it's poor quality. Sorry. Not our fault. And how can you identify yourself in this video?
My red pants.
Okay. And there is a person that is sitting next to you. Who is that person?
Looks like my wife.
Better be. Is that her? Is that? Okay. Okay. And for the record, I've asked Ms. Logan to pause it. You mentioned in your testimony that there was a store called LA Diamonds. Do you see that in this footage?
Yes.
Okay. And is that the store that you initially saw Mackenzie as well as the security guards?
Yes.
Okay. And are you sitting on this bench the whole entire time that this incident is happening?
Yes.
Okay. Mr. Monk, for the record, we have paused it. The security guard with the bald head, do you see that security guard in this security footage?
Yes.
Okay, well, was that the first security guard that you saw approach?
Yes.
Okay. And you can barely see a little bit, but do you see an individual that's standing at the counter?
Yes.
Okay. And is that the individual that they approached?
Yes.
Okay. Now, Mr. Monk, I'm going to ask you a question. Earlier in your testimony, you said that Mackenzie, that one of the security guards told Mackenzie Cochran to stop resisting.
Yes.
Okay. And you also testified that he was strike that. We'll keep playing.
Oh.
Now, Mr. Monk, do you see, again, it's very grainy. Do you recognize this person? Probably don't sit back.
Right there?
Yes.
Yeah.
And who's that?
That's my mom. It looks like her hair. Definitely my mom. You tell the way she have her hands behind her back.
Shows everybody I know about she wasn't even. As long as she don't dig up that nose with that same finger, she good, Spot. Respectfully. She hit that nostril with that hand. I'm in this thing like, whoa. What? What? What were you just doing that whole time? But you've been doing there for about 15 minutes. Let's figure this out, Sincere. Hold on. Hold on, Sincere. Shouts out to everybody that's tapped in on the Rumble, the YouTube, and the Twitch. Shout out to the fucking gang. You know how we give it up in this motherfucker. You hear them? Respectfully. We on them court cases. They get a little graphic with them videos, man.
number 2? Okay. And Mr. Monk, you see yourself in this photograph?
Yes.
This is number 2? Yes. For the record, Your Honor, this is number 2. Okay. And Mr. Monk, you see yourself in the photograph?
Yes.
Okay, and what part of the altercation was this?
This was after the initial, when security guards walked up and asked Mr. Cochran to leave.
Okay. And Mr. Cochran is bending over. Do you know at what point of the confrontation he's bending over?
This is right after he's been pepper sprayed.
Okay. And before Mr. Cochran was pepper sprayed, did you see him punch or kick or lunge or anything like that at the 2 security guards?
No.
Okay. This is number 3. At what point is this?
This looks like after, this is where the wrestling starts to take place.
Now you use the word wrestling. Can you describe for the jury, what do you mean by that?
Trying to put it in terms where they're trying to,
They being whom?
the security guards, excuse
Okay.
me, are trying to grab Mr. Cochran, but he is attempting to get them off of him.
Okay. Number 4. And what part is this?
At this point, I believe there's 3 security guards there.
And what do you see one of the security guards doing?
Grabbing Mr. Cochran's leg.
Yeah, 5. And what point is this? Is this after the 3 security guards show up?
Yes, this is 4 security guards there now.
Okay. Now you say there's 4. Can you point out the 4?
One on the legs, one standing up, the individual Caucasian male with bald head right there, and then the one that's not shown is the one that has his arms around the upper area of Mr. Cochran.
Which one is this? 6. This is 6. And what point is this? Is this it?
So this would be when the 5th and final security guard arrived.
Okay. 7.
That almost looks like it went back to the beginning, but
Okay. Number 8.
this looks like right before Southfield Police arrived.
Number 9.
This is when they have Mr. Cochran on the pole, the pillar of LA Diamond.
Now let me ask you a question about this one. Mr. Monk, if you can remember, do you know how long Mackenzie was up against that pillar before Southfield or EMS arrived?
I would say before Southfield arrived, maybe 2 minutes. Before EMS arrived, maybe 6 minutes.
That was 9. This is number 10. Show 11. Do you recall what part of the confrontation this was?
Mr. Cochran, you can see he's already on the pillar, and this is where they are standing there. I can't tell, to be honest, if they're waiting for Southfield or Southfield's already there.
Okay. They being whom?
The security guards.
Okay. This is 13? 12. My apologies for the record. 12.
This is where they're getting ready to roll Mr. Cochran out on the gurney.
13.
This is when they're administering CPR.
Thank you. Now, Mr. Monk, I believe I asked you if we had seen
3 videos before your testimony?
Mm-hmm.
You gotta say yes or no for the record.
Yes, excuse me.
Okay, no problem. Okay. And did you see yourself, this would be, hold on, this would be People's Proposed Exhibit number, 17. This is People's Proposed Exhibit number 17. For the record, is identified as the Matthew Clark video. Did you see yourself in that video?
This one or the other video?
The other video?
Yes.
Okay. And what were you wearing?
I had red pants on and a dark shirt.
Okay. And the video that you saw, that would be People's Proposed Exhibit number 17. Was that a fair and accurate recording of what occurred on January 28, 2014?
Yes.
Okay. Your Honor, I move for admission of People's Proposed Exhibit number 17.
Which video is that?
That's Matthew Clark.
Judge, you be seeing objection. He's not the individual who recorded that video.
Thank you. And in addition to watching the video where you shown photographs,
Yes.
okay, and this will be People's Proposed Exhibits 18 through 24. You see? Okay. Your Honor, may I vote?
Yes.
And if you could describe, take these from this little slide, if you could describe or tell the jury what it is that I have handed you.
These are still shots of the incident that happened.
And did those still shots, did they come from that video, number 17?
Yes.
Okay, you're right, this time up. And are those photographs a fair and accurate depiction of stills from that video?
Yes.
You're right, this time I move to admit People's Proposed Exhibits number 18 through 24.
No objection.
We'll put the, my apologies. Thank you. Okay. We're going to publish the photographs first before we get into video. This is, for the record, number 18. Mr. Monk, do you see yourself in this video?
Yes.
Okay. And there's a person that's sitting on the bench next to you. Who is that?
My wife.
And the individual that's standing up with the all black, and I believe she has on blonde hair. Who is that?
My mom.
Okay. And at what point in the incident is this?
This is, looks like 4 security guards are there, so I would say this is well into the incident.
Okay. And this is number 19? Okay. And what portion is this?
This would be a little bit further than the previous.
Okay. All right. And when you stated earlier in your testimony that there was one security guard on his legs, and is this what you were referring to?
Yes.
Okay. All right. And you said earlier in your testimony that there were security guards that were, you said, holding him, their hands holding his back?
Yes.
Okay. Is that what you were referring to?
Yes.
Okay. And at this point, anytime is Mackenzie Cochran, what is he saying?
I can't breathe.
Okay. Is he punching or is he kicking?
No.
Is he moving?
Yes.
Okay. And how is he moving?
Only thing I can see moving is his legs, his feet swing like back and forth.
Okay. Let's go back. Was his legs, were they swinging back and forth toward the officers? The
No.
security guards?
No.
Okay. Is this number 19? 20. And is this a continuation of what you saw happen?
Yes.
Okay. 21. And this is still close
Yeah.
in time?
Yes.
And 22?
Yes.
And 23?
Yes.
And 24?
Yes.
Okay. I'm sorry. Yes. And in this photograph, do you see all 5 security guards that were there that day?
Yes.
Okay. Now we're going to play People's Exhibit number 17.
Judge, I'm going to object to the video. There's commentary in the background. There's commentary in the background, Judge, that should be muted because that's all becomes hearsay, Judge. So if they want to play the video, it has to be what contains the accused judge and Mr. Cochran. If there's any commentary in the background, Judge, that's all inadmissible hearsay.
Your Honor, it's part of the video. It's not hearsay. It's not being used for the purpose of the matter asserted. It's not hearsay. It's part of the video. It is the best evidence. It's under the rule of completeness. It's not hearsay. It's not being used for the purposes of the matter asserted whatsoever.
There are comments being made, the assertions that, so,
Yeah, well, you're.
just, can you mute it?
Well, Your Honor, I would also add for the record, just in terms of the objection, that it's a present sense impression. These comments, Your Honor, are made as this event is happening. I would also, Your Honor, think that it's also admissible as an excited utterance. Both of those are exceptions to the hearsay rule. Particularly, Your Honor, I think that it definitely comes in under a present sense impression.
Are you calling all of those people that made their statements on this record? Because otherwise, we don't know who they are, why they said what they said.
And Your Honor, and I would just add for the record that I believe that their availability that's immaterial, Your Honor. That's immaterial as to whether or not it comes in as a present sense impression or an excited utterance.
And then, are you able to mute it?
Yes, Your Honor.
How the fuck was it keep catching me, bro?
Now, Mr. Monk, just to, and for the record, Your Honor, that was 2 minutes and, I'm sorry, okay. Just a couple more questions, Mr. Monk. Mr. Monk, were you interviewed by the Southfield Police Department after
Yes.
this incident happened?
Yes.
Okay. And was that close in time as to when it happened?
Yes.
Okay. And as a part of that interview, did you give a written statement?
Yes.
Okay. And do you remember what you wrote in that statement?
Some of it, that's 10 years ago.
Would it refresh your memory to take a look at your written statement?
Yes.
Your Honor, Mayor. I don't want you to read any of it. I just want you to review it and swap with you.
Okay. You said don't read it?
No, I don't want you to read it out loud into the record.
Oh, okay. Gotcha.
So, to our witnesses reading this statement, can we approach, please?
Yes.
Thank you.
Should I start reading? Should I start reading?
And once you're done, you can take a look up.
Okay.
All right.
Oh, okay. I'm kidding you first. No one wants to be like this.
You done?
Yeah.
Okay, thank you. Now, Mr. Monk, in your written statement, I believe on page 1, you wrote that you saw Mackenzie lunge at the security guard. You remember writing that?
Yes.
Okay, and from watching the videos, is it possible that you simply just got that wrong?
I'm gonna
I
object
actually-
as to hearsay.
Okay.
I'm gonna object as to hearsay. It's an out-of-court statement unless she's using it to impeach him or.
It's his own statement, Your Honor.
But it's still made out of court. It's hearsay. Unless you're using it to impeach him, but he's made an inconsistent statement today, which he hasn't.
Well, Your Honor, it's his own statement. The declarant is here. I don't understand how it's hearsay.
Judge, do. All right.
Well, actually, in my original statement, there's a slash in there. It says lunge / to a quick step. So even then, seeing what I saw on the video, I stated that it was a lunge or like a quick step.
Okay. And what you saw on January 20th, 2014, had you ever seen anything like that happen?
No.
Okay. No? That's nothing further. I have no further questions.
Thank you. At this time, I'm going to give a break, I think. The rest of it. I don't know about you, but we've heard.
All rise for the jury.
You may step down.
Thank you.
We'll take a 15-minute recess.
Thank you.
I don't know, well, we'll hang on to it because they still have to ask you questions, so I'm not sure if you're gonna need it now, but
You guys don't want us. Just inconvenience them. Bring them back. I understand. Man, why are you here, man? You're supposed to be sitting here with us, man.
I'm gonna turn this on.
Robin form. I need you to, thanks, Robin. You said it was emailed to you? Yes. But you're not able to print it?
Yeah, I'm not able to open it up for some reason. I don't know how. Gentlemen, how you doing? Good, how are you? Good, good.
We're surviving.
You picked it that quickly, huh? Just one day?
Just one day.
How many times? Right. That's right, 5 each, right?
Yeah.
Right. Because I think it's because of the number of defendants, right?
If you guys had 10, I think we would have ran out of jury pool. We had, what, 4 other trials.
I know, yeah, a lot of them.
OVS, providing emotional and financial assistance. Let your light shine.
I ain't giving them no free promo. It look like they're taking a break. I didn't know, chat. If you don't have the thing highlighted, the mission's never finished. So as we've been running through here, doing all this stuff, guess what, chat? None of the progression from the missions is in. That's why you still see all this freaking little this thing. Well, I haven't been over here. You know what I mean? This thing I've already been through there. This thing I might not have been there. There's a teleporter not there. But I ran through all these because I know that I went through here and made my way all the way around to here. You know what I'm saying? We just making our way downtown, walking by. For some reason, if you notice, if you look at the map, the little GPS ain't working. see everybody stupid gangster until I man get killed. Why is it loud? But I can't transfer it. I don't even understand that, G. I don't even understand that, G's.
He's 56 years old. He turns 57 next month. So
This is, I think they're trying to figure out if he's going to get the death penalty or if he's going to get life.
He's never getting out again.
I figured we'd get back to this when you watch it a couple of days.
The other thing I want to say is that we accept your verdict. I'd be lying if I said that we didn't disagree with some things, but that's just me doing my job for my client. But you all have worked very hard in this case. You deliberated. It's a secret proceeding. I don't know what went on back there, but I just wanted to say that
More of those secret proceedings that we've been hearing about.
we appreciate the conscientious decisions and the hard work that y'all put into this, and we accept the verdict that you all have rendered. Now, this is the sentencing phase.
I don't think
It's a
his
different
defendant,
task
I
than
don't think his client really
trial within a trial,
accept
mini
that
trial,
shit.
fearless expressions.
But I digress.
Normally, the judge sets a sentence in a case, but this is a very special circumstance. So I want to give you some general principles, if you will, to maybe guide you through this process. Protect society. We've talked about that already. I'm not going to beat it to death. Sean Finnegan is never going to get out of custody again. Punishment for the defendant. That's what we're here to figure out. To serve justice. And to follow the law. And where does the law come from in this case? we all know laws are passed by our General Assembly, the legislative branch, our state government, and our elected officials have decided that in this very unique circumstance, in a criminal case like this, that you, the jury, should have 3 options. We talked about those. Life imprisonment, life without the possibility of parole, or a sentence of death. 3 options. I'm here to tell you that the law is satisfied with a life sentence. The law is satisfied with a life sentence. In fact, a life sentence in this case follows the law, it promotes public safety, and it provides punishment to Sean Finnegan. He's never going to get out of jail again. The sentence of whether to impose death is a choice among alternatives. But I want to remind you that it's not some foregone conclusion. The state, a moment ago, got up and talked about putting things on a scale and weighing things. And the court will instruct you. Yes, you are supposed to weigh things. But this is not some rigid, rote, mechanical process. This is not some metaphorical scale where we get out and we put 6 chips on one side and 4 on the other and, presto changeo, sentence of death. Boom, easy, done. Pull a lever. That is not what this is about. And I know you all have been here a long time. I know you've been away from your families, friends, and your life, and your job, all those things. But I cannot impress upon you the importance of not falling into some mechanical view in this process. The state talked about oaths. And I can't remember how many oaths you all have taken throughout this process over the past couple of months, but there's been a lot. But if you remember back to when we were doing individual jury selection, you all took an oath and you took time to fill out those questionnaires, which were very helpful to us, to talk about very personal parts of your life and personal opinions about serious topics like capital punishment, the criminal justice system. And you took an oath that you could meaningfully consider all 3 options. Not just whether you could meaningfully consider a sentence of death, but that you could meaningfully consider all 3 options. And each of you said you could. And each of you are here for a reason. This is not random happenstance. We went through a very lengthy process to select, both from the state and from us, to select you all to serve on this jury. And you're here for a reason, is my point. The law does not recognize automatic death penalty. That's not what this process is about. So I just want to remind you, the law is satisfied with a sentence of life. Next, I want to recognize the loss that Ms. Paxton's family has suffered. The state brought up an opening, and I think it is a good reminder that a great deal of this trial was focused on the power dynamics between Rebecca Dishman and Sean Finnegan. But I'm here to say that it's a tragedy what happened to her. It's awful. We're not here to blame her for anything that she did or didn't do. None of this is her fault. And so I just want to make that clear. Her family through this process, everybody's been very respectful, and I wanted to show them respect as well. But my job, hopefully, is to humanize my client, and I know that seems difficult based on some of the evidence that everybody's reviewed in this case, the lifestyle, the behavior. But I'm here to hopefully emphasize some positive qualities that he possesses. There will be some negative things as well. Our proof will consist of Jennifer Miller from the Pine House again. I wanted her to come back and just talk briefly about his job duties while he worked there, because Sean has worked for, he's 56, he's worked for 40 years of his life consistently. So I just wanted to bring her back to talk a little bit about some of his work responsibilities and what he did there. But the bulk of our proof, our evidence, is going to be in the form of testimony from a family member of his, Miss Roxanne Mundy, who is, there were 6 children in the Finnegan, that generation of children, Sean's brothers and sisters, so he's one of 6. Many of them have passed away. But Miss Mundy is his oldest brother's ex-wife. Sean was raised in Deerfield Beach, Florida, outside, just north of Fort Lauderdale, on the Atlantic side, in between Pompano Beach and Boca Raton. That's where he's from. He moved around some early as a kid, but that's where they settled. And so Roxanne is going to be able to give us not only her knowledge of the family dynamic of the Finnegan family, which is pretty dark, but she also has eyewitness. She lived in the house for about a year when she was pregnant with her first child. So she's going to give you some insights into what things were like there in the Finnegan home. But if I could sum it up, I would say that Sean Finnegan's formative years, his childhood, adolescence, teenage years, there was a lot of damage. There was injury, there was abuse, and none of which he had any control over. And we're offering this not as an excuse. Okay, I want to make that clear as well. I'm not saying that he's justified in doing what he did in this case, or that somehow it's excusable. I think that's an easy cliche, and I think it's kind of cheap. And so I just want to reinforce that we are here simply to explain who he is, because it's important. If you are going to vote whether to sentence someone to death, I think it's important to know a little bit about who they are. I think you want to know something about him, because he sat over here quietly this whole time. He didn't testify in the guilt or innocence phase, which is his right, and there are reasons for that. I don't know if he's going to testify in the sentencing hearing or not, but regardless, I think it's important that we present some information on who he is. And it's also important to show and perhaps differentiate between what many of your all's childhoods were like. We didn't get into that granular level of detail in your jury questionnaires, so I don't know what everyone's walk in life has been, but I think that most of us were raised in a home with love and protection and dignity and guidance and respect, and he didn't really have that in the Finnegan house. So I think we all can agree that children start out basically the same, like a blank slate, and through twists of fate and other decisions and actions that are out of our control, our lives can end up remarkably different. And especially as it relates to a history of sexual abuse and the trauma that he suffered, I think it's important to show that he didn't have any help. He didn't have anybody there for him to support him. His mother, Frances, with 6 kids, and the behavior of his dad, John Sr., Big John. I think poor Frances was just trying to make it day by day. And I think Sean and some of his other brothers slipped through the cracks. And I try to think of it psychologically or even emotionally. And I've got a toddler at home. We put up baby toys a couple of months ago, and one of those hammer sets where you push down and one pops up on the other side of the board. And I think that's a good analogy for the psychology or the emotion of what dealing with trauma is like. That I think Sean, things happened to him, which we're going to talk about. It's not pleasant, but I think that he buried it deep down and tried to lock it away. And it came back out in other ways, in not healthy ways, with violence and risky behavior and toxic relationships and poor decision making and substance use. So I think that's important to remember. As the state mentioned, yes, there are going to be the legal principles of this process are the presentation of aggravating circumstances and presentation of mitigating circumstances. And so our mitigation is going to be basically a variety of instances from his childhood, the things that he experienced, what his family unit was like, sort of the foundation of his life, and why perhaps he may have, why we're all sitting here talking to each other. Maybe some explanation for that. But ultimately, I want you to remember that, aggravating circumstances are a reason to impose death. Mitigation is a reason to vote for life. And at the end of this small trial, I'll get back up and I'll be advocating for a sentence of life. Thank you.
Thanks, sir. State ready to call its first witness.
Your Honor, victim impact statements will be read at this time. And
Okay.
I don't know if the court wants to address those in a particular order, or if you want.
Let's see. The first one I've got is
Should have 4 total.
Beverly Jeffers. Ms. Jeffers, if you'll step up here, please, ma'am. Would you have a seat up here at the witness stand for me, please? You'll raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
You can't tame wild things.
We don't hear that. We got about 30, 45 minutes till the third trial starts.
I want to thank you for allowing me to speak on behalf of our family. Our lives have forever been changed. It is always hurtful to lose someone you love, but it's a different kind of hurt and pain to lose someone you love the way our family lost Jennifer. We didn't just lose Jennifer, she was taken from us. When Jennifer went missing, we looked all over town for her. Gail, Mill, and David and Brittany looked on the south side of Knoxville. The rest of us looked on the north side. We looked for her not just for a day or two. We looked for her for months, day after day. Her grandmother, who she called Mom, would call me almost every day to ask if I had seen Jennifer. It was so hard on us. We knew Jennifer wouldn't go for days and not contact Mill or one of us. Then on August the 6th, 2020, Patty, Jennifer's mother, received a call no mother should ever have to get. They found Jennifer. Patty was so devastated. When she called me, I couldn't understand what she was saying. Then when I finally did understand, I, like the rest of our family, went into complete shock. The most awful thing that could happen to a person and their family did happen. Jennifer was murdered. Jennifer, who was a mother, a daughter, a granddaughter, a sister, a niece, and a cousin. Her mother, Patty, didn't make it through the loss and devastation. She died with a broken heart before Patty passed away. She asked myself and the other ladies here with me today to promise her we would be here every day in court for her and Jennifer to show Jennifer was loved, is loved, and forever will be loved and missed. Thank you.
Thank you so much.
Thank you.
Then next I have. Okay. Do you have any questions? Any questions from the fence? Okay, thank you. Then next I have, is it Brittany Payne? think Miss Payne is going to read hers, but she's also going to read her grandmother's. Is that correct? And your grandmother's name is Mildred Corbin.
Yes.
Correct?
Mil.
Okay. Go raise your right hand, please, ma'am. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. And then obviously anything that I do will learn to do, nothing to do with it. Okay? You say your first name and last name and spell them both for me.
Brittany Payne, Brittanny, Payne.
Thank you, ma'am. Go ahead.
Jennifer.
Is this yours or your grandmother's?
Mine.
Okay.
Jennifer was my first cousin, but we grew up as sisters. I love Jennifer with all my heart, and losing her has really hurt me. I can't think straight. I have nightmares. I can't sleep right. And this past week, I can't even eat right. I can't even listen to songs without thinking of her. It hurts me to know that I'll never see her again. I'll never hear her voice again, or see her smile, or hear her laugh. It absolutely kills me that I didn't get to tell her goodbye. Knowing I'll never get those phone calls or messages ever again destroyed my heart. My whole world changed, turned upside down. I'll never look at this world the same again.
Thank you. And I think this is your grandmother's, correct?
Correct.
And I think she's here today.
She is.
Okay, great. Go ahead.
Jennifer was my granddaughter. I loved her dearly. Losing her destroyed my heart. She was my everything. When Jennifer went missing, we searched everywhere for her. Not for days or weeks. We searched for 8 months. When Jennifer was found, sadly it wasn't the news we were hoping for. When I learned of Jennifer's death, a part of me died as well. I struggle every day. The anger, the hurt, the despair is indescribable. The nightmares that I still live with to this day will not go away in this life. The only thing that helps me get by from day to day is knowing I'll be with her again one day in heaven. Thank you.
Thank you so much. All right. Any questions from the state? Any questions from the defense? Okay. Thank you, ma'am. You can step down. And then next I have, is it Michelle? And Michelle, I think you're the first cousin, right? Okay. Step on up here, please, ma'am. And I added that last page like I asked you to. Okay. And then be sure you don't read anything that I've drawn a line through. Okay? If you'll raise your right hand, swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you for having a seat, please. If you'll tell me your first name and last name and spell them both.
Michelle McMahon, Michelle, McMahan.
Thank you so much. Now you can read your statement.
I'm Michelle, a first cousin to Jennifer's mother, Patricia. First, I'd like to tell you about Jennifer. She was kind and loving, and she cared about other people, even strangers. She grew up with a tough life, as many of us did. The difference between her and us is that she never seemed to make peace and get past the hardships of her childhood and upbringing. She never knew her natural father, and partially, I think that gave her a distorted view of what a typical family unit should be. I believe this led to her making a series of poor decisions in her own life, including the men she chose to try to build a family with. She longed to have a typical, normal American family, but she trusted too easily and too much. Jennifer's mother tried the best she knew how in raising Jennifer, but in her own words, she made a ton of mistakes, especially with Jennifer. Patty was desperate for Jennifer not to make the same mistakes that she did herself, like becoming a mother at just 15 years old. Because of this, she was way too hard on Jennifer, not allowing her to have normal friends. She wasn't allowed to play in the neighborhood like her brothers or hang out with others after school unless it was with family. This is why Jennifer so lovingly clung to her grandmother. She felt loved with her. She was allowed to be more of a child with a normal life when she was with her. So naturally, Jennifer had more of a mother-daughter relationship with her than she did her own mom. Jennifer was also the middle child and the only girl to her mother, Patricia. When Jennifer went missing, it didn't go unnoticed by our family. Even though she had become part of the homeless community, many of us searched for her for months as we looked at every person we passed as we went about our daily lives, hoping to spot her somewhere, as we always had in the past. Patty, like many other parents of addicts, was terrified of getting that call or knock on her door to tell her that Jennifer had overdosed and was gone. I spent much of the time after Jennifer went missing with her mother until her passing only 16 months later. She suffered finding out about Jennifer's demise after 9 months of searching. She blamed herself. She stated and questioned regularly how if she had been a better mom or if she had tried one more time to help her, if she could have prevented what happened to Jennifer. She thought Jennifer fell victim because maybe she didn't feel loved enough, or because she had been so hard on her in her life. Patty died in the hospital, still crying and suffering over what happened. Patty had battled health issues for many years, but after losing a second child, she had just given up. She was tired of the regret, tired of the nightmares and the day thoughts, tired of suffering and missing her daughter, Jennifer. Our family would just like to say that Jennifer was not a prostitute in the terms that one may think. She was a desperate, young, addicted woman who was offered drugs and a place to live in exchange for sex.
Please. Any questions from the state? Any questions from the defense? Thank you, ma'am. You can step down and stay in the court. We're free to go. And ma'am, clerk will mark that as sentencing ID number 1. And it's just for ID. It's not made an exhibit. Yes, sir. Let me get together for you. And any additional proof by the state?
No, Your Honor, state rest.
Thank you. And for the defense, who'll be your first witness?
Please, we call Jennifer Miller.
Ms. Miller. So we need to get Ms. Miller.
She's outside the hallway, Judge. I'm
Okay.
glad to get her up too.
I think the deputy will get her for me.
I'll get her. My co-counsel.
Okay. Yes, sir. You go to the restroom? Okay, we'll take about a 5-minute break. Let y'all step down and go to the restroom. Our 2 officers, y'all need to go? Okay, so y'all stay with me, okay? All right, so rise, please.
They said they just gonna wait there till they come by. Chat, I found out how to talk to people. It was just a moving weapon with will clause 11 and 20,000. Damn! Dude running slow because pockets are full. Oh, these dudes. Chopping, chopping, da, da, da. Ah, chopping, chopping, da, da, da. Hey, shut up. Put him in the window. Hanging him out to dry, you hear me? Hanging him out to dry, damn. They're talking about a intruder alert. Black closure, get him out. You telling nobody I'm here, I need him. Hey Andy, did you notice the reminder? The first digit is 5. Okay, hit me with another clue. Your challenge should you choose to accept to collect a 4-digit code to unlock the loop. Be on it. The other 3 digits can be found in a place where you work up your sweat, on the stairs below the window, and a place where you can read but not for free. Once you find them all, look behind the little red shelter. Opposite. Okay. The thing about it is, that's how you look for all this stuff, bro. Then basically tell you where it's at.
Did you hear that?
Oh, so they back. I didn't kill them other two. I think he said he's tired of living though. Do you remember like your series about that shit? Right? July is the 7th month. Yeah, they fucked that up. But they out there just shooting at random shit. I don't know if we're gonna go around. Hello, chat. Yeah, we'll have to catch me again in a minute.
And last name and spell them both.
Jennifer Miller, JenniferMiller.
Direct Examination Counsel.
Judge, good morning, Ms. Miller. Thank you for being here again in this process. We heard your testimony earlier in this trial. Can you remind the jury again when you worked at the Pint House in Knoxville?
From January 2019 until July 2024.
Okay.
All right.
And when you were working there, what was your position?
I was a manager.
Manager. Was that for front of house, back of house, general manager? How would you describe it?
I was the general manager at first. I was an assistant manager before that.
And so were you responsible for hiring and firing employees?
Mm-hmm.
Did you hire Sean Finnegan?
No.
Okay. He came on. Describe when he worked there, his time period.
There was another manager that we had that hired him, and he was our cook, and he usually worked 5 to 7 days a week. Came in at 5 o'clock at night. Pretty much always showed up on time. Came in when I called him in. Stayed after and cleaned the floors for us.
What would a cook's job duties be at the Pine House at that time period?
Just prepping and cooking, really. Taking out the trash, maybe.
Would somebody that came on at 5 p.m., would they be doing a lot of prep work?
Yes, we only have the one shift, so 5 o'clock is the open to close, yeah.
Okay. And how many cooks would be on the line typically?
Just one at a time.
One at a time.
What?
What kind of cuisine did the Pine House serve at that time?
Just
fried
stuff, burgers.
So that was you then?
And was there...
It was you. It's all right. What's it on?
Did the service ramp up at a particular time of night or morning or late night? Was there a rush? It's a better way to ask it.
Sometimes, maybe like 8 to midnight.
Let me finish the rest of this first.
And how many tables were in the Pine House?
I hate commercials, bro. Hate commercials, bro.
How was the kitchen, large or small, or how would you describe?
It's small.
Small kitchen. Okay. Do you know, this is kind of out there, but do you know what his pay would have been at that time?
I don't know.
Do you think he was paid hourly or salary?
Hourly.
Okay, and so you testified a minute ago, and I think already previously at trial, that Mr. Finnegan worked 5 to 7 days a week. Is that
Right.
what your testimony was?
Yes.
And you had an opinion that he was reliable.
Leave stuff
is that
alone.
right?
Don't bring all that
Yes.
stuff
Okay.
downstairs. Because
Can
you already left all these
describe
toys on
what
the
that
stairs
means in the
yesterday.
context?
It's not going down.
Why is it important to have a reliable cook in a restaurant? Can you describe that a little bit?
There's a lot of turnover. People, they come, they stay for a while, they quit, or they don't show up to their shifts, or they're late frequently, or anything like that.
Was Mr. Finnegan, did he have a lot of no-call, no-shows, or?
Rarely. Very rare, yeah.
Okay. Does the cook also wash the dishes?
There's a dish machine that they just get run through, yeah.
Hobart machine?
Mm-hmm.
Yeah. I remember. Okay. And as far as Mr. Finnegan's attitude and demeanor with the staff, how would you categorize that, or characterize that, excuse me?
Generally pretty normal. We joked around a lot. It's a pretty laid-back job.
Pass the witness, Judge.
No, Your Honor.
Thank you.
Who's next?
Roxanne Mundy, Your Honor.
Deputy, would you get her for me, please?
Yeah, you just killed the mics. Oh, that's still on. Just see some chat. Oh, it's back on.
Your Honor, recalling People versus King, case number 2023-284-855.
I actually thought this trial was over.
Calling
Like they
People
just
versus Marie, case
breeze.
number
But I guess not.
2023-284-856-FH, and People versus Sieberwin, case number 2023-284-857-FH.
Good morning. Good morning, Your Honor. Robin Liddell on behalf of the people.
And good morning, LaDonna Logan on behalf of the people.
Good morning, Your Honor. DeRay Elder on behalf of Mr. King. My pin was 5772.
Good morning, Your Honor. Jamil Puja appearing on behalf of Mr. King.
Good morning, Your Honor. Wright Blake appearing on behalf of Mr. Mowry. Good morning, Your Honor. Keith Brassett appearing on behalf of Mr. Sato.
My, Dr. Brian with the jury. Here we go.
All rise for the jury.
Oh, sure, thank you.
Good morning, Mr. Monk. How are you?
Hey, how are you?
Pretty good. Only have a couple of questions for you. How long were you sitting there before the officers arrived?
I was sitting there probably, I want to say maybe 10, 15 minutes.
Okay. Did you happen to hear any conversation between who we know now as Mackenzie Cochran and the jewelry store owner?
I did not.
Okay. So, you've also earlier, you recognized the witness as Mr. Cyberling, who sits here with the glasses earlier. Did you see him punch, kick, or do a chokehold or anything on Mr. Cochran at all?
No.
No. You saw Mr. Cochran, you identified him as a black male.
Correct.
How large would you say he was?
Maybe 5'9".
Okay. Was he larger than the first two officers who showed up?
Appeared so.
Appeared so. Can you remember what he was wearing?
I know he had on a coat, a thicker coat with a hood, with fur on the hood, and jeans, and appeared to be black Timberland boots.
Was when the first two officers arrived, you said the individual stepped towards who we know now is this, the guy with the bald head.
Correct.
Correct. That was the only time, it was only after that that the sergeant or the officer sprayed the mace.
Correct.
Correct. He was polite to, when the officers first got there, they asked him to leave the mall.
Correct.
They were polite in asking him, meaning they weren't loud or ignorant in telling him to leave the mall. They asked him to leave the mall.
Correct.
Okay. He did not do that.
No.
Okay. How was his body language when he was asked to leave the mall?
How was his body language?
Or how was he holding his body?
I know, fist down at the side like this.
And he was facing towards
the security guard.
Yes, please. How were you? Clenched fists?
Clenched fists.
Okay. And where were they? Hands clenched, but where about?
On the side of his, like each leg.
Okay. Thank you.
Were either of the first two officers obstructing him from leaving, meaning in between the exit and him?
No.
So where was the exit?
Well, the closest exit would have been to his right.
To his right. But there was nobody in between him blocking him?
No.
Okay. Let's see. I have no other questions right now.
Mr. Monk, you gave a statement to law enforcement shortly after this incident, correct?
Correct.
And when you gave a statement to law enforcement, sir, you were honest and truthful, correct?
Correct.
And you were given all the time to write out the statement, correct?
Correct.
No one rushed you at all?
No.
No one told you what to say?
No.
You're able to write down the information, make corrections if you had to, correct?
Correct.
You scratch things out and kind of just then you put it down, read it through yourself,
Yes.
and when you believed it was as accurate as you can possibly be, you signed it, correct?
Correct.
Okay. It would be fair to say, sir, that when you wrote out this statement on the date of your statement, which is the February 14th, 2014, which you're showing today in court.
You guys is there?
February 4th, I'm sorry, 2014, which you were showing in court today. It'd be fair to say, sir, that information is much more accurate than any other time that you testified to, correct?
Should we restate the question for me?
Your information in this report, in the report that you wrote out, is much more accurate than going off memory, correct?
Yes.
All right. Sir, you indicated that you've been at the mall since 2003.
Yes.
And you and I have never spoken, correct? Other than at the examination when we asked you questions, correct?
If we did, I don't remember.
Okay. But you met with the Attorney General's office a number of times, did you not?
Correct.
How many times did you meet with them?
Objection, Your Honor. Relevance?
Just to find out, Judge, how often they had to refresh his memory, Judge.
Well, okay, you can ask him how
Okay.
often he had to refresh his
Sure.
memory, but let's not.
Did the Attorney Generals have to help you refresh your memory, sir, at all, when you met with them?
Not the majority, no.
Okay. So, do you recall the officers talking to Mr. Cochran? You testified earlier it was a very polite voice.
Yes.
They were using words like please, sir, so on and so
It's
forth.
okay.
Correct.
And you indicated
Doesn't
for the
matter.
jury,
Just don't bring all the
if you can
toys out
stand
there.
up and show us how he had his hands, Mr. Cochran. You said
What I
it was
just said.
clenched, correct? Can
Correct.
you stand up?
Play what you already got, because you already got toys on the stairs.
Like this.
Okay, all right. For the record, Judge, both hands straight down the side of his body with his fisted up, Judge. And then the bald head security guard tells him to leave, correct?
Correct.
And then he takes up the pepper spray and shows it to him, correct?
After he asked him to leave.
Correct.
I would say multiple times.
Multiple times.
Yes.
And after he said it multiple times in a polite way, he raises his voice and says, leave,
Yes.
louder, correct?
Correct.
All right. And then at some point or other, he takes up the pepper spray, shows it to Mr. Cochran. Mr. Cochran still doesn't leave, correct?
Correct.
And then do you remember the security guard, the bald-headed guy? He was the one in control, correct?
Correct.
He began to say, sir, do not approach me.
Correct.
And he says it a number of times, correct?
Correct.
And that's when Mr. Cochran either takes a step or lunges, whatever it is that you described, towards the bald-headed security guard, right?
Correct.
And then he's pepper sprayed.
Correct.
All right. Sir, isn't it true that both guards couldn't restrain Mr. Cochran?
Correct.
And at one point or other, sir, he was struggling so much that he was knocking over the signs of the jewelry store, correct?
Correct.
And at one point or other, sir, a third individual shows up, and they still can't control Mr. Cochran, correct?
Correct.
And you hear them multiple times telling him, stop resisting, correct?
Correct.
And sir, at some point or other, do you remember hearing the security guard saying, can you put your hand behind your back for us?
Can't recall that.
Okay. And you indicated that eventually you see the cuffs come on, is that right?
Correct.
And when the cuffs come on, that's when they disengage him, right?
Correct.
All right. Do you remember seeing one of the security guards checking for a pulse?
Nah, that I don't remember.
Okay. So, sir, if I bring you down to your statement, sir, bottom of page 2, second line down.
Do you have any statements?
I do not.
You do not? I'm sorry. Can I get the same statement again? Oh. I'll give it them. Yeah, thank you.
Oh, you're right. Oh, okay.
May I approach, John?
So you guys being held?
Sir, if you bring your attention now to line, page 2, I'm sorry. Second, the last line, it said at some point they kept checking for his pulse.
Yes, I read that. Yes.
They checked at least 5 times, correct?
Yes.
Okay. And they tried to give him water, correct?
Correct.
Sir, when you're sitting on that bench, you're about what, 30 feet away?
About 15, 20 feet away.
Okay, and you have to look to your right, correct?
Correct.
And some of the officers had their back towards you, right?
Correct.
And having their back towards you also obstructs the view of other officers, correct? Of your view of other officers, correct?
No, because at this point when they're on the ground, I can see all 5
Okay.
security guards.
All right. Sir, at no time do you ever see a security guard punch or stomp or kick Mr. Cochran, correct?
Correct.
And you described at some point or other that when he tried to put his arm in your statement, well, let me ask you this. Do you remember that they tried to move Mr. Cochran's arm behind his back to handcuff him in a way that it won't break?
Correct.
Okay. So, when you see Mr. Cochran clench his fist, he was what, within 3 feet of the bald-headed security guard?
I would say about 5 feet.
Okay. And they were as polite as they can be in their commands, correct?
Correct.
Thank you, sir. No, bye.
Mr. Monk, you testified that you had been at or you were at the Northland Mall since 2003.
Correct.
And 10 years ago, you were a store manager?
Stock manager.
Stock manager at Foot Locker, correct?
Correct.
And that's a few doors down from the jewelry store that all this started, correct?
It's more than a few doors down. Almost on the other side of the mall.
Okay, but you just so happened to be in that area.
No, my mom's salon was on the far back wall of Northland. So when I got off work, I would walk over to my mom's salon. But this particular time, I sat down on that bench to eat my lunch.
Okay. Did you know the owner of the jewelry shop?
Not too familiar with him before this incident. We would speak in passing, but not like super buddy.
Okay, so you knew of him, you
So
just didn't know him,
is
correct?
Yeah, correct.
the store owner
When you
being
first heard all this
charged?
commotion, you were sitting on the bench with your wife and mom, or she was somewhere else?
My mom hadn't arrived yet. She was in her salon.
And this confrontation you heard was a violent confrontation. Would you agree with that?
Objection, Your Honor. That's the characterization of violent. I don't
Well,
think that
if
Mr.
you
Ray
know.
was in the speculation.
Well, let me ask you heard some signs being kicked over, or did you observe the signs being kicked over?
I observed.
Okay, and so that the jury understands what kind of signs these are. Are these like little signs sitting on the counter, or are they the size of what, 5 or 6 feet tall?
No, I would say the signs are probably 4.5 feet. Signs that stand in front of a store for advertisement.
Okay, so you saw those signs being kicked aside, correct?
Correct.
And did you see who was doing the kicking?
It was a toss-up between the security guards and Mr. Cochran in the midst of what I described earlier as wrestling or a scuffle.
Did you see what the owner was doing, if anything?
Shouts out to everybody that's still tapped in. We still in the building.
And your testimony that you never heard him say anything.
Shouts out to everybody on Rumble, YouTube, and Twitch. Shout out to everybody.
Now, as you're making this observation, aren't you concerned for your safety?
No.
You didn't think that this was an unusual situation in the Northland Mall?
No.
And unfortunately, I think you even put in your statement that Northland at that time in point 10 years ago had pretty much gone down
Shit
to
was
the,
shaking.
I don't want to put a bad name on it, but it had pretty much become a dump. Would you agree with that?
You're used to seeing peculiar things at Northland.
And escalation of what, homeless people coming in? Would you agree with that?
Now that I can't speak to.
Individuals coming in smelling like marijuana or smoking marijuana there?
Yes.
Shoplifting increase?
Yes.
Fighting increase?
Yes.
So this was pretty much a normal thing that you would see, confrontation or interaction between security and a civilian, right?
Yes.
And as you're sitting there eating your lunch, you don't even move to protect your wife or your mother. You just sit there and make an observation as to what's going on, correct?
Correct, but I also know that they're on the left side of me, so if I need to, I can.
Well, I understand that they're on the side of you, but you know, danger is right there in front of you. The first person you're going to get out the way is, if it's not your wife, it's going to be your mother. Would you agree with that?
Yes.
And then your wife, right?
Well, wife first, then.
Just checking to see. So, and you pretty much stay on this bench for what, like 15,
trying to get my
20
boy
minutes?
caught up at the
observing the whole thing?
Yes.
And have you ever taken classes in CPR and first aid?
Yes.
Did you volunteer to check on this individual to see if there was a pulse or if you could administer CPR?
No, security guards made it clear that they didn't want anyone to approach the individual.
Did you see anybody in the mall try to administer CPR or try to administer any help?
There was one individual who tried to help, but that's why I said the security guards told him to back away.
Do you know if that person was a doctor or not?
I don't.
And looking at the video, it seems like during this whole confrontation, people are just walking back and forth with children, shopping bags, like nothing is going on. Would you agree with that?
I agree. It's Northland.
Now, with respect to Mr. Cochran, you said you heard him say, "I can't breathe," right?
Correct.
Did you also hear him screaming other things or inaudible things?
Yes, inaudible, yes.
And was he doing that in a nice, calm manner like you're doing today, or was he shouting at the top of his lungs?
Top of his lungs.
You know what he was saying?
He was inaudible, so I heard him say specifically that he couldn't breathe, and then at some point he was crying. You can hear the wailing.
So, getting back to Mr. Cochran, had you ever seen this individual in the Northland shopping mall before that particular day 10 years ago?
Not to my recollection, no.
So when you saw him, when you first saw him on that day, you didn't recognize him, correct?
No.
You didn't know whether or not he was a customer or someone shoplifting, fair statement?
Yeah, I didn't know.
You didn't know his mental history or incapacity or whether or not he was on any narcotics, correct?
Objection, Your Honor. That causes speculation. You've already answered he didn't know.
Definitely causes speculation.
Well, that's a different question.
I know, but how
But it's still more speculation. That's my word.
Well, maybe he could tell. He could smell it on him, Judge. There's several ways. You can smell it. You can see somebody like in the
Not a
video
narcotic.
smoking a joint.
You can't
So,
smell
did
the
you see him?
narcotics unless
Did
you
you make any
smoke.
observation?
Objecting as to relevance and also as to foundation.
That's crazy.
I can ask what he observed, Judge.
you can ask him what he observed.
Okay. Did you observe Mr. Cochran smoking anything, sir?
No.
So, during the course of this whole period of time, you're 10 to 15 feet away. You never even get up and leave the park bench, right? Or not the park bench, but the mall bench, right?
Correct.
You had your cell phone on you, correct?
Yes.
Did you bother to call, did you have a number for security?
No.
Did you bother to call Southfield Police to alert them about what was going on?
No.
10 more minutes.
And the fact that you heard Mr. Cochran say that he couldn't breathe, what were you thinking the reason he was saying
Live
that?
in 8 minutes. We're going to switch over to the YSL in 8 minutes.
Let me put it this way.
8
Sir,
more
in your
minutes, chat.
statement,
8
did
more
you
minutes.
indicate to the police that you heard Mr. McCann, Mr. Cochran say that he couldn't breathe?
Yes,
And did you put in there what you thought?
I did.
And what was that? Or why he was saying that?
To get them off of him.
Okay. Now, did you make the observation of the pepper spray?
Yes,
And you said that Mr. Cochran was bent over when he was sprayed, right?
Yes.
Did you see him try to run away from that area?
no,
And you weren't concerned about being in the immediate vicinity of the pepper spray that it might impact you?
no, so I was about 15, 20 feet away.
And you weren't concerned for your wife and your mother that they would be impacted with this pepper spray, correct?
Correct,
Or the scuffle that was taking place, right?
correct,
Because if it was such a violent scuffle, you would have taken them to safety, would you agree?
correct.
So they trying to downplay the scuffle that killed the man?
So,
I heard you. Red Sands and where
you
else?
said that Mr. Cochran, when he was subdued, he immediately put his hands up under his body. Would you agree with that?
You said Mr. Cochran put his hands under his body?
Yes. When he was subdued,
I never,
when he was put on the ground.
you saying he put his hands
Yes.
under?
They were trying to handcuff him, right?
Yeah, correct.
And his hands were up under his body, right?
That would be I guess that would be a fair assessment.
Well, he never had his hands out saying, here, I won't resist.
Right, I object.
Yeah.
That's assuming facts not into evidence. There hasn't been any testimony to that
Yeah,
effect
I don't-
whatsoever.
Go ahead.
I didn't understand the objection.
You're right. I would object. That's assuming facts not into evidence. There hasn't been any testimony whatsoever that Mr. Cochran was putting his hands, near his body, trying to prevent the officers or anyone from trying to handcuff him whatsoever.
That's right.
Maybe not.
Okay.
That's been all of the evidence, Judge.
Stop. Just because the question hasn't been asked, but he certainly can ask that question, and if he knows, he can say what he knows, and if he doesn't, he can say what he doesn't. Go ahead.
Thank you. Thank you. You ever see Mr. Cochran just put his hands out
I don't recall.
during this struggle?
That I don't recall.
Okay, if you had seen that, would you have put that in your statement, sir?
If I've seen it, yes.
And you would agree with me, would you not, that it's not in your statement?
I don't recall that being in my statement. I just read it.
Okay, but you've had like 10 years to read it, right?
That's crazy.
What, Judge?
That's about 10 years to be.
That was just
Take it you didn't like
crazy.
that.
You know, 10 years ago, we just looked it over, okay?
Yes, Your Honor.
Thank you.
So, okay, you would agree it's not in the statement. When did you give a written statement to the police?
February 4th.
You were there when the police arrived, correct?
Correct.
And you didn't give a statement to them that day, correct?
Correct.
And it was February 4th that you gave a statement to Southfield Police?
Correct.
And other than that initial statement, how many other written statements have you given to law enforcement?
That would be the only one.
This like you trying to end this nigga life.
Thank you, Mr. Mark. Nothing further.
I think this redirect. They're all done. Oh. Thank you.
I was waiting for somebody to get up
Oh.
and tell me it was all.
My apologies, Your Honor. I was waiting for you.
That's quite all right.
Okay.
Go ahead.
Now, Mr. Monk, Mr. Elder had you to describe the positions of Mackenzie Cochran's fist. Do you
Yes.
recall Mr. Elder asking you that question?
Correct.
Okay. And you indicated on cross-exam that Mackenzie Cochran's fists were by his side?
Correct.
Did he ever raise his fist?
No.
Did he ever use his fist?
No.
Did you ever see him punching or anything like that with his fist?
No.
You were also asked on cross-examination, but I believe you answered on one of the questions on cross-examination that Mr. Cochran said that he could not breathe.
Correct.
Okay. And do you recall how many times you heard Mr. Cochran say that?
About at least three times.
And if you can recall, did Mr. Cochran
that's
say
not
that
what the prosecutor
before or
heard.
after you heard the crying and the wailing?
Yes.
Was it before or
No,
after?
Judge, that was not fact and evidence about crying and wailing, and she's leading the witness. It's still her witness.
Your Honor,
Just counsel, please.
He actually said that on the stand already.
yes.
He literally already said that.
Your Honor, I do believe that in response, I believe it's to Mr. Blake's question, that the witness indicated that Mackenzie Cochran was crying and wailing. He heard crying and wailing. My question was whether or not he heard the "I can't breathe" statement before or after he heard the crying and wailing.
Wailing.
That was response that was elicited on cross-examination by Mr. Blake. I'm just trying to establish a timeline. Did he hear that statement before or after he heard crying and wailing?
I think
2
that's a
minutes.
different question than what I heard. I'll just withdraw the objection.
After.
I ain't gonna hold you. I don't know if I want to watch this or the thug, because they just breaking all motions and shit.
After I Can't Breathe came before, the crying and wailing came after.
One more question.
Prosecutor don't like that.
That's one more question. Thank you. Now, on cross-exam, well, let me rephrase it. I believe you were asked a question on cross-examination about the statement, about what you wrote on your statement, and I believe Mr. Blake asked you about you saying in your statement that when you heard Mr. Cochran say that "I can't breathe," you thought that he was saying that to get the officers off of him?
Correct.
Okay. Did you observe anything just watching the video that changed your mind?
About the question?
Yes. About whether or not Mr. Cochran was saying "I can't breathe" to get the officers off of him?
It calls for speculation as to what Mr. Cochran is trying to say.
You're right. I don't believe it's speculation. I believe it's observation.
Well, the observation would have been at the point in time that it was taking place, not from looking at a video at this point in time. So I don't disagree with the objection. Thank you. Let's move on.
No further
But it's his recollection of the event.
No questions, Your Honor.
That's a slippery slope with that one, man. That's a slippery slope with that one, Jack.
Okay. Thank you again.
Slippery slopes, God. Slippery slopes, God. I don't know why you telling me I didn't have it.
Yeah, I just had people call Miss Earthina King.
What white one? What are you looking for? You sure it's in there? I asked you if you know it's in there. You told me okay.
Open closure, please watch your step. And I'd like you to remain standing for a moment. Okay. And if you can face my foot,
Good.
this one.
Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give before this court is the whole truth and nothing but the truth?
Yes. Thank you. Good morning, ma'am.
Good morning.
If you could please say and then spell your name for the record, your first and last name.
Earthina Kenny, EARTHENAKINNEY.
Now, Miss Kenny, did you have a business at the Northland Mall?
Yes.
Okay. And what kind of business was it?
Hair and nail salon.
And what was the name of your hair and nail salon?
Phalanges.
And how long was your hair and nail salon, Phalanges, located at Northland Mall?
About 10 years.
Well,
And
YSL
was
was
it
running late.
there on January 28, 2014?
Respectfully.
And where was your hair salon inside the mall?
I want to use the bathroom.
Over
Shout out to
towards
you
the
right
corner,
back. Shout out to everybody that's
like
still
catty
tapping
corner
us
to
on all the
Macy's
platforms.
and,
YouTube,
there's another big store, I can't remember the name of it, but it's
Rumble,
right there in the corner.
and Twitchy.
Now, as Judge Anderson
out
has
my
indicated,
baby.
they
Shouts
are
out to
recording
my
you, so
baby.
you got to
It's
keep your
fine.
voice up. That
Okay.
microphone is deceiving. It doesn't amplify your voice, it just records everything.
Okay.
And you got to make sure everybody hears your testimony.
Oh, okay.
Okay. And Ms. Kenny, do you have children?
Yes.
Okay. And how many children do you have?
3.
Okay. And are boys, girls?
1 girl and 2 boys.
Okay. And did one of your sons, did they also work at Northland Mall?
Yes.
And what is his name?
Hoy Monk.
Okay. And on January 28, 2014, where did Hoy work?
Foot Locker.
And Ms. Kenny, are you familiar with the store called LA Diamonds?
Yes.
Okay. And did you know the owner of that store?
Yes.
And what is his name?
Labib.
Did Labib was Labib a first name or last name, or did you just call him Labib?
Yeah, his name is Labib, his first name.
Okay. And where was LA Diamonds in relationship to your hair and nail salon, Phalanges?
Catty corner to where my salon was.
Okay. Now, when you say catty corner,
it's so if I look out my salon, I could see his store, and it was right across from Foot Locker and Macy's, next to Macy's.
now I want to focus your attention on January 28, 2014. Ms. Kenny, did something happen that day that causes you to be here this morning to testify?
Yes.
Okay. And do you recall what time of day it was?
It was evening.
Okay. Now, Ms. Kenny, did you hear something or see something first?
I heard something first.
Okay. And were you inside of your salon when you heard it?
Yes.
Okay. And describe for the jury what it is that you heard.
I heard yelling.
Were you able to discern or make out what was being yelled, or you just heard yelling itself?
Yeah, just yelling.
Okay. And so when you heard the yelling, what did you do next?
I came out the store and I started walking down towards where the Foot Locker and the jewelry store was. And I walked to the bench. It was a bench there, yeah.
And when you started walking toward, let me back up. The yelling that you heard, was that in the direction of the jewelry store as to where you were walking?
Yes.
Okay. And as you're walking in the direction of the jewelry store, is this LA Diamonds?
Yes.
What do you see?
I see a young man and I see a security officer. And I guess he was talking to the young man. And
Well, it's looking like YSL don't start at the same time it started yesterday, which is
Okay,
12,
so just
13
so
o'clock.
we can get a good, clear record. Now, you say you see a young man.
Mm-hmm.
Do you?
Yes.
You have to say
Respectfully.
yes, okay. Do
It's been
you
summer for
remember what he
2 to
looked
3
like?
months. Now?
yes.
Okay, and what did he
Crazy
look like?
background.
He was a black young man and wasn't that tall, but kind of, average. And he had on a jacket. The jacket and had a hood to it. I seen him all the time anyway, so.
So that was going to be my next question to you, Ms. Kenny. Had you seen this young man before?
Yes.
Okay, and where had you seen him before?
Just in the mall. Yeah, I would see him sometimes over at the food court, when we go get the food, or I just see him walking around, Yeah.
Did you know this young man's name?
No,
Had you ever had any conversations with him?
no,
Okay. When you saw him previously in the mall, did you ever see him causing any type of trouble or anything?
no.
Objection, Rollins. What happened on other days, Judge?
Well, Your Honor, she testified that she had seen him before. I'm just trying to get some more information about the circumstances under which she has seen him, just to have a complete record, Your Honor.
Well, but as to what she observed, that doesn't mean you may have been at the mall other times where she didn't see him and can't testify to that. But let's move on.
Okay, thank you. So let's focus back on January 28, 2014. You said you see this young man.
Yes.
Okay, and then I believe you said you saw a security officer.
Yes.
And do you remember what that security officer looked like?
Yes.
And what did he look like?
He had a bald head, one of the older security officers.
Okay. And when you see this older security guard and the young man, what do you see next?
I see the security officer. He said something to him, and
Him being whom?
to the young man.
Okay.
He said something to him, and the young man turned and he was saying something to him, but I saw the security officer. He had a mace or something in his hand, and he squirted the young man. When he squirted the young man, he goes down, and he was like, ah, he was hollering, ah. And then I see another security officer come, and then that's when they get him down on the ground.
Okay. Now, I'm going to stop you. I want to back up. Now, you said that you saw the one security officer, you said a bald security officer?
Yes.
With mace talking to the young man?
Yes.
Okay. And when you see the bald security officer talking to the young man, do you see, what is the, how far are they apart when they're talking to each other? If you can remember. Are they close or far distance?
Oh, yeah, no, they were kind of close.
Okay.
Yeah.
Do you see the young man punch or kick the bald-headed security guard?
No.
Okay.
Shout out to my people that's in here, the A squad in the building.
And so then you say the bald-headed security guard sprays base?
Yes.
And then another security guard shows up?
Yes.
Okay. And that security guard, do you remember what he looks like?
Yes.
Do you see him in the courtroom today?
Yes.
Okay. And if you see him, so can you describe something that he's wearing?
He has on some glasses and a black suit. That him right there.
Your Honor, let the record reflect that the witness has identified Defendant John Sieberling. Thank you. And so you see the security guard with the glasses come?
Yes.
And what do you see happen next?
Then they get the young man down, but the young man gets back up, and then they get him back down, but another security officer comes. So now it's 3 security officers. So when they get him back down, now they have him down.
So let's back up. You said that the 2 security guards that initially show up, they get the young man down?
Yes.
And how do they get him down?
They like tackle him down. Like it was like an altercation. But the young man, they both just got him and got him down. So the one with the bald head, he had him, and then the other one, he helped him, and then they got him down.
Okay. Now, when you say they got him down, did you see these 2 security guards, did you see their hands or anything like that?
No, everything was going so fast.
Okay, all right. But you said they got him down.
Yeah.
And then the young man gets back up?
Yep, he got up.
Okay.
But they got him back down.
Okay.
It was like fast, yeah.
Okay. And then you say they get him back down again, and then what happens next?
and then another security officer comes, which is the one with the red hair comes.
Okay. The one with the red hair?
Hmm.
Okay.
And then when he comes,
Stop
then they,
one moment.
Okay.
Okay. You're gonna let the record reflect that the witness has identified, I believe, as Mr. Gavin King.
Is that who you're referring to?
yes,
Okay.
Yes. The record is sold.
And then you said the one with the red hair.
yes.
And what do you see him doing?
He gets down, he gets, he's trying to help the other two keep the young man down.
Okay. And how are they keeping him down? Like, what part of their hands are on Mackenzie Cochran's
Judge,
body?
I'm going to object this form of the question. She says they, if she could specify which individual she's talking about, so we know who does what.
Let's do that.
Okay.
There's more than one defendant, so we need to know which one you're referring to.
Yes.
Thank you.
So, the security guard with the glasses, do you see him holding?
Objection to leading, Judge.
Okay. What do you see the security guard with the glasses? What do you see him doing while Mackenzie Cochran is on the ground?
So he's holding the young man. He's holding the young man down. He's at his feet. This young man right here.
Which one?
The one behind him.
Which one? Describe it. Which one?
With the glasses, yes. So he's right there, and then the bald-headed one guy, he's up towards the top of his body. And then the red-headed guy, he's like towards the middle part of his body. But then I see the bigger guy comes, which is right here with the glasses.
Okay.
He comes. Okay.
Okay. Let's back up for a moment. Okay.
Okay.
All right. So you said you see the security guard with the glasses and the dark hair.
Yes.
Okay. And where do you see him?
Down. He's at the bottom, by his feet.
Okay. And then you say the security guard with the red hair. Where do you see him?
He's in the middle.
The middle of whom?
Of the young man, the young man.
All right. The middle of what?
Of his body.
Okay.
But the young man.
Hold on.
Okay.
You got to follow.
Okay, I'm sorry.
Let me ask the question. Okay.
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 You say the middle of his body. Is this his upper body or his lower body?
His mid body.
Okay.
Yes.
Can you, for the record, when you say mid body, can you point somewhere on your body when you say mid body?
Yes, right in here.
Okay. And for the record, I do believe the witness is gesturing toward her lower back.
Yes.
Okay. All right. And then you say you saw another security guard.
Yes.
And do you remember what that security guard looked like?
Yes.
Okay. Do you see that security guard in the courtroom today?
Yes.
Okay. Can you point to him?
Yes. The young man right there with the glasses and the sweater with the white and beige.
Okay.
And black.
You're going to let the record reflect that the witness has identified defendant Aaron Murray. Thank you. And where do you see this security guard?
He's at the top of his head.
Okay. And when you say the top of his head, what do you see him doing at the top of his head? This being
He was holding his head down. Yeah.
Now, when you see these three defendants holding Mr. Cochran, do you see Mr. Mackenzie Cochran punching any of the security guards?
No.
Okay. Do you see Mackenzie kicking any of the security guards?
No.
Okay. When Mackenzie is on the ground, is he face up or is he face down?
Face down.
Okay. Is he saying anything? Mackenzie.
Yes.
What is he saying?
He say help, and he said, I can't breathe. I can't breathe. Yeah, that's what he said.
How many times do you hear Mackenzie say help, if you remember?
He was saying, I think it was a couple of times. And then he said he can't breathe.
And how many times do you hear him say he can't breathe?
I want to say twice. I know the first time he said it, then it was kind of faint.
Oh.
So.
Now, Ms. Kenny, as this was happening, did you try to intervene in any way?
Somewhat.
Okay. What did you do?
I was like, he said he can't breathe. I said that.
Okay.
And then that's when this young man right here was like, I don't know. Yeah, I can't say that. All I heard was.
Let me stop you. When you say this young man, are you referring to one of the defendants?
Oh yeah, I guess he's a defendant.
Okay, the white sweater and the glasses?
Yes.
Okay. He said something in response to you?
Yeah, I'm interfering.
Now, if you remember, how long was Mackenzie Cochran on the ground?
He was on the ground for a minute. Everything was going so fast, but he was down. They had him down there for, it had to be at least, I want to say about 5 or 10 minutes.
Now, when Mackenzie Cochran is saying help and I can't breathe, do the defendants, do they get off of Mackenzie?
No.
Okay. Did you see any handcuffs?
Yeah.
Okay. And where did you see the handcuffs?
They were trying to handcuff him.
Okay. They being whom?
The security officer was trying to handcuff him.
Do you remember which security?
The redheaded. I mean, what's his name?
Mr. King?
Mr. King.
Okay.
That's all right.
I believe it was Mr. King, yeah.
Okay.
Because they were all, yeah.
Okay. You got to speak up.
Speak up.
Speak up.
No, I was saying I believe it was Mr. King. They were all on him.
Okay. Now, when you say they, who are you talking about?
All of the security officers, Mr. King, the one with the beige and brown on, Mr. What's his name?
Mary?
Mr. Mary and Mr. Sibley, and the one with the bald head. I don't see him here, but he was on him too.
Oh.
Yeah.
Now,
when
Mr. King is trying to handcuff Mackenzie, is he trying to handcuff Mr. Cochran in front or behind his back?
Behind his back.
Okay. And is Mr. King able to get Mackenzie handcuffed?
Not at first.
Okay.
No.
So tell me, what do you see happen next?
Then I see they were all on, the security officers were all on top of him, and then when it ended up being 5 security officers, and at first it was 4, but then it ended up being another security officer. So they finally get him to where they can put his hands get his hands behind his back, and then I believe officer, the one with the red hair, he cuffs him, King, and then he wasn't saying anything anymore.
He being whom?
The young man.
Okay. Did you later learn his name to be Mackenzie Cochran?
Mackenzie Cochran.
Okay, all right.
Yeah.
So you say he wasn't saying anything anymore?
No.
Is this still while he's on the floor?
Yes.
Is he moving while he's, at some point in time, does he stop moving on the floor?
Yes.
Okay. So after the handcuffs are on Mackenzie, what do you see happen next?
When I turned back around, I see they had set him up on, when I say they had set him up against the wall. The security officers had set him up against the wall, and his head was just down, but he was still handcuffed, and his head was just down like that. And then somebody got some water, but I walked over to where the Foot Locker was, and I started talking to the manager of the Kids Foot Locker, that's what it was, over to the Kids Foot Locker, and I started talking to her.
Now, Ms. Kinney, when Mackenzie is up against this wall, you said his head was down?
Yeah.
Could you tell whether or not his eyes were open or closed?
It just looked, from what I saw, they looked closed. And he was just there. He was just there. Yeah.
Was he talking or moving?
No.
Okay, all right. Now, Ms. Kinney, were you still around when Southfield Police Department arrived?
Yes.
Okay. And what about EMS? Were you there when EMS arrived?
Yes.
Okay. And what do you see EMS do?
They lay him out on, then they get him on top of the gurney, and they try to resuscitate him. But then that's not working, so then they get those shock things. And then they do that, and then they just like lift the thing up, and then they just start running towards the door to take him out of the mall. Yeah.
And after Mackenzie Cochran is taken out of the mall, do you go back to your salon?
No.
Okay.
I actually had a little, like, I guess you would call it a confrontation with the young man with the beige and the black.
Okay. Hold on, let me stop.
Okay.
Okay. Now you say you had a confrontation?
Well, I wouldn't call it a confrontation, but I had words.
Okay. You had words with Mr. Mari?
Yes.
Okay. And where did this take place?
He was right there. He was leaving from going down, I guess going downstairs, because right where we were, you could go downstairs to the security and to the office and stuff.
Okay.
Yeah, and I just said to him, with your big old butt, you shouldn't have been on him no way. And then that's what he said, F you. And I was like, no, F you.
Can I just get who's she talking?
Mr. Mari.
Because we have an instruction that evidence only applies to that defendant, not the other ones.
Yes, that's true.
Thank you.
Now, Ms. Kenny, I'm going to show you some photographs, and these are already admitted exhibits. This would be 18 through 24. Your Honor, may I approach the witness?
Have you? Why just smoking, man? I swear I'll be hearing my case for you.
You can take them. And just flip through them for me, Ms. Kenny. Do you recognize these photographs?
Yes. You mean me in them?
Yes.
Oh, yes.
Okay, that's what I mean. You recognize these photographs and recognize anybody in them?
Me.
Okay.
And my son.
Okay. Nice. You look at the, we're going to put number 18.
Right.
Oh, we need to check. Thank you. Okay. Now, Ms. Kenny, can you take a look at the screen for me? This would be number 18. Okay, this is number 18. Ms. Kenny, do you see yourself in this photograph?
Yes.
Okay. And can you just tell us who you are? Which one are you?
Right there, standing up with the blonde hair and that black coat on.
That's you right there?
Yes.
Okay. All right. And if you can recall, what part of the altercation was this?
This is when they had got him down. Oh, yep. That's when they had got him down, when the other officer had came.
Okay. So 19. And you still in this photograph too?
Yes.
Okay. All right. And is this where all 5 of the security guards were there?
Yes.
Okay. And this is 20. You still in it?
Yes.
Okay. Are you seated in this photograph?
Yes.
Okay. All right. Okay. This 21? Yes. Now, you said that there was, Mr. Siebling was on Mackenzie's legs?
Yes.
Okay. All right. Do you see that in this photograph?
Yes.
Okay. All right. And this is 21? 22. Thank you. Okay. And you see yourself still in this photograph too?
Yes.
And 23? Are you still here? Okay. And,
No.
All right. 24. Okay. Now, Ms. Kenny, before your testimony today, did you watch some video?
Yes.
Okay. You okay? All right. In the video, did you recognize yourself in that video?
Yes.
Okay. And that will be number 17. We're going to play the video.
Yes, remember game 12:45. We're clicking over to the next draw.
Yes, play it on mute.
Shout out to everybody that's tapping in. Shout out to my people. Shout out to my people.
Ms. Kenny, this is this recording. Is this what you observed and what you saw on January 20th, 2014?
Yes.
And Ms. Kenny, at this point, you're no longer in the video. Is this the point you have walked away?
Mm-hmm.
You gotta say yes or no.
Yes, I'm sorry.
And for the record, that's 3 minutes and 28 seconds into the video. I have no further questions of this witness.
Morning, Ms. Kinney.
Good morning.
Now, Ms. Kinney, you've testified that you had some interaction with this individual on the end.
Yes.
With the white and brown sweater, correct?
Yes.
And you were asked, was he on Mr. Cochran, and you said he was at a certain position on him, correct?
Yes.
And what was that position there?
He was at the top, the upper part of his body, by his head and up in here.
Okay, you're pointing to your shoulders. Now, so that we get the specific location of my client, were his hands on that individual, his weight, or was his knee on him, his body? What exactly was on the head?
From what I could see, it was pretty much his weight was on his head, and not his head, his neck area.
Okay, when you
and
say...
he had his hands on him, but he was like leaning like toward, on him, like putting his body weight on him.
Okay, so he's standing over him, like with his hands on a...
He wasn't standing. He was down.
Were the security guard's knees on the ground?
Yes.
Okay. And was he leaning over?
He was leaning over the young man.
Okay, but where were his hands?
His hands was on the young man here.
Okay.
Both sides. He had them like this.
So
both sides of his.
Looks like you're saying that his hands were on the Mr. Cochran's
shoulders. Yes.
Okay, so that's the only position or area you saw that individual, right?
Yes.
You didn't see him on the side of Mr. Cochran?
No.
You didn't see him trying to move his arms?
No.
He stayed consistently at the top?
Yes.
Okay. And did you,
you
said that you had some
45
interaction.
seconds in.
He said something to you?
Yes.
When did he?
We're going to
stop
wait to
this
file our
one,
motion in
but we're
limine
gonna
because
go
we are
back
working with
next.
the state, and we want to make sure we're not wasting the court's time.
Okay, I appreciate that.
You're not gonna lie, it sounded like they already started breaking.
And I meant to bring this up earlier today. I'm sorry. I have a client that's scheduled for a bond hearing at 2. I have
Co-defendants in court talking
attorney
and shit.
coming in.
Dog would start looking at the
court
damn
permission
cameras.
to sit with Mr. Stillwell briefly for about 15 minutes while I conduct a bond hearing, if that's okay with Your Honor. It's on Zoom.
Is it okay with Mr. Stillwell?
Mr. Stillwell, he usually works with me.
Did he say yes?
So is that, it's fine with you if he takes a brief break? Okay. Well, obviously hurry back because you seem to be the main person making a lot of the evidentiary arguments. So
that's a fact.
Yes, Your
we'll
Honor.
miss you while you're gone.
All right, thank you.
All right.
Bro, so I got this man.
Anything else
Look
from
at Shannon.
anybody? I know, Mr. Matthews, you had
Shannon
let me
looked
know
like, nigga, I
after
ain't
we
even
went
YSL
off the
no more. I
record
quit.
yesterday in the presence of the state as
I
well
quit,
that you wanted to circle back on one of the items of evidence that we had reviewed yesterday. So you can go ahead and do that.
Would you like to do that now?
Sure.
Okay. All right.
That's discreet. We can go ahead and get that taken care of.
Judge, we're before this court representing Mr. Marquavius Huey on this matter. There's an intrinsic act that was listed in the state's notice to us back in November of last year concerning item 43, which is an intrinsic act that the state is alleging should be coming into this trial. Your Honor, that particular intrinsic act stems from a November 30th, 2021 alleged incident. It's a police chase, Your Honor. In that police chase, the state are presenting to the court that this intrinsic act is somehow connected to this case and should come into evidence. That's the issue before the court. The rule that I'm asking this court to apply in this particular case obviously deals with intrinsic acts and what are the requirements for them to come in. As the court is aware, and I've cited for the court Murphy versus the state, 354 Georgia App 560. It's a 2020 case, and the case stands for the proposition that in order for intrinsic evidence to come in, evidence is admissible as intrinsic evidence when it is an uncharged offense arising from the same transaction or series of transactions as the charged offense. So the charged offense in our case, Your Honor, is stemming from an October 1, 2020 alleged armed robbery of a deceased individual, Gary Holloman, from October 1, 2020. So it is not meeting the threshold of being an uncharged offense that is arising from the same transaction or series of transactions. Number two, for consideration for this court is whether or not this particular alleged evidence is necessary to complete the story of the crime. Again, we're talking about a November 30th, 2021 police chase that is not necessary to complete any story of any alleged armed robbery of Gary Holloman on October 1st, 2020. It's not necessary to have the state provide more information in order for them to complete the context of their story. Number three, for the court's consideration as adopted from the 11th Circuit, is whether or not this particular alleged conduct as an intrinsic act is inextricably intertwined with the evidence regarding the charged offense of the armed robbery from October 1, 2020. According to the court in Murphy, evidence of other acts is inextricably intertwined with the evidence regarding the charged offense if it forms an integral and natural part of the witness's accounts of the circumstances surrounding the offenses for which the defendant was indicted. So it's not inextricably intertwined from the standpoint of the November 30th, 2021 alleged this police chase where they're alleging that Mr. Huey was involved in this police chase. There's nothing about the October 1, 2020 case that involves a particular vehicle that is supposed to be part of this police chase. So there's no connection there. With respect to the police chase itself, the vehicle was not apprehended. That's number one. The chase was ultimately called off. The identity of the driver on that day was never established through any apprehension. The vehicle eluded law enforcement. There were no admissions through any subsequent arrest that was made on Mr. Huey of any admission to even being a part of this police chase, being a driver in this car.
Shouts out to everybody that was tapping in with you, boy.
There's no photos of Mr. Huey operating this particular vehicle. There's no ownership information that would show that he actually was operating this particular vehicle on that day. And the vehicle is not the subject of having been used in this particular alleged armed robbery on October 1, 2020. So the vehicle is not.
Fucking commercials, bro. How do y'all just start trial and already have commercials?
Crime in this particular indictment. So what we have here, Your Honor, is a separate alleged crime here of a police chase, that the vehicle was I think it was a burgundy Nissan vehicle. It was fully dark tinted up. So no one could see inside the vehicle from the windows to the vehicle because it was fully tinted. So when you look at what we have here, we're having a separate incident that is over a year after the October 1, 2020 alleged armed robbery. And just to give the court some context on October 1, 2020 alleged armed robbery. So Mr. Huey was arrested on those charges for the October 1, 2020 incident. When he was arrested, he sat in the Fulton County Jail for a period of time, and we had a preliminary hearing on the case, probably sometime in November or so of 2020, give or take. And that particular armed robbery offense, we were able to get the armed robbery case dismissed at the probable cause hearing for lack of evidence. And then the state, they made a decision to indict the case after there was a dismissal at the preliminary hearing stage. So subsequent to that, a grand jury indicted Mr. Huey on these charges from the October 1, 2020 incident. And when they indicted Mr. Huey, they added charges, and therefore they put forth a grand jury bench warrant. There's no indication that they were able to establish that on November 30th, 2021, when this police chase was involved, that Mr. Huey was somehow running from the police because of he knew that there was a grand jury bench warrant or anything of that nature. In fact, Mr. Huey reported to court before Judge Dunaway on the indicted case and was taken into custody in court.
When
So,
was that?
that would have been in 2000. It was in December of 2021. Okay, so he shows up in the court, and he has been in custody ever since. So, as it relates to this intrinsic act, it just doesn't meet the criteria. Then the last step, Your Honor, I'd like to direct the court to Hines versus State. That's going to be 353 Georgia App 710. It's a 2020 case. So after the court does its analysis in terms of whether or not it is an intrinsic act that needs to be part of this case, the court then has to go to the next step of whether or not it survives a 403 analysis. In the Murphy court, the court stated that Murphy has not shown that this alleged deficiency prejudiced him, and that is his lawyer not objecting to certain evidence that was intrinsic coming in. So the Murphy court said, hey, listen, you have to show that you were prejudiced by this coming in.
That was an effective assistance claim. That's
Sure.
a different kind of procedural stance than what you're talking about.
Agreed, but I agree. What I'm asking the court to look at is if this court says, hey, look, I think that it is intrinsic, I do think that it somehow meets one of those thresholds, then the court will go to the next step of whether or not there should be a 403 analysis to determine whether it comes in. So with that being said, in Hines versus the State that I previously cited, there was an intrinsic act, and the intrinsic act was some information that came into to that trial concerning that particular defendant. And in that reference, it stated that this particular defendant, there was a word that was used that she maltreated or injured or harmed her children, and the court believed that that was prejudicial. In this instance, Your Honor, if this court allows this scant piece of evidence that has not been established that it was in fact Mr. Huey that did this conduct, we now have to look at, well, what is going to happen if this comes in? If you review this particular video, Your Honor, this police chase, you will hear in the on the radio inside the police car as they're driving on the radio, they're sending out this information. These are the things that are quoted. He has a history of running, and he has all these warrants. That's in the video. Put some stop stakes in front of him. That's number one. Number two, he's armed and dangerous, known to carry a gun. That's number two. Number three, do you know where he lives at? And then they talk about his address. So these are all prejudicial items that are going to come into evidence if this court allows this particular intrinsic conduct, and that would prejudice Mr. Huey immensely here, because these are things that are going to go to his character, it's going to go to propensity, and it's going to suggest that there's some type of consciousness of guilt.
Let me ask you this.
Sure.
Is it possible that if I determine that this is intrinsic, that video could be played without the audio?
I imagine they could potentially play it without the audio, but there, again, there are a number of hurdles here that I would submit that do not meet the threshold of coming in based upon those three items that are required.
Right.
So it doesn't meet 1, 2, or 3. It's over a year after the October 1, 2020 alleged armed robbery of Gary Holloman. This police chase occurred on November 30th, 2021. The vehicle was not apprehended. The chase was ultimately called off. The identity of the driver on the day was never established, even by preponderance of the evidence, which would be, I think, the standard for these evidentiary issues to come in. It was called off. There are no admissions, no photos, heavily dark tinted windows. So that's my position, Your Honor. I don't believe that this one would pass the muster and the requirements to meet the intrinsic acts threshold. And then after that, we believe that it's prejudicial and should be kept out on that as well. Because as the court knows, when we're talking about the 403 analysis, it talks about and tells us and teaches us that we should not be allowing under 403 prejudicial items to come into trial that are scant.
Okay, I understand the argument. Let's hear from the state. And I appreciate you bringing to my attention that the chase was over a year afterwards and the circumstances of that. And I know that in the state's filing from November of 2023, they have the dates. So I'm not meaning to suggest that they were trying to pull anything over. We kind of ran through that real fast yesterday and, just kind of talked about a fleeing that was after the armed robbery that's an overt act. And I just kind of was thinking in my mind without looking at all of the words, oh, okay, this is at the same time. So thank you.
You're welcome, Judge.
Good afternoon, Your Honor.
Hello.
The state believes that this should be admitted as an intrinsic act. Just a few things for dates, Your Honor. So the preliminary hearing for the original armed robbery was actually in August of 2021. It was August 24th, 2021. At that point, the judge reserved her ruling and ruled either the next day or subsequently and dismissed the charges. Then in November of 2021 is when the state indicted the case. So November 8th, 2021 is when the case was indicted with additional charges and the grand jury warrants were taken out on November 15th, 2021. This chase actually occurs on November 30th, 2021, so about 15 days after the grand jury warrants were issued in this case. And Your Honor, on November 30th, 2021, Investigator Flores was actually conducting surveillance on Mr. Huey. So the notion that the police or law enforcement did not know who Mr. Huey was, they did know who he was. They were conducting surveillance on him and watched him enter into the vehicle, so they knew who he was once he entered into the vehicle. They tried to initially blue light him and pull him over.
Was he driving? I mean, did they see him get into the driver's seat?
He was driving. He was the only person in the vehicle.
Uh-huh.
They attempted to blue light him and pull him over. At that point, he took off, and he, amongst other traffic offenses, went to the wrong side of traffic. They were then able to get the Phoenix air unit up to follow him. And the reason why the chase was called off, Your Honor, is because Mr. Huey drove in restricted airspace. So the Phoenix unit could no longer watch the vehicle because he was near the airport, and so they could not go any further. So they had to pull back and could not keep eyes on him. So that is why the chase was
Okay. Well, let me ask you this. So, I mean, you have evidence that it was Huey who got into the vehicle and who was driving the vehicle, and that he fled when he was blue lighted. Do you have any evidence that he knew that the reason they well, two questions. Was the reason they blue lighted him because they were about to arrest him on the grand jury warrant? And do you have evidence that he knew that, such that it would arguably be intrinsic to this charged armed robbery?
To answer question number one, yes, they were going to stop him based on the grand jury warrant. As to question number two, it appears, and I'm looking at text messages from his phone, and I don't know, all I can do is quote what I have, and these are text messages from November 8th of 2021. He says, just wait till after Christmas and the New Year and turn yourself in, see what they talk about.
All right, what? Okay, so, and the chase is November 30th, so this is several weeks before then.
Correct. And so the case went to grand jury on November 8th. The warrants were issued on November 15th. These are text messages he's receiving.
Oh, Jeff.
And I want to make sure. Yes, it appears that these are text messages from his girlfriend to him on November 8th. And she's saying to him, just wait till after Christmas and the New Year and turn yourself in, see what they're talking about. She says it might not be a lot of time. You think somebody's snitching on you. And then his response is, I can't miss another Christmas, man. And then he goes in, yes, I don't want you to, but you can't run long either. That's going to make it worse. I'm lost. I don't know what to do. I would say to go to court, they might lock you up. He's like, yeah, but then they might not. So it appears from text messages.
So how's they gonna shake this shit up? Like, who they gonna get to take his spot?
Had indicted the case. Again, warrants weren't out yet, but at least that the grand jury had indicted the case because those text messages are from.
Oh yeah. All right, we can do that.
Of 2021. So that's all the evidence that I would have.
All right. Well, I mean, given that he says, yeah, they might lock me up, maybe they won't. I don't think that. I mean, it's an argument to be made, but I think we're getting a little far afield of what's charged in this case. So I think I'm actually going to keep that particular incident out.
But I would just argue that he's fleeing from the armed robbery.
I know you're arguing that, but it's my ruling, so.
Thank you.
All right. All right, and with regard to the two kind of post-indictment intrinsic acts or arguably intrinsic acts, the stabbing in the jail and the exchange of the Percocet, I've watched the video now about the Percocet. I mean, I think that the state's rendition of what occurred is, pretty much on point. I can't hear what any deputy says, but, I don't think that there was anything particularly off about how they described what happened. I mean, I see what happens on the video. I've looked at some further case law, and how soon do y'all need to know what my ruling is on that? Because I'm kind of having the same thoughts about if we're talking about, whether these actually meet the in any of the three requirements for intrinsic evidence, and then on top of that, 403, I'm just not real certain that these need to come in. I haven't made my final ruling yet, but I don't think that either of these is something that the state can't try the case without, which is not the only test, but I don't think they meet that test. So just kind of FYI on that. I'm having some.
May we offer some case law for the court?
Sure.
We'd offer to the court an 11th Circuit case decided June 20th, 2024, United States versus Harding, Harding. The site being 2024 U.S. app, Lexus 14995.
Okay, and what does it say?
Your Honor.
Or if you've got a copy of it, that's fine too, or I can just plug it in here.
And Harding, we do have a copy of it.
Okay.
And it's just standing for the proposition generally that an act that occurs after the indictment can be included.
Yeah. Okay. No, I've found my own cases that say that. Yeah, that's clear. It's not post-indictment does not bar it from being an intrinsic act. That law is pretty clear.
Right, Judge, and if I may, just very briefly, let me stand up.
That's all right. I mean, I got it. It's just...
I guess going back to the court's question in regards to how soon we need an answer from you in regards to that. I can't speak for the state. I'm not sure when they planned to try and present that evidence, but I would ask the court to continue giving it its full analysis, and especially in regards to the 403 and the overarching consideration as to whether or not they really need this particular piece of evidence to make out their case in chief. I don't believe that's the case, but I know that the court is wrestling with that. And I'll look at I don't know if I really need to look at the Harding case because we've already kind of established that that issue is not really an issue. Right. But I'll be happy to look for some additional case law.
Okay, thank you. Appreciate it.
Your Honor, you had asked the same. I'm sorry. Your Honor, you had asked the same of me. I have been pulling some case law, trying to put it together in a coherent presentation instead of just a list for Your Honor.
Okay, sure.
I definitely do want to take a look at this Harding case where it was found that the district court abused its discretion by admitting evidence as being intrinsic. So I certainly would like to take a look at that.
Okay.
So Your Honor, in terms of other cases that talk about intrinsic evidence, we would just cite the court to Jennings versus the state, 318 Georgia, 579. And I am just giving a list right now that for the court's consideration. This is not something that we have to decide right now. This particular one is not coming up at all soon. The next case is Anderson versus the state, which is 313 Georgia, 178.
And what are these standing for?
These are all regarding the intrinsic evidence and how it is that one is how one is to look at and determine whether evidence is intrinsic, broadly speaking.
Okay. Yeah, actually, U.S. v. Harding, I'm pulling up what I put in my Lexis research folder this morning, and that's actually one of the cases that I was looking at this morning.
Okay. And the last one is Hughes versus the state, 312 Georgia, 149. And we too will present to the court a more coherent sort of overall arching.
All right. Appreciate it.
Argument.
Okay. All right, so where do we want to turn now. What are y'all ready to talk about?
So, Judge, if the court likes, we have reviewed we haven't discussed it with Mr. Williams' counsel, but we've reviewed and looked over the brutal motion redactions. Okay. So I'll let counsel for defendant Williams speak to them, because this is Mr. Kendrick's statement that is already in there. Portions that he is arguing are inadmissible because of Bruton. Mm-hmm. Our position overall is that Bruton specifically requires that that a defendant be directly inculpated, and at these various points, I'll let them explain why they feel like someone is directly inculpated, so that I can respond. But we've reviewed them, and whenever the courts.
All right. So, is it the state's position then that none of the identified portions of Mr. Kendrick's statement actually qualify under Bruton?
No, there's one enumerated time area.
Which one is that?
And they have it enumerated as.
And has anybody sent me that statement? I think I asked, but I'm not sure that I received it.
Mr. Kendrick's statement?
Yeah, that's the one at issue right now. Yes. And maybe you did. Obviously, I'm getting lots of emails through Ms. Persifield from all of y'all, but I don't recall seeing it.
I'll make sure.
Maybe somebody could just send it now, since that's what we'll be discussing. All right, so which is the one that you don't have an issue with?
It's the point at which the detectives ask Mr. Kendrick, who do you think did it? And
okay, so he's actually broken them down into little Roman numerals. So which Roman numeral are we talking about?
I wrote at the bottom my own timestamp. It's at 10004. So that would be. Here it is. It's their number 8. Well, they're number 9 really, but they're number 8 specifically.
Detective Gaither mentions Mr. Stillwell, the one that is labeled that.
Right.
Okay.
Well, it's labeled, I'm sorry, Mr. Kendrick mentions Mr. Stillwell telling detectives who they say killed.
That's 8. But, okay. And you agree that that should be excised?
Partially, because what happens is that this is the part that we would ask, that we specifically would argue is not inculpating anyone. Okay. What Mr. Kendrick says is they say our crew. And he's, in saying our crew, he's acknowledging that there is a crew. He said, because we're the ones beefing. And then they specifically say, who within your crew? And at some point, Mr. Kendrick says, they say Shannon. That part we would agree comes out, but they didn't enumerate it exactly that way on this sheet of paper. So they say Shannon, we would agree.
We're going to my island for a few days. Do you guys want to come?
We need to know what's really going on. Blink twice if I'm in danger.
Blink twice. Rated R.
Let's get real. Your butt's not perfect. But at Orgain, we love them all. We love Ricky the Rump.
Love you back.
Bubble Butt Bobby.
That's me.
Laura Longcheeks. Tara the Tush. Lad Iron Phil. Madame Derriere.
Merci.
Boney Brittany. Clenching Craig.
I'm clenching right now.
And Wedgie Wendy.
I like it this way. Hi, Bob.
Feel good about your booty and the rest of you too with protein-packed nutrition from Orgain. It's real nutrition for real life.
If the state, if I heard correctly, if the state is not, over objection, by the way, intending to play the actual recording, then it's just question and answer. So I assume they're going to advise the witness, whomever the witness is, don't mention Mr. Williams, or if you're going to mention Mr. Williams, what are the specifics? Because otherwise we're just going through something that they may not ask the question.
Your Honor, if I may respond to that, I'm glad Mr. Steele brought that up, because as we were going through these last night, there are portions that I needed to bring to the court's attention that I need the jury to hear Mr. Kendrick say. So we don't intend to play the video
in total.
Right.
Okay.
But there are portions that we would be introducing to have so that the jury hears him. And generally speaking, the overall method of introducing the majority of his statements would be through questions to avoid any implication of brutal.
All right. Well, if there are particular portions that you know you intend to actually have the jury watch and listen to, if you can let the defense know which those are, that'll probably be helpful.
Okay.
That's easier, because if it's question and answer, it's easier to deal with.
Yeah, sure. So just let them know which of the portions. But okay, let's go through all of these if we need to, which it sounds like we need to.
Did you send it to me?
So do you want me to be, is there a transcript for this statement, or do I need to be listening to the audio?
We don't have a transcript of this statement.
Okay.
But we can. I don't know how they want to do this. Since the defense has timestamps on it that are different than what we have, I think they may have downloaded it into an MP4 format, so it may be easier for them to play it from their format, because I have a specific time. And they
Sure. Mr. Steele, would you be able to play the video or the portions of the video that you want to litigate for us here so that I can know exactly what that says? Okay, that'd be great. Okay.
Yeah.
Sure.
Can I just bring up another concern on this subject? The concerns aren't limited to Bruton. I still we're talking about playing a tape where Mr. Kendrick says that other people are saying, he's not saying anything that he knows, he's not telling on anyone, but he's saying other people are saying that our crew and Shannon and Woody, and they're talking about taking Shannon's name out of it, which of course I'm in favor of, but I'm not even.
Yeah, no, I agree. That's a little weird that the state's evidence would be, well, I mean, here's what the rumor on the street is.
Right.
So I bet Ms. Relev's going to say we're not intending to elicit that.
Exactly, Judge. The point is not, and we can tailor the questioning and the presentation of evidence to, not include.
Okay, well, I mean, I suspect the reason they're asking that now is because when we just went over that example, you thought that the only, and you may have just been saying the only part that I believe is Bruton is this part where somebody is specifically mentioned, and that's fair. But if you don't intend to use any of that portion of the tape anyway, or get a question and answer that would elicit that information, then it would be helpful if you would say that, because there's no point in us, spending time on something that the state doesn't intend to use anyway.
So to speak to that example, for instance, I might ask the detective a question that, did you talk to Mr. Kendrick about the Donovan Thomas murder?
Okay, that answer would be yes.
Yes. Did generally speaking, what?
Let me ask you this. Do you think that it's relevant for the jury to hear that, Mr. Kendrick said, well, here's what the story on the street is right now?
No, that part I don't. I don't think that part about, the people on the street think X, Y, Z is relevant. The relevant part is his acknowledgement that
our crew
was beefing with them.
Okay.
There was a us and a them that was in conflict.
Okay. So then the only part of that then that you might elicit is that he acknowledged that at the time this all occurred, his crew was beefing with the other crew.
Yes.
Okay.
Thank you for actually.
All right. So when we're going through any of these other ones, if there's something similar, just kind of let us know that. Okay.
Judge, we've just now sent to the court, we're sending to the court the October 6, 2015 interview. Does the court need the evidence reviewer player sent to it again?
So, no, I don't think so. But if we're going to go by Mr. Steele's playing of it that has his timestamps, I guess I'll just watch that on Zoom. Are we close, Mr. Steele?
I think that the answer is yes, I believe.
Okay.
I'm not doing
Okay.
So I guess for me, yes.
And I don't want to belabor unnecessary points.
Mhm.
We are looking at it, and I was looking at this for the purpose of Bruton.
Right. Sure. Any other little discrete items we can deal with while we're waiting? Nope.
We could look at the operation planner's PowerPoint, or that might be too long.
I mean, we're certainly going to have to do that. I guess we can get started on that. Unless we're really close. 1 minute away. All right, we'll just hold for a minute. Or so. Or so. Come on, Mr. Kokobo. No pressure. Mr. Steele, how'd your oral argument go this morning?
The argument was good, but no one remembers the argument, so we'll see what the opinion is.
Okay.
But it was actually a fascinating.
Yeah, sure. I mean, we might as well fill our time some way.
So it's in this courthouse. It says indictment on the cover. Second page has, typical indictment things, waives formal reading, etc. Third page has the grand jurors in Fulton County names. Then count 1 through count 6. Former district attorney Paul Howard does hereby charge the appellee with murder. Goes like that. So I didn't try the case. I did the appeal. The Honorable Judge Newkirk granted the motion for new trial, finding no jurisdiction because it was an accusation. So the Supreme Court was very lively.
Interesting.
It was an interesting case. And then it got so narrow. I was being asked, well, this is a novel issue. How would a lawyer know? You're saying it's deficient performance. How would a lawyer know? Yeah, I'm like, well, if I know, then anybody could know because I'm not that deep. So that's what I said. But it was fascinating. It was intellectually stimulating.
Interesting.
And thank you for letting me attend.
Absolutely.
So, Your Honor, this should have, if I'm using
Okay.
time space, please correct me somebody, but this is 50. I just want to know.
This is October 12th.
No, it's October 6th.
We spent all that time on the wrong interview. All right, well, maybe we can turn to the PowerPoint issue and at least start making our way through that are we ready now on the right one? Okay. So we want October 6th, is that right? Okay. Lawyers and tech, they just don't mix.
I hate to defend Mr. Kokomo here, but this is a lawyer issue, not a AV issue at this point.
Okay. So, Ms. Love, I know you said the state's timestamps were somewhat off, but can you get close? Maybe maybe we just go that way, since this seems to be taking longer than we had anticipated. The defense thinks they've got it, and the state thinks they've got it. So the defense has got it. All right, let's do it. Yes.
Just to avoid the inevitable confusion, the numbers, the times that we are giving is based on the MP4 that was made from the evidence reviewer. Okay. So, and we can figure out how to convert that. But the 50 minutes, for instance, is not going to be 50 minutes on evidence reviewer.
Okay.
Correct?
All right. Well, thankfully, we've got the kind of general subject matter listed as well, so that'll help us.
Do you want this marked? I assume we have to have this marked somehow. We can put it on a thumb drive.
What we're playing now?
Yeah, but in case God forbid there's an appeal, do you want just to know what we were looking at since we're saying 50, and we could do that?
Sure. Yeah, that's probably the easiest way to do it. So I guess this is the hearing on Mr. Williams' Bruton motion.
Can we call the exhibit that?
Yeah.
We'll give it to Ms. Winfrey if the state wants to see it, that exhibit.
Yes. So this will just be Defense Exhibit 1 to the Williams Bruton motion concerning Mr. Kendrick's statements.
And we'll have that thumb drive today.
Thank you.
No, thank you.
Like, I think of other people you associate with. Probably. Anybody you can think of? Oh, man, of course, that ain't no question, but that ain't, like, that's on some whole other shit. Like, that's like my rep pump. Like, we do shows, he help me out. You feel me? Like, he bring me on to his show, just help me, just stay above flow.
The first one was 52.
Your Honor, we're going to start at 49 minutes.
Okay.
And it should be Detective Gaither saying,
me just a little bit more general idea of what they're talking about at this point in time.
Okay.
Yes.
Detective Dennis is in here. Detective Gaither's in here. Detective Gaither's a female. Detective Dennis is a male. And the gentleman in custody is Mr. Kendrick.
Yeah.
And Detective Dennis at 4841 is bringing up that Mr. Arnold, he's a co-indictee, pled guilty. He also goes by Duke. He indicates the word Duke. Regarding the issue where Mr. Kendrick was tased, he was actually chased by police and tased.
Okay.
And Mr. Kendrick then mentions Duke or Mr. Arnold about the involvement in that. I didn't challenge that because I didn't think that's a root issue. And then Detective Gaither talks about Duke, and then going right into whether Thug is a reason that people went after them, meaning that there was this
Why, whatever that incident was, occurred. Okay.
So, to me, I'm doing, I think, what the court wants, but this will never come up on a question answer because no one's going to say to Detective Gaither, I would hope.
Your name, your email, your phone number, your address, the address of your friends, and your interesting online searches. Your data is leaking. Protect your online privacy with Surfshark.
Mr. Steele would not mind just letting that part play from 49 so that we could.
Throw them on the bus, but them, there's 40 over here. When I got tased on Bankhead, over here. When I got on Collins Boulevard, that was, man, I was leaving my little boy from Warzone, so I had that. He was in the car. You're like, man, y'all see all this shit going on. You got, it was to me, I try to keep one, then with that one, because it's like, yeah, it should go down anytime. Like, man, he been on some hang, jealousy. So why they coming at, I ain't talking about Duke, I ain't talking about the mother folks you roll, why they coming at you? They thinking like, I'm bad at it. They think I think I'm bad. Because I used to carry myself. Like, I see because of other people you associate with. Probably. Anybody you can think of? Oh, man, of course, that ain't no question, but it ain't, like, that's on some whole other shit. Like, that's like my rep punk. Like, we do shows, he help me out. You feel me? Like, he bring me on to his shows, just help me, just sell ball flow. I don't know why, would you feel like I took your part, your spot? A lot of people feel like, Bloody J, a lot of people feel like I took their spot. You know what I'm saying? But it's not, I don't get around on niggas, try to take no niggas. I'm a grown man. I got whatever I got going on. We was just spot. Yeah, he was grown, bro. Got spot. We grown ass men. Who the hell are you, man? But then when somebody had to tell me, like, bro, you know these folks right feel like you take their spot. Right. I had to think about it, look at it from other people's perspective. Okay, that may be what it is. Yeah, but everybody.
Okay. So, Your Honor, there's no part that I hear Mr. Williams' name mentioned in there. I didn't hear Thug or Mr. Williams' name mentioned, so I don't.
Okay, well, let's just ask it this way. Do you have any intention of who's this coming in through?
There would be either Detective Thorpe, probably Detective Thorpe later on.
Is he even in this interview?
He's right there in front of you. To the left.
Oh, okay. I thought you had said Dennis and Gaither.
Dennis and Gaither are sitting in front of Mr. Kendrick. And Detective Thorpe is to his
also
right.
In there.
He
Okay,
is.
all right.
There are three.
So, I mean, you're not going to ask Detective Thorpe if Gaither asked if Williams was a reason why.
No.
Okay, so that would be one then. This example would be one where you could say, we don't intend to ask that anyway.
Okay, so we do not intend to elicit or ask whether Defendant Williams was.
All right, well, let's
whatever
circumvent spending the 5 minutes listening to it if you know you're not going to use it anyway, okay? That would be super helpful. Okay, next.
But so when, again, this is one of those them, us, we, them situations. It is simply not one of those situations where we would be saying, you know, are they coming after y'all because of Thug? Are they coming after you because of we wouldn't be eliciting anything about another defendant. But if Mr. Kendrick is talking about a us and a them, like he is in this circumstance, they want to take my spot, things like that, then we would be putting that in. The reason I was saying we're looking at it in terms of Bruton is because if he's not talking about a defendant and he's not saying that person's name and inculpating him, then it's something that we will likely use. If there's a point at which I know that I'm just not going to even touch it, I'll do as the court has instructed, though. If, you know, and say, no, I wasn't even going to ask that anyway. It doesn't do us any good.
Okay, so then what I hear you saying is that while you're not going to elicit that somebody asked if Mr. Williams or Thug might be a reason people are after them, you would maybe ask about some part of Mr. Kendrick's answer there, which said something about they, whoever they is, wanting to take my spot.
Yes.
Okay.
And that we contend is not Bruton.
That would not be Bruton. Okay. Next.
5239, and it should be Detective Dennis speaking. And he talks about Mr. Shannon Stillwell. He calls him Shannon.
Okay. And then you know, you wouldn't be able to mention Mr. Stillwell. Is there some part of this little bit? Go ahead.
I'm sorry.
Go ahead.
So he does not say that Mr. Stillwell bought the gun. He does not say anything that directly inculpates Mr. Stillwell. And my understanding is that Bruton does not prohibit the mentioning of...
All right, let me just hear it. I see this is the way it's going to go.
Playing from 5214.
And this is before buying the gun for what? What are we talking about here?
Oh, I'm sorry.
Anybody?
So one of he was stopped with a gun in October and one on January 28th, and they're talking about the guns that he had in those situations. January 28th and October 1st of 2015.
All right, and these are overt acts, or are they?
Yes. One is an intrinsic, January 28th.
Okay. All right, go ahead.
Why don't you breathe? True. But I be like, my first man like, fuck these big ass guns. But the second man like, I got to ride with something that's gonna protect myself. You feel like, right? How long have you had it? Like a couple days. Yeah.
Did you buy it after you spoke with Shannon?
I bought like before all this stuff happened.
I don't think that's. You can stop it. That seems pretty inculpatory of another defendant. Did you buy it after you talked to this person? As if no.
Okay.
Don't
leave that part out.
That
Got
one's
it.
out. Okay. Next.
It's right after that, but it's the same thing, Your Honor. Okay. Now it's Mr. Kendrick speaking about Mr. Stillwell. He includes Mr. Arnold as well to clarify what Detective Dennis just said about the gun. And that's at 5251.
Just to go back just a bit, he wasn't saying that Shannon told him to buy the gun. He was orienting Mr. Kendrick as to a conversation with Shannon. It wasn't saying that Shannon tell you to buy the gun. So it wasn't inculpating Shannon. I think that it may be helpful to hear before the part that they started on. It's like, did you talk to Miss Hilton? Yes. Did you buy the gun after you talked to Miss Hilton? Yes. But it has nothing to do with Miss Hilton told me to buy the gun.
Well, I mean, unless you can make it really clear that all that's doing is orienting him in time to something, but to have the question be in front of the jury that is, okay, you had this gun that you got in trouble for. Did you buy it after you talked to one of your co-defendants? Okay. Just seems too brutal-ish to me to permit this. And the state ought to want to try a clean case.
We do.
So
that's fine. We don't have to keep that in. Okay.
Go ahead. Next one.
This is 5250. You should back it up. This should be Mr. Kendrick. Mr. Kendrick bringing up Mr. Stillwell and Mr. Arnold about clarifying the answer that you were just discussing, although I think that's out, actually. So it's really 54 minutes we can go to, and that should be Mr. Kendrick. And he mentions Mr. Copeland, Duke, or Mr. Arnold, and Rich Homie Kwan, Mr. Lamar, and Mr. Stillwell. And he doesn't want to be associated with them. So we ask that Mr. Stillwell's name be redacted.
All right, well, I'll listen to it. Give me enough so that I can hear the context of why he said it.
See, that's why I be a man today. That's why I fuck up it. I be on more of a defense. It's like, if I wouldn't got that call, I would stay asleep. Right. It show you that though, like I'm so much of a good partner and friend, that way it hurt me. You know what I'm saying? Yeah. Well, I mean shit. This like it. And he get to go with it, like he get out there before me and all that and look at shit. Yes. So it's like, God damn, bro. Like it make me look at my loyalty and my friendship like you can't be bending your backward for a lot of these niggas. And that's why I feel back from the people we all just saying. Right. Which was my original crew member, like the people I was rocking with. That's why I feel back. So it's like I ain't get 100% from none of them. So it's like y'all ain't gonna be getting my 100%.
Who are you speaking of when you said that?
From Shannon, whoever. Dude, it's just everybody here. Going, like everybody, cause all of us have been together at once. Like all of us in rock, joke on all of us. So it's like once I figured out, and it was like, I don't want no part of it. You feel like? So it's like, what are you gonna?
All right, I mean, he says something about being regular crew members and not getting 100% from them and then saying them by name. I think that's a brutal issue. So, would you understand if you do intend to ask about this?
Not having to mention Shannon's name.
Make your mark as an expert. Stand out among the professionals. Create your .pro web address at name.com/pro.
Well, I might not even need to hear that one.
Your Honor, just before we go to that one, I just want to make clear Mr. Stillwell's name is the only one that is on trial that Mr. Kendrick mentions at the last little clip. Mr. Copeland, Mr. Arnold, Mr. Lamar, they have those names listed in their motion. I'm sure they don't intend that. That is a brutal violation. They're not on trial. So we would believe that it's okay to mention those names. But
Does the defense want to be heard at all on that, or what your position is on that?
I'm still researching, Your Honor,
How did y'all redact this indictment?
In
We've
what
been
way?
asking for that to
You
be
say
redacted.
redacted.
It's been denied.
Well, what got read to the jury at the beginning?
Everything except, I think, overt act 26 maybe was redacted, maybe 2 overt acts, but I have to check my notes on which ones. Otherwise, the entirety of the indictment was read to the jury.
Including the names of all of the co-defendants that are not on trial?
Yes, every one of them.
Your Honor, at the time, they were on trial. So severance happened during the course. So when we first had the indictment read, it was more than just the 6 that are
Was it
presently in the
all,
court.
whatever, 19 of them?
With the exception of maybe
Yeah.
the ones that hadn't yet been apprehended.
Yeah, so everyone was here.
At that point in time was on trial together?
Yeah.
Okay. I mean, it's been a long time.
Except for the ones that pled and a few that were not apprehended, yes.
Well, ones that had not had attorney.
Huh.
And some that had not been apprehended. So,
So-
there were, I think, 6 that weren't.
So Mr. Kitchens is indicted. He pled guilty around Thanksgiving of 2023. The jury first came upon us January 4th, 2023. So I made a mistake. Mr. Kitchens pled guilty under Alford in November of 2022. Mr. Arnold did the same. Mr. Sumlin did the same. Mr. Stevens did the same. Mr. Murphy did the same. Mr. Sledge did the same. Thank you. And I should look at the indictment for more. Mr. Garlington never had a lawyer, so he was already removed. Mr. Wani Lee pled guilty around the same time.
Who was that last one?
Mr. Wani Lee, L-E-E,
Oh, okay.
and Wani is W-U-N-N-I-E.
Yeah.
So, the stage, I'm sure it was a miscalculation, but these people were all included in everything in the indictment, but were not on trial before the veneer panel was first put upon us. And if I left somebody out, Mr. Eppinger was with us for jury selection. Then he got, something happened and he got removed after that. So he was in a different category. Mr. Blaylock pled guilty after the veneer panel.
Mr. Blaylock has not pled guilty. Mr. Blaylock was severed as well. So I believe I said everyone who had not pled and not been arrested was present. So there were individuals who were severed subsequently. So Mr. Blaylock was severed after the jury was impaneled.
That's true.
Mr. Dorsey was severed. Ms. Eppinger was severed. Mr. Mender was severed after the jury was impaneled.
Right. So the people I mentioned pled before the veneer panel was read the indictment. And I'll look at the indictment. There may be a couple more, but that's my memory. Mr. Winfrey was severed before we did, he was apprehended, I think, afterwards. So name was read to the jury, but he was never with us.
So if they had not pled and they had been arrested, they were all on trial. And so obviously those names were read. Were the names of the people who hadn't been arrested and hadn't pled been read? Were they read? So everybody's name was read. Okay. And I don't know if there were any counts of was every count of the indictment read? Even if it was only against somebody who had already pled?
Yes, Your Honor, because I think it was pre-recorded, and so everything was read. To answer your question, yes.
Okay. Was there any objection to that? Okay.
When the court says
Can we get clarity? Because on the yes.
I mean, honestly, at this point, that'll be a motion for new trial issue if it gets to that stage. I'm just trying to figure out what this jury has heard. Y'all would not intend to send out an unredacted indictment if we get to deliberation, right?
We had actually talked about redacting the indictment. I think we were actually.
Okay. All right. Well, good. Because I don't think an unredacted one should go out. All right. Anyway, back to what we were doing. So I mean, the question was with regard to people who are not on trial here now with these 6, is there any kind of objection to those people being mentioned?
Yes, so I'm finding Bruton under conspiracy.
Yeah.
And directly impact, and that's what I have to get to the court.
Okay. All right. Well, why don't we circle back on this one then? Because that, obviously what the law is will determine what the answer is. So it's definitely out with regard to naming anybody on trial here other than Mr. Kendrick, but with regard to anybody else, TBD, depending upon what the law says about that.
Yes, Your Honor.
Okay. So y'all get the next one lined up and let me jot myself a note on that. Okay, I'm ready for the next one.
So Mr. Kokomo will orient us earlier on what's going on here, Your Honor. Detective Gaither is asking, this is at 10055. So then after Woody got jumped, you know who Woody is? Who shot up the studio TIG? Mr. Kendrick states, I don't know. Mr. Gaither said, I heard your crew shot up TIG after Woody got jumped on. There's a discussion of where is TIG. Then Detective Gaither says Metropolitan, like over there by Thug Studio. Mr. Kendrick asks, where's Thug Studio at? And then they talk about that location. They talk about YF and Lucy. And then at 103, Detective Dennis say, you still on Bloody J when he got locked up, and it goes on to that event. And
so is this just because Mr. Williams' studio is mentioned to orient people to where things are?
Well, at 102, it's just about the studio, but I was targeting the Rico conspiracy. So I was targeting the, this is where, actually, I'll withdraw that because it does not mention, I apologize.
All right, no problem.
All right, number 105:19, 1:05:19, Detective Dennis mentions Mr. Williams' quote-unquote girl regarding a shooting, supposed shooting of that event. And that is it's 104:32. Detective Dennis states, didn't you catch them down bad? That's a reference to Mr. Kendrick's music. They laugh. It's a verse in a song. And then Detective Dennis says, so who shot up Thug's Girls event? Or did you hear about that? and Mr. Kendrick says, I don't know, that's my first time hearing about it, so I wanted that excluded.
What's the response?
Doesn't, number one, evidence of that has already come in through Dennis, but number two, that in no way inculpates Mr. Williams in anything because it references
His
him as
girl being a victim.
right.
Okay. Yeah, I mean, I don't think that's a brutal issue.
So my issue with that then would fall back on a different issue then. What's the point? The answer is, I don't know anything about it, so we're now
Right.
just using
So
the
now
question.
we have a relevance objection. No, we'll do them all at the same time, so we don't.
I don't have a problem not having him since he doesn't know anything about it, keeping that part out. He said, I don't know
Okay.
about that. I don't have any problem keeping
All
that
right,
part out.
thank you.
Next is 108, 1:08:40. And this is the part you heard earlier that may be stipulated to. Mr. Kendrick mentions Mr. Stillwell telling detectives who, quote unquote, they.
Right, and on that one, what would be permissible to ask about is that at around this time,
They were beefing with
our crew were beefing with
them.
the other group, but not anything about the rumors or anything like that. So that one I think is clear. Okay. Next one.
The next, Your Honor, will be it's really the same flow, but it's 108:51, so it's only 11 seconds later. And Mr. Kendrick, mentions Mr. Copeland sharing that he was tied up with Mr. Stillwell and specifically, and then Mr. Kendrick identifies a photograph 8 seconds later of Mr. Stillwell. Then Detective Thorpe mentions Mr. Stillwell and clarifies that the word is that Mr. Stillwell and Mr. Copeland killed Mr. Thomas. And Mr. Kendrick speaks to that.
We don't have any intent to bring that out.
Any of that?
Right.
Okay.
Okay. The next is 1:11:30. And it's Detective Gaither mentioning that Mr. Stillwell is the person that whoever everyone is, brings up related to the murder of Mr. Thomas.
And this falls in with what we initially said, that when they were talking about who they said killed Donovan and bringing up Mr. Stillwell's name, we have no intention of doing any of that.
Okay.
Okay. The next one is 1:13:44. And it's Detective Thorpe, I believe.
All right.
And he says, people talk to you in the city, all put you four involved in the murder of some kind. Mr. Kendrick denies it, says they are lying. Detective Gaither says, you think anybody going to tell the same story? Mr. Kendrick asked, what did they tell? Detective Gaither said, I heard you was in the car. Mr. Kendrick said, what car? Detective Gaither said, the Infinity rental from Thug. And then Mr. Kendrick said, no, I wasn't. Check whatever, my phone, whatever you want to check. And then Detective Gaither says, we did. It was said a whole lot. And then they go off on that. So I was objecting to Mr. Williams or Thug being mentioned.
Your Honor, that whole, all of that colloquy is part and parcel of them talking about who people said killed Donovan Thomas. Anytime we're talking about any of these defendants being rumored to have killed Donovan Thomas, the state has no plans to get near that part. Now, Mr. Kendrick denying that he was in a rental by Mr. Williams, we would proffer that type of information because it would not inculpate Mr. Williams.
Yeah, I agree with that. I mean, I think it's already in evidence that Mr. Williams rented an Infinity, right?
Yes.
And up for dispute whether that was involved or not.
Right.
But saying, the Infinity that he rented doesn't inculpate him directly. So that I would be okay with. I mean, I don't think there's a Bruton violation if you ask or get an answer that talks about the Infinity that Mr. Williams rented or that Thug rented. Okay.
The next, and I'm skipping based upon what the state just said about that whole colloquy.
Okay.
So it would go to 1:18:31, and that's after 1:17:35. Mr. Kendrick reaffirms he has nothing to do with the murder of Mr. Thomas, and then at 1:18:25, Detective Gaither asks about NARD, N-A-R-D, and DUWOP, D-U-W-O-P, where they are now. And Mr. Kendrick explains he's almost questionably locked up. And then the target event, Your Honor, is Detective Gaither asked from January 10th until today, how many times do you think Shannon been locked up? We'd like that redacted.
My apologies for leaving that out. I would not put that in.
Okay.
Okay. The next one.
The part about Mr. Stillwell being locked up, the other part, yeah.
Yeah.
The next one is 1:21:25, Your Honor. And at that point, Mr. Kendrick had shared with the detectives that he went to Miami after January 10th. Detective Dennis asked who all went. The answer by Mr. Kendrick is everybody. Detective Gaither said, who is everybody? And then Mr. Kendrick starts naming little d, everybody, and then Detective Dennis points to the photograph of Shannon Stillwell. Mr. Kendrick says yes. He says yeah, actually, Y-E-A-H.
Okay.
So that's the part that we were taking out, the picture and the pointing.
Well,
this is just him saying, here's who all went to Miami.
Yes. Immediately after
doesn't
the
inculpate anybody directly in anything. It might be argued to be a part of the evidence, but that wouldn't be a Bruton violation.
Okay. We're just raising objections then, if that's okay. When I say okay, I'm not waiving anything.
I understand.
Okay, thank you. Okay. But thank you.
Yeah.
All right, the next one is going to be included. Did Thug went? Was a question by Detective Gaither. The answer is yes or yeah, so I assume it's the same ruling.
Yeah.
The next one, Your Honor, would be and I assume it's covered by your ruling. Detective Gaither asked Mr. Kendrick how long did Mr. Williams stay in Miami, so I'm assuming it's the same ruling. So I'm moving on from that one.
Okay. So the one about before that 1.23.06 about Mr. Stillwell getting calls.
Yes, I should have included. I skipped that one accidentally.
And what'd you say, Ms. Love?
I'll let the court decide on that. I'll let the court hear that because I didn't count that as inculpating because everybody was, what he's contending is that people were calling, but I'll have to hear that part again.
Okay, let's just hear that part because I'm not sure what it says. And
Start at about 1:22:40 if you can, Mr. Kokomo. And what it should say is it should be Detective Dennis asking about what conversation was like on the way down to Miami. Detective Dennis specifically, I believe, said, Your Honor, the ride down had to be some type of, just like you just said, like when Duke got jumped on, people started hitting your line, so y'all started to get worried, and Mr. Kendrick said, it wasn't on my conscience. And then in there, they talk about Mr. Stillwell was probably getting calls.
all right, let's just see.
One of conversation.
Everybody just sitting there like,
Yeah, I was just stoned with it. Like I get my own strong heart.
right. But what I'm saying is the ride down had to be some type of.
I don't know. I ain't
Because
know
it's
anything.
just like you just said, when Duke got jumped on, people start hitting your line.
Yeah.
What's going down? So y'all had to start getting word that these names are out there as nuts just got killed.
Yeah, but it's like it went. Yeah, they probably got getting like calls and saying shit like they think it was them, but it wasn't on my country or folk wasn't calling me. Like
have any problem taking that whole last 2 or 3 sentences out. Like, they were probably getting calls thinking it was them, and then Dennis saying it was your people, you guilty by association. Like that, those 3 or 4 lines, we don't have any problem coming out.
All right, does that cover it?
Yeah, Mr. Kendrick, I'm sure it covers it. Specifically said Shannon, so I'm assuming that's it covered it too.
Let's make sure.
Yes.
Okay.
Yes.
Okay.
Excuse me, Your Honor. Can we take 5 minutes before we continue down the list?
Sure. Yeah, that's fine. Let's take a quick break.
Thank you.
Sure.
too. I'm tripping. What happened to we won't go my live.
Right there. I'm not saying that to demonstrate because basically I was saying that we weren't having a conversation.
backwards shot. I thought that side was the prosecution, the other side was the defense. But those two females over the prosecution. Well, both the witnesses, right?
No, you can't come up to me and say, "Can I send the no, sure. It's not, no, it's not on there. It's not on there. Out here, it becomes best. That's not got it back down. They had it back. So, and they had them down. But the other they got them back down. It's right there. So it's not like it's like it's right there.
gonna be on his bed.
I remember her. Yes. But I some of the I don't remember what. But I keep trying to remember. Yes. Yes. Well, but what you just asked, I understand so I'm sorry, no, I don't remember saying that. You're not last seen them. right now. That's what I'm saying. I saw when I walked over to her. Well, I'm walking over backwards, but that's pretty nice. That's pretty nice. Oh, yeah. Actually, I would want to be done with it. I want that way. Because what's wrong? I'm really else not in back. But else not in back. Yes. I'm late. But else not in Thought about what? I started to get more, but something, I couldn't really because I'm actually wrong. And so that's what I issue. What I do. Oh no, I don't know what he was saying. All I know he was trying to get back up. Get him on. Right here, just like this, right there.
My fault, Chad. My fault, Chad. I've just been on the game all that.
Whatever the co-conspirator statements are, whether they're from the wiretap or a different source, do they have them all?
Yes.
And have they been identified as potential co-conspirator statements?
Yes, Your
Okay.
Honor, for the most part. Just 1 second, I'm going to confirm one thing.
Okay.
Sprinkles folder have potential co-conspirator statements in them. We don't have them extracted out. We just have the ones in there that we intend to use.
All right. I mean, y'all ought to be aware that if there are jail calls by co-defendants, that those might contain co-conspirator statements. So that would be the only thing that might not be specifically identified. Is that okay?
My expectations are correct. In line with the courts, the state is going to specifically identify those alleged co-conspirator statements. Correct. I mean, there's thousands of jail calls from probably, I'm underestimating, thousands, yes. So we would need to know what statements, when they're made, between whom and whom, if the state, because we would like to litigate these beforehand. I know the court would too.
We put in the Mike Sprinkle bucket the jail calls that we're using.
All right. So jail calls y'all intend to use are all in the Mike Sprinkle folder?
The ones that we have identified that we intend to use, and those are the ones the court told us to use.
Okay. So the universe has been narrowed, hopefully substantially. I haven't looked to see how big the Mike Sprinkle folder is, but
If it's the same one that I think they're talking about, it's about 200 calls.
okay, well,
15 minutes each. So that's 50 hours of.
okay. Which I presume is one of the reasons y'all said let's hold off on dealing with what's in the Mike Sprinkle folders. So as the state, look here, as the state is itself going through the Mike Sprinkle bucket in further detail and identifies for itself the specific co-conspirator statements that it intends to introduce, please identify those as well to the defense. As soon as you know, let them know.
So we have 14 in the Shannon Stillwell folder. We could start there since that is his client, Mr. Shart's client, that we could actually review.
Okay. Let me get some clarity. So in the Stillwell file of jail calls, are those already identified? Just here are the co-conspirator statements, or are they just like, here's a 15-minute call, here's a 5-minute call? All right, and do you know what portions of those calls yeah. All right, but whether you've broken them out or not, do you know what those are? Okay, so if you can, that's what I'm saying, is once you know, here's call from January 2nd, that is 15 minutes. I'm going to use minute 2.5 to 2.9. That's the part I care about. When you know that, let the defense know that. Okay, so if you know that already, instead of us sorting it out here live, give that, one of y'all sit there and type it up and send it over. They can look at it tonight. We can deal with it tomorrow. Okay? And similarly, do that for everything else. All right?
So that it sounds like the most productive thing to move to next, unless somebody else has a different idea, I'm willing to listen, is to just open back up, the witness folders and move on to whomever the next witness other than Mike Sprinkle is going to be, and go through that proposed evidence for any kind of evidentiary issues we can hash out now. All right, let's do that. Dropbox link we were working from yesterday, that is the Dropbox link of the first 30 witnesses. So if everybody can find that again. It's not easy to find it because sometimes instead of y'all giving each a new reline to your email, you just tag on to one that already existed.
The 2024 email from Mr. Atkins.
I'm pretty sure that's right?
Yes, Your Honor. It says 30 witnesses, and then it has 8 August 24 in parentheses.
All right, y'all let me know when everybody's there. Is everybody there now? Almost. All right.
I'm waiting on y'all to tell me if you're there. All right, is everybody there? Has everybody got the 1 through 30 Dropbox link up?
We have the full Kendra has the full.
Okay,
I don't know about that.
great. Thank you. I've heard from 2 of 6. Y'all ready? Okay, 3. Stay ready. Okay. Mr. Matthews, you got it? All right. Who else? Are you ready, Mr.
You are the future. Pursue tech careers with the DeVry Scholars Program. Advance your ambition.
Sure. All right, so the question on the floor was whether there's anything we need to look at with regard to any of those 3 cell company custodians.
As to those records, we can just bring in the records themselves and save that time, but.
That would be nice. How about it? Miss Westmoreland doesn't want to. Okay, no, that's not going to happen. All right. Well, so we'll have 3 more witnesses, but with regard to the evidence within those, any kind of motion and limine type issues we need to deal with on those. Thank you. Okay. Then James Burney is the next witness listed. Do we need to look at anything with him?
Expert from the FBI phone records.
Okay.
This is one that I voiced an objection to repeating the testimony because Agent Racy talked about for a long time where the phones were located. The prosecution stated that based upon questions by some of the lawyers for the accused, that they needed to do something else. I'm still holding my objection because I believe it's going to be, I looked at the report, it's the same thing, maybe a little nicer because it was done nicer. And I don't mean to insult Detective Racy. He didn't have like a chart, but I just believe that it's the same. And by when the same, I'm talking about the April 26, 2015 shooting of the bus, tour bus of Mr. Carter, a performer known as Lil Wayne. Otherwise, no, I don't have any issues with with Agent Burney.
All right.
Your Honor.
Yeah.
Per the court's guidance, this April 26, 2015, we are not discussing Special Agent Bernie. This, when he speaks on specifically the January 10th, 2015 murder of Donovan Thomas, that's the only cell records he's going to be testifying to right now. He does analyzes cell site tower data for other acts in this case and counts. So he's one of those witnesses that testifies multiple times when that act comes up. So what Mr. Steele, specifically the April 26, 2015, we will not be
calling him for that purpose.
Correct, Your Honor.
Okay, but so when he's called here, it'll just be for the January 10th,
2015.
2015. Okay. Anybody else? Nope. I hear. All right. Not hearing, but I'm seeing nods. No. Okay. All right. Great. We'll move on to the next witness folder. All right. GBI Firearms Voss in Wheatsel or Whitesell. Any issues on those?
My understanding is that these witnesses listed are the witnesses that are going to be called. Is that correct?
Mr. Voss is not going to be called pursuant to the information we sent to you all a few weeks, 2 weeks ago maybe. Mr. Whitesell is going to be called. I believe there's on the email that we sent to the court and to counsel for the defense, the peer reviewer and the verifier for David Voss would be called rather than Mr. Voss.
All right, and is that peer reviewer / verifier Whitesell?
No, it's actually Vanna Kelly.
Vanna Kelly? Okay.
Yes.
Is that Ms. Kelly?
Yes.
Okay. Does she have her own reports?
No. Actually, what we're doing is getting the data, the underlying data. So she verified these. And so any underlying data that she has that they may want, just in case they want it, we have to get that for them.
Okay.
It's unclear to me the work that I guess Miss Kelly did on this case. It's unclear to me what the work she did was, but obviously, Your Honor, there's potential for confrontation clause issues involving Miss Kelly testifying to the results.
All right. I would presume, typically when they testify, they say, I ran all the tests myself.
Right.
And obviously, if they didn't, then that's going to be problematic.
Right, it would be. She looked at the evidence under the microscope herself and came to the same conclusion.
So she will be testifying to her own conclusions, not to his conclusions.
Right. Hers match his, and he was the one that put out the report. She verified his by going through and looking at that physical evidence under the microscope.
Okay, but her conclusions will be based upon her own testing and observations.
And to my understanding, we don't have a report from Miss Kelly. Maybe she's not writing a report, I don't know, but I'm bringing it to the court's attention and state's attention that my understanding is we don't have a report from Miss Kelly. So if one was generated, we need that report.
But I was just saying she did not generate a report, but her underlying notes and data, that is what we said we would get for them because her conclusions.
Okay. She doesn't have a separate report, but she's got notes and data, and y'all will be provided that when? Did y'all have that yet from her?
No, I spoke with the GBI last week, and I'll follow up this week.
Okay. Let them know that this is an ongoing trial, and they need to
I will.
Provide it ASAP, and then provide that over ASAP to the defense. Okay.
Also, with respect to Agent Bernie, if we could swing back to that.
Sure.
He will likely not be testifying until the end of September, in which case any time needed, we believe, for the defense to review his analysis of the April 26th incident would have, we believe, that rather than having him testify 2 different dates for those, for the incident here and the incident in April, would be obviated by the fact that he's going to not be testifying until the end of September, as opposed to having him testify at the end of September and then come back 2 weeks into October. So I guess we're asking for clarification on whether or not he can just be brought in, whether that is not enough time for them to look at the additional reports that they were given last week, or was it last week? Week before last, right.
Okay, let's find out.
The issue isn't the amount of time that we had to review Agent Bernie's report about the April 28th incident. The issue is that Detective Racy already testified concerning the movements of cell phones. And and the state seems to be justifying this on some sort of cross-examination. Really, the allegation is that Mr. Winfrey was moving with the bus, and the allegation, which I strenuously deny, is that Mr. Stillwell was moving with the bus. Mr. Stillwell didn't have a cell phone, so I'm not sure what the point of any of this is in the first place, much less hearing it for a second time.
Okay.
Yes, Your Honor. During cross-examination, they challenged Detective Racy that he was not an expert, and therefore that he could not testify as to what side of the tower that the phone was on, only the tower placement.
Okay.
And because it was specific as to what side of the tower it was on, that's why we asked Agent Bernie to do the analysis based on their cross-examination. I think specifically Mr. Weinstein objected that because Racy was not an expert, he could not testify to what side of the tower that the phone was actually on, which is important given the movements of where the phones were at particular times the evening or the morning of April 26th. So that's why it became relevant for us to get Agent Bernie to do the analysis, because he can talk specifically about what side of the towers the phone was on at a particular time.
All right, which phone?
This was, it was Mr. Winfrey's phone, also the phone that we're identifying as Dolly White or Max's phone. There may be about 3 or 4 other phones that I can't just recall off of the top of my head, but all these individuals were ascended upon the compound, which is where they started, and followed the bus all the way up to the hotel, and then went down to the studio after.
Okay. And does anybody identify a phone as one belonging to any of these co-defendants?
Shorty close to her heartbeat going off there, buddy. Shit crazy.
I can't get this to go back.
Yeah, when I jump on the book, shit gets shaking, buddy. You hear me?
Hang on.
Sorry.
All right, go ahead.
Only phone that he analyzed from these defendants here will be Mr. Williams' phone, because Mr. Williams' phone, we had that plotted that he was in Baton Rouge at the time of this, which was consistent with what some of the testimony.
Okay, so tell me why we need to hear from and we may, but tell me why we need to hear from Mr. Burney about the side of the tower that other people not on trial hear.
Because it's a part of the conspiracy, and it corroborates what other people said about the movement and where everyone was at the time, and because they challenged it so much that we can only say that this is where the tower was, but with no more information.
Okay, and was there testimony, whether there were cell phones for these people or not, was there testimony that X, Y, or Z co-defendant on trial now was with this crowd?
We believe that some testimony will come in soon that Shannon Stillwell, although we did not have his cell phone,
right,
that Shannon Stillwell was present at the time of the, it has not come in yet.
Okay, all right. So then, with regard to that incident, Mr. Burney's testimony should be on the narrow issue of I analyzed these cell phones, and I can say that it was this side of the cell tower. But we won't need, I would think, to go through, I don't know, but did Detective Gracie give sort of the overview of here's how we know all of this anyway, and here's what, you know.
Correct.
Okay, so we won't have to go through all of that again. You can just cut to the chase of, yeah, I know all of that stuff too, and here's what else.
This nigga is crazy,
Yes.
though,
Okay.
man. What did I just miss, though, baby?
That works.
Like, give me
All right,
the breakdown,
moving back
because I can't wait for him to come back on the phone. Because I'm gonna talk shit.
Question?
Yeah.
Does that exclude then Mr. Williams, who's in another state at the time? We're not going to hear about that again.
I mean,
Am I correct?
are y'all going to bring that up again?
Because that
Yes,
was testified to.
In the sense that he received that document,
Oh, man,
and
King just shared that shit.
he
This is one
plotted that
viral.
as well. Yes, but we don't have to go into the details of it. But I think it's a part and parcel of what was happening that night
All right, hang
that
on.
they challenged.
Hang on. Did anybody from the defense challenge the legitimacy of Detective Gracie's conclusion that Mr. Williams' cell phone was in a whole other state?
I agreed with it.
Okay, then if there was no challenge to that, that shouldn't need to come up again. Right?
Can we ask him whether or not he plotted that phone? Because if he's going to talk about some of the records, we
I
think
told
it's
you whenever he
important that
say
these jurors know
hold
that
on or some shit, I'm just gonna say it back to him.
Yeah, I mean, if it's like that can be like a one question.
Yes.
Yes, and it was in somewhere else entirely, which I would think, Mr. Steele, at least you would like. Okay. Well, that part certainly wouldn't. So you okay. All right. That is what I said. Okay, so back to the two firearms examiners who are going to be Kelly and Whitesell, where we can move on from that. Silence is yes here. Okay, so next is Officer Zaffa. Looks like, is this one of the crime scene techs?
He's the responding officer to the January 22nd, 2015 shooting at 1007 Hill Street that we talked about earlier.
Any issues with this?
And you're right. I think it's actually off.
Oh, here this bitch ass nigga go, guys. What's up with you, boy?
Okay, there's no change between those two.
Who's
Officer.
good, bro?
Okay, thanks. Any issues on those photos, images? Are y'all just looking at these now? Okay.
My concern is I don't have any statements from any witnesses. I have the officer responding, but we'll see the next witness that you have on your list. We'll see if there's any more information that we're supposed to get.
We have the police report, Your Honor, that we've provided, and then we provided, at least for this one incident, will be Miss Reed, which is the victim in the case, and so that is what we intend on introducing.
And is there a statement of the alleged victim? That's what I was.
The statements are reflected in the report to the extent that she gave on site.
I doubt if they can hear her. That y'all is gonna have to pull that mic back over.
Her statements are reflected and memorialized in the reports that were written and provided to the defense.
Okay.
Just so we're clear, my understanding is that the allegation is her home was shot up multiple times.
Yeah, the Whopper too.
And so we do not have any written statement or any taped statement by any detective, taken by any detective, given by this alleged victim. And so that's what we're asking about. We understand that statements may be memorialized in a report, but we are specifically asking about taped statements, written statements.
Your Honor, we'll double check, but the answer be no. Whatever her statements is contained with what she told the responding officer and he put in his report.
Okay. And this was way back before body cam was typical, so that wouldn't be unusual. All right. If y'all find something else, obviously provide it, but no, that to their best belief at this point, no, there's not anything. You have everything that there is. Okay, so I'm assuming that other than that concern, there aren't any issues with these pictures that are included, since I hadn't heard any objections directed to those. Is that fair? Okay.
Hell nah, nigga. I'm in the building.
Next is Sanders. I'm not sure what CS.
Or the ski. This nigga with his hat looking like he got a bad wig on over here, but you want here so bad. It's word of my baby. That's good.
Also, lots of pictures.
That's crazy, blah. I'm about to take a picture. Word of my baby. You like you want here so bad right now.
And documenting it.
And nigga said, nah, just give me a little bit right here. You know what I'm talking about? Just give me my shit right here. You know?
And then the report. Any issues?
Yo, he said my boy got the Tory implants. Yo!
All right, thank you. All right, moving on to Antrivia Smith. What is that, a video? Okay, any issue on that? Oops. It's a short video, so even if you're watching it for the first time now.
I was under the belief that they were going to introduce this video through Mr. Sledge, but
All right, hang on, and nobody can hear across the courtroom if we don't talk into the.
Let's keep this dialogue going, shall we?
Look at me. Does it appall you that I have somehow managed to make it on my own? I needed my friend, and you used me!
I hope you all enjoy feeling your flesh sear in the hell you've created.
Industry, streaming exclusively on Max.
Weekend plans?
Automating lead management 24/7 with Zapier.
With another man over a girl. I don't know YSL how that fit in, but
I think.
Okay, well, that may be, it probably will. And if it's presented that way, then y'all will have some good subject matter for your cross-examination.
That there's Mr. Sledge, since it was mentioned, Mr. Sledge said, oh no, it wasn't over a girl.
Okay.
We weren't beefing over a girl.
All right, well, they'll say whatever they're going to say, and y'all can examine accordingly. All right, Sharon Latner's. These would be the CAD reports, I assume. So we'll hold those for tomorrow. Does that work? Okay. And tomorrow, y'all can tell me what parts of, if any, of those y'all think might be excludable as hearsay without an exception. All right. We are moving now, at least theoretically, to a different overt act, I think, right? So now we've got crime scene tech Turner, and that folder is empty, at least for me. Do y'all have something in y'all's folders for that? They're empty for y'all too? Okay, well, maybe that was just a mistake. Is there supposed to be something in that folder?
I'm going to check. I think that we may have already.
All right, we'll come back to that one. Y'all check on that tonight.
And that may have been the ones that they told us that APD no longer existed. It may have been the ones that we identified and told the defense about. There were about 127.
From the hack from whenever
Yes,
that was?
we had asked them for the physical copies, if there were any, because they said that the digital copies did not exist.
Okay.
And so that, I think that those were, it was Turner. It was Turner's
Okay.
photos that were those photos that we were trying to
Those
get.
were lost in that several year ago hack, it sounds like. So that's why that's empty.
That's what the photo lab
Okay.
told us.
All right, moving to Jenkins. And these are just crime scene photos. Look pretty standard. Any objection on those that y'all anticipate? Okay. All right, Tyrone Dennis. All right, let's walk through it kind of one by one. All right, so the first thing is what's identified as States Exhibit 71, Act 78, and then the lyrics to Bad Boy. All right, what's our objection? And this is only if this hadn't already been litigated. If it has, it has.
Mr. Williams doesn't, these are not his writings.
Okay.
Somebody, Google, I was told Google, just put them down. I'm not telling you that they're wrong, but I'm certainly not telling you they're right. but it shouldn't come in this form. This is not how Mr. Williams made a song.
Okay.
So I would be objecting to the best evidence rule, and I don't know why. I don't know if the state is planning to hand it out as an exhibit to the jurors, flash it on a screen, but I don't believe that this is proper testimony. In addition to that, Detective Dennis, for him to claim here are lyrics and here's what they mean, I don't think he has any basis. I've asked him whether he,
Okay.
when he was qualified, whether he spoke with anybody with the lyrics, how he makes the lyrics. He has no idea. He's just a listener.
Okay.
So those are all but those are, I raised those objections previously when we were arguing.
Sorry, go ahead. And what?
And the court stated he made a preliminary finding, the prior court, that lyrics are admissions, confessions, co-conspirator statements, and if a proper foundation is laid, then he will decide later if they come into evidence. That's pretty much how it was.
All right. So the best evidence objection y'all might need to deal with.
Your Honor, we would be, as far as the displaying or the publishing of the song and the lyrics to the jury, we would likely be doing it through Mr. Williams' words as he speaks them, and we may have a accompanying, it can be typewritten, whatever, transcript of the lyrics, however it is that we intend to display it, but that we can also provide to the jury in terms of their ability to more easily hear
as
what is being said.
Demonstrative aid.
Yes, and as far as the objection as to the meaning behind certain words or lyrics, Detective Dennis would be talking based on his expertise in certain areas, particularly as a gang expert, as to certain meanings or certain language. But if there isn't, if there's a different interpretation or if someone else intends it a different way, then we would submit as the area for cross-examination or a different testimony from the person who's seen.
All right. Well, I think that with regard to something being used as a demonstrative aid, you need to make sure it is the correct transcription of what the lyrics actually are. It does not need to be pulled off of Google. I mean, if you want to pull it off of Google, you can, but it doesn't need to look like this. And please provide it to Mr. Steele and Mr. Adams beforehand so that if there are any disputes as to what the words actually are, those can be dealt with. And then I would permit Detective Dennis, if he's been qualified as a gang expert, to say, in my expertise, this might mean XYZ. Obviously, doesn't mean that is what it means, but that's his opinion of it, which the jury can accept or not accept. It's up to them. And of course, he can be crossed as to how on earth he might know that, and, all sorts of good things, I imagine.
I guess it depends on the lyric, but, intention can never be discussed by an expert, a person's intention, because it's not beyond the
Agreed. I mean, yeah, I wouldn't let him say, here's what Mr. Williams meant when he wrote this lyric. Just this lyric in common gang parlance, we believe means whatever. Okay. All right. All right, the next is Exhibit 72. It's basically the same thing. It's just another set of lyrics. Okay.
Your Honor, one other thing when we're talking about these lyrics that I think I need to bring up right now.
Okay.
I believe that we are going to be asking for a limiting instruction.
Okay.
I don't know how the performance of music, the state is fighting us tooth and nail saying YSL is not music. So I don't know how that at the same time putting out music could be in furtherance of a conspiracy. So I would think that the lyrics can only be considered in regards to the person who is the source of the lyrics and not the other people sitting here.
Judge, I think that so one, we've never made the contention that YSL members do not rap. We have repeatedly asserted that there's that aspect of the game. So that's not true at all. And I believe that the issue of who it comes in against has already been litigated. I will make certain, looking at the order that Judge Glanville has entered, but there is no limitation as to this only comes in against Mr. Williams because he's the one that said it. It's not a testimonial statement. We would argue it's at the very least a co-conspirator statement, but and at times there are adoptive admissions, at times it's a party opponent, but there are various hearsay exceptions that allow these statements in. And Judge Glanville, we're looking at the order, but I believe Judge Glanville specifically ruled that they come in as co-conspirator statements. We'll look back at the order he wrote and entered after our very, very long hearing on this matter.
Okay, well, y'all let me know about that. And if y'all want a limiting instruction, you can certainly propose one and I will take it under consideration. And, you know, if it's a blanket, every bit of this is a co-conspirator statement, that's one thing. If some of them are one exception and some are another, I'll just have to look when I'm considering a potential limiting instruction.
And Judge, also, when we intend to enter certain statements made by certain of the defendants in that they have put a beat behind, we don't intend to play all of the words to all of these songs by any means. So we'll extract the words that we intend to introduce and make certain they're aware of those and tailor those to the order that has been entered in any order that rulings that the court makes.
Okay, thank you. All right, so our exhibits down through 79, also lyrics.
A lyric, 79 is a video.
Sorry, then 71 through 77 are all lyrics?
Yes.
Okay, so the ruling would be the same as to each of those. All right, so now we'll turn to 79, which I can't seem to open.
It's a picture, actually.
Okay.
I can share it. Well.
Okay, thank you.
Want me to share it, Charm?
Sure. Okay. Okay, it's already in.
But I don't think the caption.
I couldn't hear you. What'd you say?
We believe that's in already. We agree.
Okay. Mr. Steele, did you say something about Bruton?
That's what I'm reading, but no. I said the same thing as Miss Adams.
Okay.
I cannot be 100% sure, but I believe
y'all,
it's
all right. Well, if several of you over there think it is, and y'all think it might be,
the caption may not be.
Okay. Any issue with the caption?
Not 100% sure. I believe it's in, or at the very least, it's been testified to. But I guess when we find the original.
All right, y'all can let us know on that one then.
Judge, did we reserve on some of the 71 through 77 because we were going to check the order, Judge Glanville's order? I want to reserve on 74.
Okay. Yeah, we did. We're going to get the order and then come back to that.
All right. Thank you.
Thank you. Suddenly.
I've seen it. I just remember whether it's in or not.
Sorry, y'all. Somehow everything got closed, so I'm opening it back up. Okay, so then next would be Exhibit 82. Is that already in by chance?
I don't believe it's in. I believe we've discussed it in regards to another witness previously. I don't have any problem with it personally.
I believe we talked about this
I
picture
think we've
yesterday.
already dealt with this. All right. States Exhibit 83, what is it, Lima LL? Not that up on my native phonetic alphabet. I got it right. Lima. What is, I mean, I know what this is, but what does this have anything to do with?
Your Honor, that is I believe that is the gun, yes. That is the gun that was found at the Dunbar Center with Mr. Copeland.
All right, any issue on this?
Not if there's an appropriate testimony to it. So no, I don't anticipate any issue.
Okay. So I imagine, obviously, they'll have to establish that's what it was, but assuming that is established, that can come in. Bless you. Okay, and then 84 Lima A. Any objection?
If this is this the black and white picture, Your Honor?
No, this is a video of a club.
So this is, Your Honor, September 30th, so the night preceding the October 1st overact with Mr. Kendrick and Mr. Arnold, where Mr. Arnold gets into a fight at Magic City. This is a video of that. And that's also 84, it's 84 LL A and 84 LL.
Okay. Any issues? Evidentiary issues?
Not assuming they can lay the appropriate foundation.
Okay. So LL is just a different view. Okay. So, and then there's another 84 LL.
LL and then 84 LLA.
And then another 84 LL. Maybe that's a still? I don't know.
Let me see.
Oh, no, that's a gun. Maybe
So, okay.
there's a mislabel.
There's a mislabel, Your Honor.
Okay.
Okay, so whatever that gun is will need to be
A different label.
a different number, but I assume that's some gun that's some way tied to something.
Yes, that's the gun, Your Honor, that was found on Quindarius Zachary when he was at the gas station.
All right.
That's it.
Okay.
Quindarius Zachary.
Then we've got 85 through 90 LL. Any objection to any of those?
One of them we've already. So 85 LL is the interview of Mr. Kendrick.
Okay.
Yeah, and we've already dealt with
All right.
the PowerPoint, which is 86.
All right.
87 as well.
We've dealt with 87 already?
Yes. 'Cause
Okay.
that's
Oh, yeah, that's okay.
we have not dealt with 88.
88. Any objection to 88? Evidentiary objection?
I'm sure we'll be objecting to the commentary on this posting.
Well, except for the ones by Mr. Stillwell, I suppose, because so yeah, okay. We wouldn't have any problem taking out anything that Mr. Stillwell doesn't post.
Okay, yeah, I mean, that's going to be done for all of these kind of Instagram-y type posts anyway, right?
Yes.
Okay. All right. Yeah.
If the state would educate me on the relevance of Mr. Stillwell's posting there.
Okay.
What they think it means, because I mean,
all right,
I'm not gleaning too much from it.
Okay, there's a relevance objection.
All right. So, Judge, we are alleging that Mr. Stillwell is a member of and a participant in a criminal street gang and a criminal enterprise known as YSL. His donning of these red bandanas, one on his right hand and one over his head, and his use of welcome to be that red bee with the red heart, Day Paradise, on March 28, 2015, during the year or the relevant time of this back and forth that was going on, are all relevant to the allegations made in the indictment. So with relevance being
Your Honor, I
the bar that it is.
misspoke.
Hang on, don't interrupt.
I'm withdrawing.
Okay.
I misspoke.
These mushrooms make you feel better. They increase focus and energy while keeping you calm and stress-free. Plus, they cut down on bloat and heal your gut. Wait, and they taste good? Someone should make a coffee out of this stuff. Right.
Thank you. And I think that's 100%. Anyway, not a heart. Had to get my glasses out for that one, but I think the argument would be the same. Okay, so that objection's withdrawn. Long as, yeah, you just need with all of these to take off the comments. Same with 89.
Yes.
Any issue otherwise to 89 LL or 90 LL? Well, 90 LL is not a photo, it's a video. Any objection to either of those?
Your Honor, as long as they keep my client's comment on that exhibit as well, where he sarcastically says we beefing, mocking the idea that there's gang rivalries.
Are we talking about 90 LL?
We're talking about 89 LL, right?
Okay.
I don't actually see that.
He doesn't say his client says dripping through Cali with some real ends at Gotti with that red B. His client is not listed under the 6 comments that are going to be taken out.
Is there like some comment later that isn't shown, maybe? Because I don't see it on this.
You're right. I think he's talking about, correct me, the first comment says at SB with the we beefing, but I don't think that that's Mr. Stillwell. That's the other person posting that she's beefing with him.
What's going on is these comments are in dark blue on the black background, so I'm only seeing the white. So I'm seeing my client commenting "we beefing," which obviously would be sarcastic. He's sitting next to his friend, but now I see the blue that Okoye having her way posted that. So
Yeah. Okay. All right. How about 90 LL?
We'd be objecting to 90. I don't know what the relevance is of
Okay.
90.
All right. There's a relevance objection to 90 LL.
And 403.
And 403.
Judge, I think it's best if we just play this
Okay.
one.
Big B, Lil B, Slime, YSL, Crip Killer.
That's Mr. Williams's voice.
Based on
Directing
Let's not interrupt each other, please.
directing this child to throw up these gang signs.
Okay.
So that's what we.
So are you going to have some kind of either somebody familiar with Mr. Williams' voice to say that's him, or a voice analyst to say that's him?
We would have someone that we believe is familiar enough with his voice to say that that's him.
Okay, well, we'll see.
on behalf of Mr. Stillwell, we're going to ask for a limiting instruction, if that's admitted.
All right, provide proposed one, please.
On behalf of Mr. Williams, Your Honor, what is the import of this? So I understand it's prejudicial because a person may think that a young child using what I would consider gang language with their hand signs may be inappropriate. But why would this matter here? The lyrics are coming in. Mr. Williams is constantly changing the letter B to or letter C to a B. Like instead of Cleveland Avenue, Believeland Avenue, there's a whole bunch of lyrics that Judge Glanville let in. There are tattoos on Mr. Williams' body that has already come in that shows the letter B and alleged other supposed gang symbols. They have introduced, they being the court has admitted into evidence, exhibits showing things like a green snake or an emoji with a B on it. I just don't understand why the child is an important part of this mission to find the truth here. And Mr. Williams' voice, I find it to be wholly prejudicial, and I find the probative value to be scant.
All right, let's hear from the state.
So, Your Honor, as the court is aware, the rules of evidence are rules that favor admissibility, and 403 should only be used in extreme situations, and Mr. Williams, not the state, bears the burden of showing when something is shown to be relevant, it's presumptively admissible, and he bears the burden of showing that its prejudicial effect substantially outweighs its probative value. And Mr. Williams has said nothing about the prejudicial effect of this video with his child, with Mr. Williams dictating to this child throw up B, YSL, Crip Killer, which are all things that Mr. Williams has attempted to distance himself from throughout the entirety of this trial. He has asserted that all of this is, not real. All of this is, just a facade. And the more that the state is able to show to the jury that this is, in fact, not a facade or not someone pinning on Mr. Williams' designations that are not accurately pinned on him, then the stronger the state's case becomes. So our argument is that Mr. Williams has in no way shown that this video is substantially more prejudicial than probative.
All right.
Your Honor, with respect to Mr. Huey, we would also chime in on the 105 instruction, but notwithstanding that, Your Honor, can you hear me, Judge?
I can hear you. I don't think that's working, but I can hear you anyway.
Can you hear me now, Judge?
Yes.
So we would also ask for the 105 instruction on behalf of Mr. Huey, but notwithstanding that, Your Honor, this is extremely prejudicial from the standpoint of having a child hold up these gang signs and so forth and so on, what appears to be gang signs. And again, this is going to be one of those scant and cumulative aspects of a piece of evidence that if the court allows it to come in, it's going to be drug in for the sake of its prejudicial effect. Clearly what 403 says we can't do. So I would ask the court to take that into consideration.
Okay, well, I'm certainly considering the appropriate law. Yes, sir, Mr. Steele.
There's also another, I can't find the exhibit number, but there's a video that came in over objection that Mr. Williams is doing something similar, or someone's doing something similar with a child.
All right, why don't y'all get me that, and I'll consider whether there might be a cumulative issue here. But with regard to just 401, 403, it's certainly relevant, and I agree that it's prejudicial, which, case after case says most of the state's evidence is prejudicial against defendants. I don't think it's substantially more prejudicial than probative, considering part of the conspiracy they allege is preserving, protecting, and enhancing the reputation, power, and territory of the enterprise by the posting of messages, images, videos, and songs demonstrating alignment to the enterprise and a willingness to engage in violence on its behalf. I mean, it's wildly probative to that.
And Your Honor, we're also going to ask for a Rule 105 instruction on behalf of Mr. Kendrick. And we echo the comments made by the others.
Okay. Yes, ma'am.
We don't believe that a 105 instruction on this type of evidence is appropriate. It's not a testimonial piece of evidence, a testimonial statement. So we would ask that a 105 instruction not be given in instances where this is the evidence being presented. And we would also submit that Jeffrey Williams is alleged to be the leader of this gang, and in having or directing this child and other children to do things like he's doing, he is, in effect, he's starting early and starting young. That is part of the state's theory in this case, that this gang recruits young children, and this is what it ends up being.
Judge, I think there's a piece of evidence that came in on, or we reviewed a child on yesterday, if I'm not mistaken, that we saw in an image. It was either posted.
Yeah, but I don't remember that being anything that the child was doing in response to somebody directing them to do it. I think it seemed like the child was, I'd be happy to look at it again, because that's not specifically what I was looking at it for then. But if that's what y'all are thinking about,
Well, that's one at least that immediately came to my memory.
And do you recall that child was doing that in response to somebody directing them?
I'm not sure if there was sound associated with that particular image, but it was certainly at the direction of an adult, and then the child was.
Was it Mr. Williams?
I believe it was.
Yes, Judge, it was. It was the one of the two videos that you saw on yesterday, and when you listen to the sound, it's exactly the same thing. The child is being directed, and in fact, it's the same child.
Okay.
He says Big B, Little B. He doesn't say Crip Killer. He doesn't say YSL.
All right, that is not cumulative if that's the only one that y'all had in mind. So that's, I'm overruling those objections. Okay. I think that takes care of that. Witnesses, exhibits, at least.
Bless. Appreciate everybody for still
Martinez
tapping in,
Arnold.
Tweets, Rumble.
I see there's
Appreciate
a
y'all, man.
plea agreement in that one also.
We
On same
almost
grounds
there.
as before. Is there anything in
almost there.
particular on that one? I know there was. This isn't the same one we talked about before, is it?
No. Mr. Sledge.
Okay.
It will be similar ground. You know, he's testifying, so why do we need a plea agreement? And the state wants to put it in, my understanding. And it would be continuing witness because it's a statement, and he could testify to whatever, and then he can get impeached.
All right. Well, continuing witness is only about whether something goes out to the jury or not.
Correct.
So that's not relevant to whether it actually comes in or not. And then it's the state's intention to use this only if you need to impeach him as to something? Correct. Okay.
Correct, Your Honor. And if he's truthful, then we don't need to accept, I mean, if he's truthful, then we don't need to go and show and introduce this as an exhibit. And I'm assuming they're talking about the factual acknowledgments, not the conviction itself.
I don't know. Let's find out. Are you talking about the factual acknowledgments?
I am talking about the factual acknowledgement, and then there would have to be a proper purpose for the guilty plea, which there could be one, but I didn't hear it yet.
All right. Is there anything about the factual acknowledgments here? Like, I know that last one y'all were saying, I don't think this person has any firsthand knowledge. Is there anything like that I need to look at in particular? Okay. All right. And so for these people, you just intend to have them admit they pled guilty? Okay. So this wouldn't be relevant at all unless they say, no, I didn't, or no, I never asserted that fact, or this would be.
So or that he was forced, or he didn't know what he was doing.
Right.
I think the certified conviction might actually be proper evidence. I need to think about that, but as far as the other stuff that they're talking about,
yeah, and you can certainly, I guess, tender that if you want to.
All right.
Yeah, but the other information is only, as we said earlier, if someone isn't truthful on the stand.
Right. Okay. Thank you. All right. The next item in there, I can't open, so I don't know what that is, but if y'all can open it and you know what it is and don't have an objection, then it doesn't matter that I can't open it.
Your Honor, we're talking about the third one down?
I was talking about the second one down because I don't know what that is. The one labeled like NT Fulton CODA and then some numbers. Oh, okay. Don't know why I can't open it, but we've already reviewed that one. Or no?
So this is a transcript of an interview with Mr. Arnold, and there is no need to enter this or use it unless we need to impeach him.
Okay. And I assume it's a certified copy that y'all would use if need be. I mean, I guess it wouldn't have to be, but
it's not certified.
Okay.
You mean of the transcript?
Yeah.
It's not certified. It's just
It's a hallway conversation.
Say that again.
It's a hallway conversation. It's
hallway
not,
conversation.
It's not in court.
It's a 130-page transcript of a conversation.
Oh,
interview.
It's not a transcript of the guilty plea.
Right, no,
okay.
It's an interview. Thank you. It's an interview. That's what I was saying.
Okay.
It's an interview.
It's a transcript of an interview, which you don't assume you'll be using unless you have to refresh his recollection or impeach him?
Right,
Okay.
that's what I was saying.
All right, no problem. How about this next thing labeled recording?
And let me just say, I don't know what Mr. Arnold's going to testify to or not testify to. To the extent that the state is ever planning on just playing I understand targeted impeachment, but and if I've fallen short of expectations, I apologize, but I have not reviewed this transcript for any extraneous, irrelevant, prejudicial.
And and thank you. Y'all don't intend to wholesale use that. If you did, that would be a problem. Needs to be targeted. So yeah, just regular old trial evidence. Okay, thank you. All right, and this next thing, which is maybe some sort of a musical recording.
Itself.
Ah, okay. I opened it up and it shows a musical note. I guess that's just my media player. Okay. And then this last thing is a picture. Any issues on this one? No? Okay, moving on to Officer Munson then. Looks like there's another set of crime scene pictures, maybe. And a crime scene report. Couple of crime scene reports. Any issues on those?
Don't anticipate any issues with the crime scene photos.
Okay, thank you. All right, moving on to Jennings Kilgore. We are almost to the bottom of this grouping of 30. This seems to be a ballistics expert.
NIBIN expert.
A what expert?
NIBIN, National Institute of Ballistics Integration.
He is a ballistics expert with a particular.
NIBIN is different.
It's a big time one, right?
It's the one right before. It's not the actual firearms examiner, so it's a step before. It's a comparison to see if if these have the same characteristics.
All right. Anyway, anybody have an issue with the evidence that's going to come in with this person?
I'm sorry. What is this?
She hit her with a respectful.
This is under. I'm trying to find out specifically where this. It's under the NIBIN reports. I don't know if I'm pronouncing that right. NIBIN charts. There's a document labeled Operation Planters NIBIN chart.
Okay, I can't open that one either, but
yes, and that's a summary of NIBIN matches that were.
I'm having trouble seeing it in detail, but
yeah, maybe because the black on the blue is a little hard to read. And we're all old and have old eyes. So is the question just kind of like, what does that say?
What is that?
Okay.
So those are the chart with the black on the blue. That one is showing that there were 5 shell casings from a particular seen, the black on the blue is the address.
Okay.
The red lines are matches to other addresses where shell casings consistent with the firearms at the previous address were found.
Okay.
And there was, I think that we served in discovery, but I don't think we included in this list of exhibits. There is also an ATF NIBIN examiner that we didn't have in here that they also examined some of these shell casings from different sites. Both Kilgore at the Atlanta Police Department and ATF were all working in conjunction with one another. So
Okay.
there is one more person that we'll be adding to that, but we'll let them know well before we.
All right. Well, if they're going to say the same thing, we don't need them both.
We won't. We won't have.
All right. So with regard to this kind of chart, I guess, now that you know what it is there an objection?
I have one. Okay. Well, here's the problem, Your Honor. And before you were involved in this case, a lot of these prior incidents were Detective Dennis took the stand, and the state brought out an easel, and they wrote down all these different case numbers, and they went through them real quick.
Okay.
On January 26th, 2015, there was a shooting at 841 Smith Street. I'm just making that
Yeah.
up. Okay? And in this, and as a gang investigator, I determined that was part of this beef. Okay, we for a lot of these incidents, we have not heard from any witnesses that collected shell casings. There's been no chain of evidence. There's been no testimony about the collection of evidence.
Okay.
So this is just like coming in without any basis or any foundation, and it would all be hearsay.
All right. Is
And
he
violate the Confrontation Clause as
okay?
well.
Is he going to be testifying that he received the shell casings from each of these and did the exams, or that other person from ATF that you mentioned, or how is this going to get used?
When shell casings are collected, the first person that does that comparison is either Kilgore at APD, or they're taken down to ATF to do that comparison. What Kilgore or the ATF NIBIN person.
Search less, solve more. Buy online, operate anywhere.
I don't like today commercials coming so fast, bro.
Be able to testify that for each of those
So
blue
fast.
boxes, he did an examination or comparison, and that's what he came up with?
Yes, for everyone that we have a match for, either Kilgore or ATF, Kilgore or ATF did that initial NIBIN comparison. I'm not sure what the objection is. If we're not going to have him talking about something somebody else did. If that's
Okay, so I think one of the objections is that thus far we have not heard shell casings were collected from this firearm scene and provided to Kilgore, and then Kilgore obviously would say, yeah, I got them and I did this evaluation. Is that all of that foundation is going to have been laid in evidence by the time he gets here to testify to this?
Yes, that's why we have the crime scene technicians coming up talking about what they collected.
All right. So it sounds like by the time we get to this, that will have been done.
Be a two-way connection, though. It can't just be we collected. I'm using an example. We collected. Certainly, we've had the crime scene, or we will have had the crime scene technician, I believe, from the January 10th incident.
Mm-hmm.
So we'll know what was collected, and it was sent to Kilgore, and it was sent to NIBIN, and we get that. But if they're going to say, well, it matches another crime scene, the expert in the lab can't say that unless we know. They can say, I guess, presumably it matched another bullet in the database or something like that, but unless there's a link to an individual crime scene, yes, we collected this and it matches up, that's still based on hearsay. Kilgore or whoever the expert in the lab would be testifying based on hearsay about where that other ballistic evidence was collected from, unless we hear from the person who collected the evidence.
And we would. So I don't know why. I don't know why we're arguing at this
We're
level.
we're not arguing. We're trying to clarify. So, for instance, and I can't
She
see
just don't
them,
want nobody to question
but
whatever she got.
the very top two on there, you know, they apparently say, okay, this crime scene A and crime scene B. We will have, and this person, Kilgore, will be able to say, I did a comparison of bullets from crime scene A and bullets from crime scene B, and they're consistent with having been shot from the same gun or something similar. The question on the floor is, okay, will we have already heard not only the chain of custody for Kilgore getting the crime scene A bullets, but the chain of custody for Kilgore getting the crime scene B bullets?
Yes. So we would not have. Yes, all of the foundation. I don't think chain of custody, like, you know, specific, like every link in the chain would be necessary, considering we would have the crime scene technician who would have collected it. We would have the testimony that when the crime scene technician has collected it, it comes to my department, my being Kilgore. This is the case number 150261534. And I compared it to case number X.
Okay, so we will have both, just so I make sure I'm understanding you. We will have a crime scene tech from crime scene B say, I collected all of this and I gave it to the crime lab. Or whom, I don't know if this is
I put it in evidence.
I put it in the, you know, box or whatever they do. And then we'll have Kilgore say, here's the way evidence gets to me, and this got to me that way.
Yes.
Okay. Does
Yes.
that answer your question? I mean, I guess it's yet to be determined whether we will hear all of that evidence, but the objection is going to be, if we don't hear all of that evidence, he can't testify to this. So do you understand that?
Sorry, Judge. The objection is that
if we don't hear the foundation that is both crime scene A tech giving the evidence to Kilgore and crime scene B tech collecting and giving the evidence to Kilgore, and then Kilgore saying, I got them both in the regular course and I compared them, here's my conclusion, that there's going to be an objection that he can't testify about crime scene B.
And to make certain, looking at the witnesses that we had initially put up, what we can do is add the 10 witnesses from each of those crime scenes that are on this list to make certain that we have each of those links included as
Sounds
evidence.
like that's going to have to happen. Now, it does not need to be, I don't think, a whole as if this were the crime on trial.
It would just be,
it can just be,
hi,
I'm a crime
witness
scene
number
tech.
1 through 10 that I'm adding on. I collected this
I went
one.
to this crime scene at this date. I collected
Right.
this evidence. I gave it to whomever.
Right.
Which should take 10
minutes.
Okay. All right. She plans to now do all of that.
No.
Unless y'all want to stipulate that those bullets got to the crime lab in the normal course from whatever crime scene, which I don't see happening. So, okay. All right. So anything else with regard to Kilgore's, the evidence that would come in through Kilgore? All right. Then our witness number 30 on this list is Underwood. Is Underwood also a NIBIN expert?
She's one of our and detectives and gang experts in this case.
Okay.
And she actually may have been the one. She was an ATF task force agent, and she also would have been instrumental in taking some of the evidence over to the task force versus APD's ballistics lab where Kilgore worked.
Okay.
To have it tested over there.
Okay. Any issues with her evidence?
Yes, because it's going to be repetitive. She is an APD officer, and she's going to be supposedly or potentially the same treadmill of information about YSL and IFGang, and this is what the policy is of the City of Atlanta Police, why we qualify people in a gang, and we've heard it from Detective Belknap, Detective Gaither, Detective Dennis. They have 5 gang experts allegedly from the same exact, they work together.
Is this a gang expert?
That's what I said.
She may be a gang expert, but is she going to testify as a gang expert?
I don't anticipate getting into anything overlapping. And actually, we were, before this last conversation, thinking of not calling her at all.
But, okay, so she would be chain of custody only?
Some chain of custody. And at this point, I don't anticipate calling her as another expert. But as far as the gang experts are concerned, Your Honor, I just point out that what we've done is announce to the court and to each of the defendants that our gang experts would not be talking about overlapping pieces of information. Every expert was talking about a different point in time as to their knowledge. Detective Underwood had an earlier knowledge of this particular street gang than did Detective Dennis. Detective Belknap testified to a different slice of time. Detective Dennis and Gaither were 2 people who worked as partners during the same period of time. But when we are alleging that this is a street gang that has existed from 2012 up until 2022, you know, during the time of this indictment and even afterwards, and we have every step of the way had cross-examination questions and the rebuttal assertion that this is not a gang, this is just a music label, and none of what you see really amounts to what the state is saying. To have gang experts who have an expertise in particular cuts of time that the gang existed is not cumulative. And the very fact that some of what they say overlaps doesn't in any way make what they're testifying about so cumulative.
I understand. All right, so has this person already testified as a gang expert?
She's not. She's just been qualified as one.
Okay, so you do not anticipate having her testify in her gang expertise role just as custodian of whatever this evidence and getting it from one place to another then, is that right?
At this point, like we said, at first we were, and then we were like.
All right, and I would think that if for whatever reason you decide that's something you think you need to do, let's address that, because I don't think we need to hear, and I hear you saying we haven't heard the same thing, but we don't certainly moving forward need to hear the same thing. So, okay, that's clear. Thank you.
Your Honor, as the state is announcing that she's just going to be, Investigator Underwood is just going to be a kind of custodian of or transferring evidence from one place to another, I assume that the operation planner's NIBIN chart and the operation planner's NIBIN lead's new chart will not be introduced through her?
Well, none of it's the same or substantially similar to what will be introduced through Kilgore.
I agree. I just noticed that in the folder.
Yeah, I mean, they do. I don't know why, but I can't open a lot of these on this computer. But is that the same thing, or is that something different?
It's a colorful picture showing like a flow chart involving the information that Kilgore has.
Generally the same?
It's all the same information. It's just presented.
It's more colorful?
Yes.
I mean, pick one or the other. Okay. All right. Is it easier to read than the other one?
It is.
Okay, well, you can always switch the witnesses that you were going to use that for. But yeah, we don't want to see it twice. But okay. All right, that gets us through our first 30 bucket.
We haven't done Mr. Sprinkle.
Well, yes, other than Mr. Sprinkle that everybody wanted to come back to. All right. Trying to just look back through at things we need to revisit or visit for the first time. Okay, so I think this is a good place for us to stop today. And then, tomorrow, other than the potential hearsay and CAD reports, which we can take up,
Hello?
we can either
Yeah, I was
move
trying
to
to
the
call
next
Eric.
30
I know
and
it
do
was
the
kind of
same thing
standard
with
with the
regard to them
99
because they're
stuff.
going to have to be done at some point when the jury is out.
I was trying to call Eric and made a
or-
mistake and called your phone with the 99.
Y'all don't seem to want to reach
or
the
998 or
wiretap
something.
stuff yet, but as quickly as y'all can
How you doing, though?
specifically
What you doing?
identify that and get it to the defense, then we can
said,
get
how you
to
doing,
that.
though?
I think
What
it'll
are you
be
doing?
easier once they actually have targeted information about that. Yes, sir.
Really?
Know why necessarily, but the state specifically identified jail calls for my client
No,
as they've stated, which is
Try to
I
call
believe,
Erica
13 or
because
14.
our other kids
I've
was looking for
reviewed
Erica.
those.
We're right.
and
Okay, so
looked through the
tomorrow
text
we can
messages.
tackle
Erica's
those.
number's not saved in my
And-
phone. It just shows
I'm
99
just
something.
warning everyone.
Just like your number just
other
shows
people,
99 something.
Not in a,
I can already see what
I'll
type
just
of
say
time
it
you
affects-
are.
Alerting everyone.
Apologies for making a
I'm
mistake
alerting
calling
everyone
you.
that it affects more than just my client.
Okay, so
Yeah.
everyone might want to take a close look at those
Yeah.
before tomorrow.
Wow.
Okay, anything anybody needs to put on the record, make suggestions about for how to be efficient
Damn.
tomorrow, anything like that?
Your Honor, it states exhibit number 55W, which would target the child with the hand signals.
Okay.
If you can, it's 55W has been shown to the jury.
Would it be easy for somebody to pull it up on screen for me? And is this just a still photo or is this a video?
A short video.
Okay,
It was played for the jury.
all right.
Oh, I need 10 ones. That's crazy. I'm not sure what I'm supposed to do.
Is Mr. Kokomo going to play that for us or is he, I don't see him anymore. I think the state's going to try to find it.
I don't remember yesterday's. I just don't remember that. But it's one that was played months ago from the jury. Yeah. You come outside the house.
Okay.
I have another matter while the state is
All right.
helping us. Can I just tell you a case?
Mm-hmm.
Okay. So I believe that my concern about when it's dealing with the Rico conspiracy in Bruton, and then the person in custody is giving a statement, confrontation clause statement, talking about the enterprise, let's say.
Okay.
I have found that my argument has been rejected. And this is the 11th Circuit, United States versus Espinosa, ESPINOZA. It's 635 Fed, FED period, APPX 739. It's in Division B, as in Barry. And it's 11th Circuit, 2015. And the 11th Circuit found that We reject the defendant's argument that because the confessional statements may be proof that a RICO enterprise existed, which is a necessary element of the RICO conspiracy charge against both defendants, the statements trigger a confrontation right under Bruton. If the defendants were correct, then any incriminating statement made by one non-testifying co-conspirator would be inadmissible against the other, whether or not the statement facially incriminated the other co-defendant. Bruton's narrow exception to the general rule of admissibility does not extend this far. That's what I found.
All right.
So it's only triggers what we were saying earlier, Mr. Stillwell, Mr. Williams, but I was saying YSL or the crew, and I cannot find a case that supports that.
All right. I appreciate you bringing that to the court's attention. Every attorney has a duty to be candid with the court, even if the case law does not favor the argument they wish to make. And so I appreciate that, because I have to say, unfortunately, everybody doesn't do that. So thank you for doing that. Okay. Do we have this ready to play? Oh, okay.
Young successful lifestyle.
Oh yeah. Well, I just fucked when he said young successful lifestyle.
Man, but mud, we do this every day. I ain't talking about put you on the camera. Go on the trench, man. Yeah. Want to give a special shout out to my niggas. Big B. I know this shit. Little baby rolling.
Yeah, that's actually the one I was thinking about. I mean, that child starts doing all that stuff unprompted and then maybe gets encouraged to do a little bit more, but I don't think that that shows the same thing as the other piece of evidence that we were talking about. So thanks, but my ruling stands on that.
Can we have a continuing objection if I need?
You may. All right, I'll see everybody at 9 in the morning.
Judge,
yes.
One thing we did reserve, if you recall, waiting for the order from Judge Glanville on witness number 26, that's Dennis, particularly number 74. We can deal with that tomorrow easily, though.
Great. Dennis, number 74. Mr. Harvey, was that one of the lyrics issues, or was that a different item?
Well, it's lyrics, but it's a video.
Okay.
Thank you.
Thank you.
What? Stop with the winding them up for it. What is the problem? What?
I want at the store.
You want in the store?
No, in the store.
It's not your toy. It's not yours. Stop crying over something that's not yours. Got it? Got it? Yes or no? Stop whining. What are you? You sure? You want something to do?
You know what box is?
Is that what? A box? Cool.
Take it down.
Big long box. Should be two of them over there. This folder's somewhere around. Yeah, no. You don't draw it down. Put your paper on top of here, draw on top of it. Do your thing. Stay serious. Stop whining. There's no whining. This shit's gonna take 0 watts. What? Oh. Okay. What do you need over there? There ain't no pencils, it's only pens. My dude's just a creeper. He's a creeper. He gets me, dog. Yeah, since there. Uh, Okay. I ain't got no pencil. Ask Erica if she's at a cooking. Just right. Just right. They take the metal barrel package food. Took the basic risk. Please don't start with a response. That's how you can find the thing. That's how you can find the thing. Go ask your grandfather for a pencil. He got some downstairs. What, Sensei?
I asked my grandma. She said no.
Same.
She said no.
Why do you want costumes? Why do you want costumes? I mean, you tired? Sure? Cause you act like you tired. That's what you act like. You know you're trying to take care of them. Your mom lets you come over here to prepare them and all your boy. Come on, some toast for me. Sincere. Wife's your sister is the sharpness. Yeah. Sin, stop yelling.
Did you know I got 30? No. What?
$84. Stacking and macking, baby. Stacking and macking, baby. No. Folders.
Wait, Daddy, those are folders?
Yes.
What? I'm gonna pick a movie.
No.
Down, 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 down. Yeah. Down. Down. I'm pressing down.
Go downstairs. Watch a movie downstairs.
Why? Daddy. Because we already put game time on.
What?
It can be games on TV.
I know it's games on TV.
What games on TV? Now let's play these games. Not telling you. I remember putting it on TV. Yeah, Kylie, you put it on TV. You girl. You put on the baby. All the baby. I don't know why you do it. I don't know. So you want to do it. Down, down. Oh,
Well, so I'm here with the kids. What's going on? Said I'm here with the kids. What's going on?
yeah. I will fly to play. That's the last place.
No, but I call her early in the morning. I've been on the phone with my lawyers and shit today. I said I'll call her early in the morning. I had to go sit down with my lawyers and shit today.
It's a movie on Bam. Thankful. Titan. Why did he say Titan?
Man, when I did the application, I put all that in. That actually got on the application.
Yeah.
It all depends on if they got openings though. That'd be a thing. It all depends on if they got openings. All depends on if they got openings, Kai. Openings.
No, take the password off. We're not taking it off.
Yeah, I heard you there. Okie dokie.
She forgot my name.
No, Kai, but you're gonna need the air conditioner next year, so
That was not an S.
It'll be alright. It'll be alright. Clean it off, use it next year. Yep, clean it off, use it next year.
I was literally playing this. I don't know why
Kai, I already answered this question. The day that you asked me is when I took it out the window. When I told you I would put it in the show. This was the whole conversation. That was already. Yeah, I told you about another AZ because it doesn't really do anything here, guys. So I don't know what to tell you, guys. I'm telling you, there is no one to use it, Kai. There's no one to use it. I'm not bringing it back here. So why would I bring it here and then bring it back to your house next year?
How did Kylie do that? Kylie, since you're doing that, she was.
I don't know what to tell you, guys. I truly don't know what to tell you. I don't know what to tell you guys, what I just said. That's up to you, Kyle. You're gonna need another AC next year. What difference does it make in me that you go outside? Like, go for it. Whatever you want to do, Kyle. Whatever makes you happy. Yeah. Time. I'll see what I can do, Kyle. Okie dokie. Okie dokie then. Okie dokie, Kai. That's what I said. Okie dokie. Kai, why are you calling me all this right now? I'm just trying to figure out why are you calling me with it right now? I just told you I will figure it out to get it. I just said, listen to what I'm saying. Listen to what I'm saying before you answer, because you're answering before I finish the question. I just answered all this. You just said you needed this money. I said, okay, I will figure it out and see what I can do, correct? Because I'm not going to work at this moment. I can only get money when I don't have the kids. So I will have to figure it out on a week when I don't have the kids. But yeah, you're going to call and ask me this shit right now for what? That's what I'm trying to figure out. Then your next question was what? You said when you going to have it. Like you running down for what? I just gave you an answer beforehand. And then afterwards, you ask the question right afterwards. After getting the answer to the question. Dancing party all night. Heard you the first 3 times, guy. I just feel like you just need to say it again and again to make yourself feel better. That's all I was saying. Then you're just gonna say the same thing that you just said again, over again. I heard you the first time. That's what I'm saying. Yeah. You should hang up the phone before you start talking. So y'all dancing in here all night, what y'all saying? That's what you're saying? You just dance, revolution, dance, revolution. Did your sister ever come out of the bathroom from stinking up the building?
Yeah.
Because she was stinking up the building when y'all was looking for her. They gave me a Jeep. See my new truck? It's going down. It's going down. Put it on, think this would drive better on the bike. This actually drive worse. Who spelled their name?
Huh?
Who spelled their name?
Hey.
Hmm?
Hey.
Oh, found it.
I am gonna reflect this game after this hello sun. Callie, this how we move in. Callie, this how we move in. Looks like it's super down. No, what was that?
Oh, board ball. You're just out here riding around, Kylie, just chilling. I think it's not right, Kylie. Something's not right. I think we gotta go kill the big guy. We're gonna kill the big guy. You down? Let's just do it.
Element. I think it's going to learn how it sounds. And then let me go again. Are you ready?
Back up.
Say back up.
What?
Did you say back up?
Yes. Yeah.
Finally are done.
So what are you doing?
Okay, so
Sending out invites.
wanted to sing a song because she got a guitar. We got a guitar. And she got jumpers.
You got a what?
She got drums.
We got drums. I think we'll be drumming around the mountain when she comes out.
Oh, those. Oh, those. Gonna be it up.
Yeah.
So. No robot. Now I'm going to put this on Solange's foot and I'm going to give it to her. Now, I'll let you got it, Kylie.
So you know.
You want to get this? Come on. But on her foot, that's not hearing enough. That's karate. And so no.
So when was your plan to do this miraculous thing?
So we said that we were gonna do it.
You said what?
So we're going to do it on Wednesday.
What's today?
Tuesday?
Friday.
No.
Yesterday was Monday.
I know. So it's Tuesday.
So technically, it's Wednesday in the future.
Yeah. Oh, that's true. It is. But basically, it's just not. Whatever, no. Why you taking me that? It looks like a train.
Really?
Okay. So now I just need a. Work for me. Me too.
They keep putting me back zero. This is not an over-workout. You know how it is when you come in late for work. Mystical Crate is the next riff. Whoa. I'm gonna come and shoot shot for it. Not bad. Not a thing? I be having the bros out here talking like blood this and blood that. We ain't even blood. Oh no, one round though. Respectfully. You got no back door? Screen turn. But it told me that. It had adrenaline settings for the game. Look up, I probably just like saving bullets, but I ain't even get it. Well, I got the big ones. Okay. Respectfully. Actually, Mhm. I use about those are legal. That nigga said, yo, you know how I know that niggas wasn't for you? Because when you lead a dinner, they give you a sucker. He said, why is everybody asleep? Because most of these niggas is following their dreams. You don't get the whole food? Oh, man. What is this? Oh man. Oh. For sure. We figuring it out, chat. We figuring it out. Damn. Big one. You learn how to use that chat. Respectful. Face fight. Truly. Look at my boy. Let's go. That's everything, right? Yeah, there's some of it. Damn. Dang, he was spit that damage, wasn't he? And it's 7 young to die. Appreciate you. I don't know if I should do this again. Let's hear the Chrono Cage and solo. Okay. Respectful. Shout out to Spicy or whatever. My Spicy sounded out me earlier.
Still making this sauce.
What?
They're making them eggs.
What's wrong with you? Why are you screaming? It's okay. Talk to me, Miss Suko.
Now that you took down another Transcendent, I have more memetics for you. And it looks like you've got something interesting in your cradle, too. A dream catcher? So this web spun itself a spider. One that could prey on people while they slept. It seems pretty scary. I know everyone in Iron River must be grateful you laid this thing to rest. I certainly am. You risked your life to save them. Meanwhile, I've just been hiding here. I feel so useless. Will I ever be strong enough to go back into the world?
You just gotta fuck with your boy, man. You just gotta fuck with your boy, man. You just gotta stay in tune with the loop and know what we doing, how we doing, what we doing. That's what we doing. You know what? You just needed to whisper to you in your ear one time, but you hear what's going on inside my noggin, what's thriving. You hear me? Let me see what's going on with the pain. You already know how to do my thing.
Thank you, Netta. It's good to know I can count on you when the time comes.
That's
You
Shorty
once told
that
me
blew up the
mayflies
plane.
are small, yet invincible.
It's either her
I need to remember that.
or the Shorty that
We
we
need to keep
working
holding
with.
on, just
Mary.
like them.
Mary, where everything is scary and you know that the sun is so blurry. We didn't even get nothing, dog. I feel like running that shit back. See if I could do it by myself. Yeah, dream catcher. Wow. So now I gotta go back. Get one of those. Push those. I'm not gonna let me see. Yeah, what's that? Enjoy 9% yield, no money for gold, silver, stardust, or okay. Furnace, sinister, brick, and glass crafting time cut in half by 50% and twice the yield. Alright. Mastering the crafting of explosives done. It was bad. Extension. So the first 3 or 4 are really good. Oh, just give me a minute. I don't know if it is, but Oh yeah. Sniper Bay 1. Sniper Bay 1.
Who's there?
Just give me the light and pass the draw. I want to get the rift first. Thanks, that.
Yeah, we're like, you know.
Simon. They got it all together, don't they? Hug him and bug him. Nearest monolith dangerous one. Let's go. Let's go. Now don't run.